My lord, under compelling circumstances, may I mention a matter, my lord? Upon notice, I am mentioning this is appearing as item number 32 and 30.
Day of mentioning, so I will not upgrade matters. No use mentioning.
One
have your
very small innocuous, my lord,
Yes.
for our urgent inclusion, it is appearing as
Urgent inclusion.
my lord, it is not inclusion, my lord, it is appearing under the heading upgraded motion. I am praying for urgent, my lord. The very short matter relates to, my lord. I have done my tender work. I have been given completion certificate. Part payment has not been made by the KMD respondent.
Which item?
My lord, item 83 of today's list.
83 Friday. Under the heading payment of dues, serve notice upon the other side. Slip is not required.
may I have
83 of today's list.
83.
may I have your
Great.
lordship's kind leave to seek leave of your lordship to move an application, court application tomorrow, my lord. This is on the appellate side. The facts are these: 13-4 notice issued.
Listen, court applications 48 hours. It will appear in the list. You please file it
No,
in the department.
date of possession is tomorrow. I went to the DRT 1 month back. The DRT 3 presiding officer says I don't take up matters except 2 days ago. Takes it up, dismisses it. The order is uploaded 7 p.m. on Monday, and possession is tomorrow.
DRAT is also.
DRAT, there is no scope to obtain certified copy, file appeal, and move it before the 21st.
So this is
entire-
the only place where one can come.
And I have
Just
possession is
understand the-
taken. If possession is taken over, my lord, no 13-2 admitted by the bank. No 13-2. He has just not even looked into that fact. No 13-2, 13-4. DM's order under 14 not communicated to me. Police come and paste it. That's my knowledge. I immediately go in my pending.
So I understand all said and done after.
I know. I'm.
Statute is after the tribunal, go to the appellate forum.
But if the
Now-
appellate forum is left rendered nugatory by the, I'll go to the appellate forum. But so long it takes me to approach the appellate forum and get it listed there, on protect me.
And
DM's order,
which bank is it?
This is State
And
Bank.
DM's order must be in the appellate side.
I'm on the appellate side. I am asking
You
for
said
your lordship.
you'll file it as court application.
I'm sorry, but
Oh, you.
slip of my
The court application means it has a different meaning.
No, I'm sorry, my lord.
In the appellate side, you want to move it
Yes,
tomorrow.
tomorrow morning, my lord.
All right, give. But then ensure service and your other side should be there.
Yes, ma'am.
Lordship, may I be permitted to mention one matter, Lordship, for correction of
Oh,
an
oh,
order
oh,
dated
oh,
14 August.
Yes.
For a correction of an order dated 14th August.
Correction.
Yes.
What is the correction?
Lordship, in paragraph number 9, it is written sale cause of action.
Same. It should be same.
Yes, Lordship.
All right, give. Call the list, please.
Grateful.
My lord, I'm led by Mr. Mukherjee. This is that matter with the port, my lord. Lordship, on the last occasion, had instructed us to sit together and try to resolve the matters. My lord, we've written to the
Port
to our
authority.
respondent. My lord, this requires some more time, perhaps because of the vacations in the middle, the long weekend, not able to fully complete it, my lord. Maybe we given or kept on the 3rd. Mr. Mukherjee is also not here today.
I'll keep it on the 3rd of November.
My lord, it'll be very late then. Keep the 3rd of September, my lord, which should be resolved well.
Only
Good time.
the thing they are not interested perhaps to, otherwise, my lord, we have to impose penalty. That you'll,
My lord, my lord, if
that your
my
lordship
learned
will
friend,
record,
my lord, I have
November, I don't
written
mind,
to my learned friend to come and discuss. My lord, they have not responded also.
Yes.
It is not for him to come and discuss. It is for you
No, my
to
lord,
go.
I've asked for a
You
time.
and- you
I've asked for a
and-
time, my
You
lord.
and Mr. Bose, my lord, one
Give me money
My
and
lord,
go back.
I've-
I'm not going to the merit of the matter. If you don't follow lordship.
My lord, I've
Nobody
written
is
to,
going to merit.
My lord will also not.
my lord, I've sought a time. I've asked them.
Settle it out. Why will the court enter
My lord,
into all these
my lord,
things?
my lord, we,
tender matter, either you accept, you don't accept.
my lord, we have
you have
approached them.
accepted,
We
then
asked
you have
them
to comply with
what
the
time
terms.
is convenient. We will come and see you. That is what my email says, my lord. Kindly see.
I did not sit with me. You will pay me, I will leave.
He doesn't have anything to
He has to
say.
give a sanction plan. I'm just asking for a copy of the sanction plan.
My lord,
Written three
that
letters.
That was not the provision in the tender, as is very basis. He has
My
taken
lord,
the inspection.
my lord,
Now,
I have
after
not taken
participating in
inspection
the
of the
tender,
sanction.
now you are coming with a
My
new
lord,
term.
sanction plan is not handing over, my lord.
If you are not interested, do not proceed. Let them
My
proceed.
lord, I am
Somebody
ready with the
else.
money. Last time also Mr. Mukherjee said I'm willing to pay within a week and take the property.
Why don't you pay it first? Show your bona fide at
My
least.
lord, I'll take instructions, but my lord, my sanction plan
When
is not, they're not handing over.
filed,
That's all, my
when
lord.
the tender was
money, you will get the sanction plan.
Deposit the
First
money
sanction plan,
first.
let them hand over the sanction plan.
Acha. Learned advocate appearing for the petitioners seeks some more time to proceed with the talks of settlement. Step next. In view of such submission, release the matter on 10th of November. Not 10th. Make it on
10th of November, my lord.
no, not November. He's praying for September, 8th of September.
8th of 7th, then already.
Grateful, madam.
8th of September.
8th of 7th.
Grateful, grateful.
Item number 2.
Item 2.
I appear for the respondent bank.
You are for the
I appear
petition?
for the petitioner.
Yes.
I am with Mr. Dot. Well, the short point is, my lord, lordship at the occasion earlier, lordship had asked the bank to file a report, and we have taken an exception to that. My lord, the point in law is, my lord, whether
Is the report there on record? Where is the bank?
I appear for the respondent bank. No, I'm sorry, my lord. The
May I
report was
file
not
the
filed.
exception.
We've been received. My lord, may I just file the copy of the report? They've served a copy of the exception upon us.
Yes.
My lord, I'll indicate what was the point involved. My lord, the point in short was whether there can be a second 13-2 notice, my lord, under the SURFACE, my lord, after a period of 10 years.
10
10 years.
years.
Because, my lord, it's an admitted position that the first notice was issued on 24th February 2014. And, my lord, thereafter, they did not take any steps pursuant to that. And this notice of 2014 was issued. 2 notices were issued separately, one to the borrower, one to the guarantor. I appear for the guarantor, the writ petitioner was the guarantor. Then, my lord, after a period of 10 years, the impugned, my lord, notice with which we have come up with is, my lord, of 2025. My lord, page 73, which is 15th May 2025. Lordship will find the first notice at page 46 and the second notice at page 73.
Yes.
My lord, page 46, if my lord comes to, Lordship will find, my lord, addressee number 4 and 5. Mr. Saval Tibdewal and Sant Kumar Tibdewal, we are the 2 guarantors. So this is of 2014. And my lord, a
13.2.
prerequisite of that is, my lord, the account has been declared NPA and all that. So, my lord, this notice has been issued over here. My lord, kindly come to page 47,
Yes.
the paragraph at the top,
Hmm.
second line. Therefore, the bank hereby calls upon you as the guarantor exercising its right under section 13.2 read with 13.11 by issuing this notice to discharge in full the liabilities of the borrower as stated in Schedule D hereunder to the bank within 60 days from the date of receipt of this notice. Further, you are also liable to pay your future interest at so and so. So this is invocation of the guarantee pursuant to invocation of the section 13.2. Now, if my lord is pleased to come to my lord, page 73.
Yes.
Page 73, Lordship will find, my lord, this is 15th May 2025. Lordship sees the subject. At the top, my lord, in the box, my lord, Lordship will find, my lord, the same Sant Kumar Tibrewal and my lord Sawal Tibrewal. One is, my lord, in the middle column on the first row, and my lord, another is on the left on the second row. So these are the two persons in question, and my lord, the subject itself is revealing invocation of guarantee and demand notice in respect of unpaid debt in default from Basukinath Food Processors. That is the primary borrower. And my lord, kindly comes to paragraph 3. They suppress the earlier notice and then they say fail to do, and my lord, they claim a higher amount and they say this is that. So, my lord, the short point, and we are covered. Judgment of the. My lord, we are covered by this judgment of our court, my lord. I'll just give you a lord. The first judgment, my lord, is 2019-10 SCC 572, where, my lord, the lordship will be pleased to come to one Kejriwal ta kothay kothay.
1910 572.
My lord, over here, no, Gouda Bhargavind. My lord, have I handed to your lordship, my lord, Gouda Bhargavind by Dave?
Right.
My lord, kindly come to para 3. An independent proceeding was then begun by respondent number 1 on 3/10/2017, being in the form of a Section 7 application filed under the Insolvency and Bankruptcy Code in order to recover the original debt together with interest, which now amounted to 124 crore. In Form 1 that is statutory to be annexed in the Section 7 application in column 2, which was date on which default occur, the date of NPA, that is 21st July 2011, was filled up. The NCLT applied Article 62 of the Limitation Act, which reads as follows. Well, that is for the mortgage 12 years. Then Mr. Aditya Para 4. Mr. Aditya Parolia, learned counsel appearing on behalf of the appellant, has argued that Article 137 being a residuary article would apply on the facts of the case and has right to sue accrued only on 21st July 2011, 3 years having lapsed since then in 2014. Section 7 application filed in 2017 is clearly out of time. He has also referred to the judgment of BK Educational, so and so. Whether it's whether the residual article or 137, whether it applies, then Mr. Banerjee opposes that. Para 6. Having heard the counsel for both sides, what is apparent is Article 62 is out of the way on the ground. It would apply only to suits. Present case being an application which is filed under Section 7 would fall only within the residuary Article 137. As rightly pointed out by the learned counsel appearing on behalf of the appellant, time therefore begins to run on 21st July 2011, as a result of which the application filed under Section 7 would clearly be time barred. So far as Mr. Banerjee, that was rejected. Now, my lord,
Which was approved in 2019.
that prior to 2019, my lord, our High Court had already, my lord, on similar lines. I first showed your lordship the Supreme Court. Now, lordship will consider our High Court decision. Well, this is 2017 SCC Online, Calcutta.
8742.
8742. My lord will be pleased to come to. My lord, I rely on para 7, 8, and 9. The following issues have arisen for paragraph 7, my lord. Paragraph 7.
Yes.
The following issues have arisen for consideration in the instant proceedings. Whether the period of limitation stops on the filing of a proceeding under section 19 of a recovery of debts due to Bank and Financial Act for a bank or a financial institution to invoke provisions of Act of 2002 in respect of the same claims as in section 19 proceedings. 2002 is the subsequent act. To what reliefs, if any, are parties entitled to? The petitioner, as a medical professional, had started a medical diagnostic center and obtained loan from Canada Bank. Petitioner had claimed to repay such loan. Thereafter approached Punjab National Bank for credit facility. According to the petitioner, bank had sanctioned a credit facility. Subsequent to the sanction, the bank did not discharge its obligation. Rather, the bank had caused loss and damages due to the various unlawful activities. Petitioner had filed a civil suit. My lord, I need not trouble your lordship with that. Kindly come to the last line, which says civil suit was transferred to the debt recovery tribunal. So, a debt recovery, my lord, section 19 proceedings, lordship will make a note. It was there in 2000. Then, my lord, para 9. The parties had taken various steps against each other in several other proceedings. The bank had issued a notice under section 13(2) of the Act of 2002, that is the Surfacy Act, on 4th February 2011. The petitioner had moved the High Court quashing such notice. Such proceeding was dismissed on the ground petitioner had a statutory alternative efficacious remedy. On 13th April 2011, bank had invoked the provisions of 13(4) of the Act of 2002. A possession notice in respect of the residential house of the petitioner was published on 27th April 2011 and a sale notice was published on 10th May 2011. The petitioner had applied section 17 of the Act. The petitioner had applied section 17 of the Act 2002 before the Debt Recovery Tribunal. The bank had then taken a stand that it would withdraw the notices under 13(2) and 13(4). The bank had done so by publication of a notice in the newspaper dated 6 June 2011. The bank had thereafter issued another notice of 5th July under section 13(2) of the Act of 2002. This notice was issued to the guarantor. A reply under 13(3)(a) of the Act was sent on 29 July. The bank had dealt with the same by the letter of 9th August. Well, this was the factual background. Now kindly come to para 10. The issue is formulated. In such fact scenario, the question is whether invocation of the provision of the Act of 2002 on 5th July 2011 through the issuance of the notice under 13(2) is within the period of limitation as envisaged under section 36 of the Act of 2002. Well, 36 is the limitation principles of laws of limitation apply to surface. That is the reference. Now, this has been answered. Lordship will find the relevant act, the relevant provisions of the 2002 Act, that is the Surface Act, debt has been quoted. Then the provision of section 36 has been quoted. And my lord, I am skipping this for the time being. My lord, kindly straight away come to paragraph 24 and 25.
Yes.
A proceeding under section 19, well, this was filed in 2001. I showed you a lordship. The RDB Act proceeding was in 2001 in this case. A proceeding under section 19 may result in a certificate in favor of a bank. Such a certificate can be put into execution by invoking the provisions of the Act of 2002. This does not lead to an anomalous situation as the bank has contended. The laws of limitation do not take away a subsisting right. It merely postpones the enforcement of an existing right to be revived for enforcement upon happening of a future event. The bank, upon receiving a certificate under Section 19, has its right to proceed under the Act of 2002 revived. It then needs to proceed under the Act of 2002 within the period of limitation from the date of such certificate. Then, my lord, para 25, very important. The issues raised are therefore answered by holding that the initiation of proceeding by the bank was barred by the laws of limitation on July 5, 2011, and all proceedings taken by the bank consequent upon and pursuant to the notice under Section 13(2) of the Act of 2002, dated 5th July, are quashed, including such notice. And, my lord, this judgment of our High Court, my lord, this is Lordship will note, my lord, the name Dr. Dipankar Chakraborty versus Allahabad Bank has been quoted with approval by the Supreme Court, my lord, in the case of Jignesh Shah. My lord, this is 2019 10 SCC 750. আমি দিয়ে দিচ্ছি তোকে। Para 16, my lord, Lordship will. Well, the factual background of the Supreme Court case, Lordship will find from para 3 to 4.9. I am not troubling your Lordship, but there also, it is a similar question whether you can, after the expiry of period of limitation, you can invoke a second notice. Now, in discussing the law, my lord, para 16, in Dipankar Chakraborty versus Allahabad Bank, the fact situation was the suit had been filed by the petitioner in City Court at Calcutta for damages. The bank in turn filed a proceeding under Section 19 of the recovery of debt due to banks and financial institution in 2001 before the Debt Recovery Tribunal, Calcutta. The civil suit was also transferred to the Debt Recovery Tribunal, Calcutta, where both proceedings were pending adjudication. Meanwhile, under the Securitization and Restructure of Financial Assets and Enforcement of Security Interest Act, hereinafter referred to as the SURFACE Act, a notice dated 3rd March 2016 was issued under 13(2) of the SURFACE. The question which arose before the court was whether invocation of the SURFACE Act being beyond limitation would be saved because of the pending proceeding under Section 19 of the Recovery of Debts Due to Banks Act. The court negatived the plea of the bank, stating, and my lord, paragraph 22, which I have read, has been quoted. Para 25 has also been quoted. Now, my lord, kindly come to paragraph 21 of the Supreme Court judgment, which is at page, it should be at page 770 of the SCC online print. Paragraph 21. Other judgments are also quoted, and this is the ratio. The aforesaid judgments correctly hold that a suit for recovery based upon a cause of action that is within limitation cannot in any manner impact separate and independent remedy of a winding up proceeding. In law, when time begins to run, it can only be extended in the manner provided in the Limitation Act. For example, an acknowledgement of liability under Section 18 of Limitation Act would certainly extend the limitation period. But a suit for recovery, which is a separate and independent proceeding, distinct from the remedy of winding up, would in no manner impact the limitation within which the winding up proceeding is to be filed by somehow keeping the debt alive for the purpose of the winding up proceeding. And then, my lord, Lordship will straight away come to paragraph 36. My lord, in the Supreme Court case, the issue was, my lord, in Jignesh Shah, issue was, my lord, whether the winding up petition is time barred or not, because the suit is pending and was filed within time. Paragraph 36, if Lordship is pleased to come, which is at page 777. Even on the facts of this case, the winding up petition alleges that the ultimatum to the respondent company asserting that the respondent company was legally obliged to purchase the requisite shares in accordance with the terms of the letter of undertaking was on 7 January 2013. By this date, at the very latest, the cause of action for filing petition under section 433E, well, this is of course of the old Companies Act, certainly arose. Also, as has been correctly pointed out by Dr. Singhvi, the statutory notice given on 3rd November 2015 does not refer to any facts as to the commercial insolvency of LAFIN. The statutory notice only refers to the suit proceedings and attachment by the EOW, which had taken place long before in December 2013. Factually, therefore, no basis is laid for legal contentions argued before us by Shri Kaul. In the winding up petition itself, what is referred to is the fall in the assets of Miller. This is the factual background. Kindly come to Miller, the last 4 lines of para 37 or placitum E, which starts with the sentence whereas.
Yes.
Whereas in Form 1, upon transfer of the winding up proceedings to NCLT, what is correctly stated is that the date of default is 19th August 2012, making it clear that 3 years from that date had long since elapsed when the winding up petition under 433E was filed on 21/10/2016. We therefore allow civil appeal and dispose of the writ petition by holding that the winding up petition filed on so and so 3 years, Article 137 applies, is time barred and cannot therefore be proceeded with any further. Accordingly, the impugned judgment of NCLAT and judgment of NCLT are set aside. And Miller, the last judgment which I cite is for the purpose of an interim order. What interim order can be passed? This is in the case of Umang Kejriwal. The same issue was there. It kindly comes to Miller para 3. Whereas the date when the debt was due has been shown to be 31st March 2012. The notice has not only been issued on 30th November 2023. Has only been issued. It is contended that even going by the record of default with regard to the borrower, the date of default which has been shown in the information column as May 1, 2015, which also takes the cause of action beyond the purview of the zone of limitation. Then Miller Dipankar Chakraborty was cited, Jignesh Shah was cited, and then para 5, learned counsel for the respondent seeks to argue limitation comprise a bundle of facts and mere date mentioned in the demand notice may not be the sole determinant. That apart, it may very well be reflected from the concerned balance sheet and account. Be that as it may, in view of such arguable question having been made out, the writ petition shall be listed on so and so. Affidavit directions were given. Operation of the impugned demand shall remain stayed till disposal. And my lord, applying the ratio, if my lord now comes to page 81.
This is the Form B notice under IBC.
Yes.
Lord, page 81, Lordship will find this is the demand notice, my lord, under Form B, under the Insolvency and Bankruptcy Code dated 11th June 2025. This is in our case. My lord, in that, my lord, towards the bottom, kindly see, my lord, serial numbers 3 and 4. Date when the debt was due, 4th November 2013. Date when default occurred, 4th February 2014. And my lord, kindly see the amount in default is the same, 33 crores 74 lakh 64,250, which my lord, now if Lordship again comes back to page 73.
Is any matter pending before NCLAT? Page 82, it says application in NCLAT admitted on 22. Next date of hearing is such and such.
This is against the borrower.
All
My
nothing.
learned friends appear for the guarantors.
All right.
But my lord, the principle is the same. Is my lord, date of default and debt due being admitted. You can't have a fresh cause of action in 2025 and we are covered by this.
Now they have
And my lord, the
95 application.
Well, the reason why, my lord, it was mentioned, my lord, they now, my lord, after the first day it was moved, They file a section 95 application before the my lord, National Company Law Tribunal under the IBC seeking, my lord, personal insolvency proceedings. Now, insolvency proceedings are also on the same NPA and date of default. So, my lord, the question will be, my lord, that is why, my lord, an interim protection, my lord, is of importance so far as my client is concerned, because if this notice is not stayed, then, my lord, they will proceed with this. Because the cause of action is, my lord, and my lord, moratorium will apply and, my lord, no proceedings will lie. So, my lord, my respectful submission is, Lordship will consider and pass an interim order. My lord, this is the petition, my lord, which they have filed before the NCLT.
This is without annexures.
Well, this, my lord, I am just showing to your lordship without the annexures, just for my lord's perusal. Lordship will find the petition is seeking, my lord, personal. It's a personal proceeding against Mr. Tibrewan.
All right. Yes, your submission.
This can be decided here and now. But all these issues that have been shown by my learned senior friend has been decided by the Supreme Court in one judgment of 2025, particularly in respect of the Insolvency and Bankruptcy Code. But before I take your lordship through the provision, 3 sections I'll show, nothing else, my lord. But before that, I'll have to show exactly what has been argued factually. Mr. Chaudhuri says that there are 2 notices issued under the provisions of the SARFACI Act, particularly section 13(2). That is absolutely wrong. There is only
Without
one
going
notice.
into anything, page 81, which has been shown the date
Yes.
of the debt and the date of the default and the date of the proceedings. These are the 3 dates which will be relevant, nothing
There
else.
is another bit of it. Only one additional point in excess of whatever your lordship has said. The original notice that has been shown by my learned senior friend, which is appearing at page number 46, the 13(2) notice of 2014. He says there are 2 section 13(2) notices. One is your one is 24th of February 2014. The second notice, he says, is of 2025, which is at page 73. The second notice is not under the SARFACI Act. The second notice is under the Insolvency and Bankruptcy.
What happened to the proceeding which was initiated in
2014? Well, there were steps that were taken against the borrower. We have stopped taking steps against the guarantors under the SARFACI Act. So, as far as the SARFACI Act is concerned, there was an issuance of a 13(2) notice. In fact, I'm told that there is also a sale of a mortgaged asset. But today that process has come to an end. In the year 2025, before I address...
Come to an end, that means
I have not taken any
money.
steps. I have recovered part money from the sale of an asset. And as far as the borrower is a part of the asset, my remedy against the guarantors survive. So merely because I've been able...
After the borrower's asset got sold, was the loan amount not liquidated?
No, it was not.
How do you keep a mortgage of such a value that even after sale, your loan amount is not liquidated and you run after the borrower?
Because well, that is not even the issue that they are saying. Today, I have, my lord, been mortgaged an asset that is, my lord, whatever we thought was quantifiable as per the loan. The borrower, my lord, when the loan account was declared as a non-performing asset in the year 2014, I stepped against the borrower with a notice under section 13(2). I stepped against the guarantors with a notice under section 13(2). Subsequently, the borrower has now gone into CIRP. There's a corporate, which is the 2000. No, that is one bit of it. Now we have, my lord, against the guarantor issued a fresh step which we are entitled under law to take, which we have taken on the 15th of May 2025. Which, my learned senior friends, is the second section 13(2) notice, but it is not. The notice clearly is, the first notice says section 13(2). The second one says it's under the Insolvency and Bankruptcy Code. Because under law, now it's a settled proposition. I can approach and I can go against borrowers or guarantors under different statutes. There is no doubt with respect to that. Now, subsequent to that, I issue a notice under section 7(1) of the Insolvency Bankruptcy Code, which is a statutory prerequisite. Because I cannot file a case under section 95 of the Insolvency Bankruptcy Code without first giving a notice under 7(1). That is a statutory requirement. Now the statutory framework post filing is this: that once I file the application for personal guarantee insolvency, there is an automatic moratorium. So as on the date of filing, which has surpassed, but it was during the pendency of the writ proceeding, because there was no stay on me or on the notices, the moratorium today has commenced. Now, the next step beyond that is the NCLT will now appoint a resolution professional.
No, without going into that, whether you can proceed against the guarantor after the prescribed period of limitation is the issue.
Yes,
Show me the law.
I can. Lordship will look at one judgment. I'll show. Because this issue will not be decided. My challenge principle is on the point of maintainability. Lordship will look at, my lord, this is 2025. Extra copy. Sir. 2025, my lord. SCC online 375. So it's exactly similar facts, my lord. I'll read from paragraph 2 onwards. The question for our consideration is whether the High Court could have justifiably invoked judicial review under Article 226 of the Constitution to interdict personal insolvency proceedings initiated under the bank against the respondent number 1 under section 95 of the IBC by holding that his liability as a debtor has been waived. The High Court jurisdiction was invoked against the order of the adjudicating authority, but this is with respect to that point of notice and limitation. Now, Lordship will kindly look at, my lord, paragraph 3. I'll just read the facts before I take your Lordship through the law bit.
Is the limitation point?
Yes, that is the principal point here. That is the principal point. The relevant facts are that the respondent number 1 was a promoter and director of Associated Decor Limited, while the corporate insolvency resolution proceeding has been initiated against the corporate debtor as well. This is not the subject matter of the present appeal, which is restricted to the personal insolvency proceedings against the respondent number 1. Commencing from 2010, the corporate debtor took various loans from the appellant and respondent number 3 and 4, who are the consortium of banks. Respondent number 1 entered into a deed of guarantee for securing these loans on July 10, 2014. Due to default in payment by the corporate debtor and after initiation of CIRP against it, the appellant issued a demand notice dated August 11, 2020 and invoked the deed of guarantee, personal guarantee, calling upon the respondent number 1 and the other guarantors to pay an amount of rupees 244 crores. However, by letter dated 14 December 2020, respondent number 1 and other guarantees offered rupees 25 crores as full and final settlement. After issuing a demand notice in Form B under Rule 7.1 of the IBC, and on February 2021, the appellant filed an application under Section 95 of the IBC, read with Rule 7.2. The adjudicating authority, they decide that issue. Respondent number 6, paragraph 6, respondent number 1 preferred a writ petition before the Honorable High Court of the to prohibit the adjudicating authority from entertaining the personal insolvency petition against him, primarily on the ground that his liability as a personal guarantor stood waived and discharged. The High Court, vide the order impugned before us, allowed the writ petition and held that the personal insolvency proceedings are not maintainable, as respondent number 1's liability as guarantor stood waived. In order to arrive at this finding, the High Court examined various documents pertaining to the guarantee and loans. Further held that the court in so and so, my lord, not considering an application that was maintainable before the adjudicating authority and thereby distinguished the same pursuant to the impugned order. Now, Lordship will come to, my lord, paragraph. Before I show the most relevant paragraph, my lord, the factual bit I'll have to show once. Lordship comes to, my lord, paragraph 11. I'm sorry, my lord, paragraph 10. In light of the statutory scheme which has been followed by the adjudicating authority, we are of the view that the High Court incorrectly exercised its jurisdiction as, first, it precluded the statutory mechanism and procedure under the IBC from taking its course, and second, to do so, the High Court arrived at a finding regarding the existence of the debt, which is a mixed question of law and fact, that is within the domain of the adjudicating authority under section 100 of the IBC.
Where is the issue of limitation?
Whether the debt exists or not, they are saying that the debt does not exist, which is the same as this judgment.
No, you show me the Limitation Act where it has been taken into consideration. It is not that. Factually, it is not so.
No, this is, they are saying in this judgment, they are saying that today the debt does not exist in the judgment of the Supreme Court.
Limitation, not for any other reason.
I'm not talking about Mr. Chaudhury's submission. I'm saying the judgment that I've placed.
Show me something which is relevant in the facts of this case.
No, I'm showing. Lordship will bear with me for 30 seconds. Lordship looks at paragraph 9. My learned friend is correct. Lordship looks at paragraph 9. The adjudicating authority by its order dated February 16, 2024 has followed the procedure envisaged under section 95 to 100 of the IBC and has also relied on the aforesaid principle in Jiwarjat. It specifically observed that the respondent number one's objection regarding limitation and waiver of the guarantee will be considered once the resolution professional submits his report. So today, before I take your lordship through the rest of the judgment, lordship bears with for 30 seconds only. Well, Mr. Chaudhuri's case is that today I issued a notice in the year 2014. I did not act on the basis of that notice. So therefore, I have given a go-by to that notice. And today in 2025, I cannot revive that notice. Therefore, it's barred under section 137 of the Limitation Act. That is his case. Here, in a similar factual situation, the court says whether that debt continues to exist or not exist is a mixed question of fact and law, and that will necessarily have to be decided by the Insolvency Bankruptcy Court, because once the admission under 95 happens, that is the application has been filed, the adjudicating authority, that is the NCLT, will appoint a resolution professional. Resolution professional will file a report. If today the resolution professional files a report and says this debt does not exist, then it goes. But there are no 213(2) notices. That is a wrong submission. Lordship will kindly take up page number 46 once. He has shown this page. Lordship allows me to show it one more time. Lordship looks at page number 46. This is the first notice that has been shown.
Yes.
Lordship looks at, my lord, dear sir, in the middle of the page.
Yes, yes.
Notice issued under section 13(2) of the SARFAESI Act 2002. This is the first notice of 2014. Now Lordship looks at page number 73. Which is the second notice that is shown. This is dated 15th of May 2025. There is no mention of the SARFAESI Act. Now, Lordship comes at the bottom of the page, paragraph 4. By this notice, the guarantee as furnished by you against the credit facilities availed by so-and-so is hereby invoked, and you are called upon to discharge, pay the amount under default as on date, and also future interest thereon, costs and expenses to us within 7 days. Failing which, bank shall be proceeding under the provisions of the Insolvency Bankruptcy Code. So there is no connection between 2014 and 2025, because the first notice was under 13(2) of the SARFAESI Act. The second notice is under the Insolvency Bankruptcy Code. The reason I issue this notice is because this is a mandatory precondition. Now let us assume for a moment that Mr. Chaudhuri is right and this is barred by the law of limitation. If this is barred by the law of limitation, then under section 100 of the IBC, it is the resolution professional who is to decide. The judgment which has been shown, my lord, just the coordinate benches, they are no longer, my lord, they are not binding, because now 2025, the Supreme Court says that it is the adjudicating authority which is to decide, not the writ court. Which is why, my lord, Lordship will come back to the judgment I've shown, paragraph 14. 14, this is the portion, my lord, that I wanted to show. 11 once, my lord, will take up. Because there is an entire mechanism. Lordship, we look at the judgment that I have placed, my lord, once. This is the main paragraph, my lord, that I wanted to show.
Yes, yes, you read.
It is well settled that when statutory tribunals are constituted to adjudicate and determine certain questions of law and fact, the High Court do not substitute themselves as decision-making authorities while exercising judicial review. In the present case, the proceedings had not even reached the stage where the adjudicating authority was required to make such determination. Rather, the High Court exercised jurisdiction even prior to submission of the resolution professional's report, thereby precluding the adjudicating authority from performing its adjudicatory function under the IBC. Now, paragraph 12.
Under which provision of law you are taking steps, will that be more important? Or whether the loan amount can be recovered, that will be more important?
Both. Because today, whether the loan amount can be recovered or not recovered, that would necessarily I am saying the loan amount can be recovered. Personal guarantee has not extinguished. My limitation does not start from 13(2). My limitation starts from invocation of the personal guarantee under the Insolvency Bankruptcy Code.
And anytime you can do it.
Under the statute, Lordship, I have not been able to explain myself. If today I proceed under the SARFAESI Act for recovery of money, that is by enforcement of mortgage, my limitation is from the date of issuance of the 13(2) notice. I have not done so. So my chance is gone. Now, once I proceed under the insolvency bankruptcy code, then my limitation commences from the date I issue a notice under the insolvency bankruptcy code.
That means there will be different points of limitation for recovery of the same mortgage till
Yes,
full
that
amount?
is the statutory mandate.
Sorry, I need
That
to.
is the statutory mandate, my lord.
No.
Because that is what that is. That is. Well, Lordship, bears with me for just one more. Lordship is passing the order. I'll about it. So my invocation of the bank, the personal guarantee for the purpose of section 95 is in 2025. I have not taken steps pursuant to the 13-2 notice because that cause of action is gone today. And also now that I have filed the section 95 application before the NCLT, there is already a moratorium that is operating. Today, section 7(1), my lord, according to Lordship will kindly, which is why I was showing, my lord, paragraph 12. Lordship looks at paragraph 12 once of the judgment.
Please
While
come.
there is, Lordship will look at the, at least, my lord,
No, no,
Lordship,
please come.
for the satisfaction of the court, my lord. Because it's clearly held, section
The-
7(1), on that specific point.
The notice dated 15th May 2025.
Very well, may I just show section 96 that
issued
now
by
it's state.
the Canara Bank. And the subsequent notice dated 11th June 2025 by the bank to recover the loan amount which fell due in the year 2014.
That is operating, but I could not have enforced it. She'll stay the notice.
কি বললাম?
Lord, may I just make one submission? Factual submission. The interim moratorium has commenced today.
Which fell due in the year 20.
Under provisions of the Insolvency and Bankruptcy bracket open application to adjudicating authority. Now, under the provisions of the Insolvency and Bankruptcy Code 2016 and the regulations thereof, is impugned herein. Stop. Paragraph, the parties have already filed their affidavits. Stop.
Well, the
The
report has been filed by. We've not
report
filed
you've
that.
taken, it's an affidavit in the
It could
form
be
of an affidavit.
report on
Do you want to file any further affidavit?
I don't think that will happen.
Acha. ঠিক আছে. Has been filed and the matter is required to be heard. Stop. The immediate urgency which the petitioner pleads is that the NCLT is proceeding against the petitioner for invocation of personal guarantee. The petitioner prays for stay of the proceeding. Stop paragraph. Whether the bank can proceed to recover the loan amount at such a delayed point of time is to be decided. Stop. Next. For the time being, the bank is restrained from proceeding any further against the petitioners for recovery of the loan amount till 28th of November 2025. Stop. The matter is directed to appear in the list for hearing on 4th November 2025.
Lordship will record my objection, my lord. Otherwise, I'll not be able to, my lord, seek vacating of the SIP under 39(4).
According to the bank, the bank has the right to proceed against the petitioners, being the guarantors of the loan, for recovery of the loan amount.
Lordship will kindly record the judgment that I've placed reliance upon, my lord.
I have not recorded the petitioner's judgment.
My mind, my lord,
so
with
we
respect
will
to
not
my
record
objection.
anything.
Otherwise, I'll
Nothing.
be precluded from taking this point of maintainability later.
You the bank has taken an issue of maintainability of the writ petition before this court. Stop. It has been submitted that the proceeding before the NCLT ought to be permitted to continue. Stop. The তারপরে ইন্টারিম অর্ডারটা দেবেন, এনার বক্তব্যটা আগে দেবেন, দিয়ে তারপরে ইন্টারিম অর্ডারটা দেবেন। অলরাইট, আর একটা লাইন লিখে দিন যে it is within the jurisdiction of the resolution professional to take a call as to whether the loan amount still exists or not. Yes, call the next matter.
I was appearing on behalf of the petitioner. This is with regard to classic. I'm sorry.
Yes.
This is with regard to classification of a loan account as fraud. Milord, I indicated, Milord, on the last occasion, there were two, Milord, successive notices. Once I replied to the first show cause notice, a second show cause notice came. Milord, the show cause notices were based on certain documents which are not, Milord, admittedly, Milord, furnished to us. And then, Milord, rate flagging and all, which were, Milord, all sine qua non for, Milord, declaring a loan account as fraud. Milord, going by the show cause notices, those things, Milord, took place later. So, Milord, here, Milord, is a case where, Milord, the cart was put, Milord, before the horse. Milord, on the last occasion, Milord, an impression was given to your lordship by my learned friend's client that, Milord, they are not going to, Milord, proceed as of now. But, Milord, I am told, Milord, my learned friend will correct me, Milord, if I am wrong. Now, Milord, they are going for a review, which, Milord, even the circular does not permit.
Review of
Their own decision.
Where is your affidavit?
There was a direction for filing our report in form of an affidavit, and following this filing of this writ petition and the amendments made therein, we have got the instructions from our client that they have referred this matter to the competent authority for review of the process, whatever in which they have declared the account as fraud, and which is why they have they have requested to sought for some time to file our report in form of an affidavit.
You have forwarded to the competent authority
Of the bank only.
There is a willful defaulter identification committee.
Milord,
So,
this is not
declaration
willful
of
default,
fraud.
Milord, this is
Declaration of
fraud.
fraud.
Milord,
All
there are two
right.
separate circulars.
So there is a committee.
There must
Right.
be a committee.
So you have who in the writ petition, where are the documents to show that a committee was formed for identification of the petitioner as fraud or something?
That is what we were supposed to come up with in our report in form of an affidavit. We have communicated the last order to the respondent bank lordship. So what they did that they have referred this matter into their internal committee only for the to review the process by which the declaration of fraud has been taken into.
All right.
So that process is under process right now, lordship. I am carrying the instructions given. So I am praying for some more time to file my report.
All right.
Milord, there is a
Yes, instruction, lordship.
This
I am
shows that, Milord, a step is being taken, Milord, to overreach the proceedings, Milord, of this honorable court. I tell your lordship, Milord.
Overreach.
No, Milord, I tell you, lordship, Milord,
They can always rectify it.
Milord, in my humble submission, my humble
They cannot rectify their own errors.
Milord, I tell you, lordship, Milord, why? Milord, there are two separate circulars by Reserve Bank of India.
Yes.
One, Milord, is with regard to willful identity, Milord, this willful
Defaulter.
default, which my lord was referring to. There, Milord, there is a mechanism provided in the circular for, Milord, review, recalling, etc.
No, this is not a review in that exact form. They want to check up as to whether the proceedings initiated against you
review in
for declaring you as fraud was proper or not.
Milord,
It's not that review.
Milord, of course, subject to correction by lordship.
No,
As
no,
a
please
student
come.
of law, Milord, when Milord, an administrative
They-
authority, Milord, takes a decision, Milord, he cannot sit over it, Milord, as review, as a review committee.
They cannot rectify their errors.
Milord, if this is a clerical error, they can.
Next, আপনি লিখুন তো যে learned
Milord,
advocate
let
for
them not
the
take any coercive step in the meantime.
learned advocate for the bank seeks extension of time for preparing the report by way of an affidavit. Stop. It has been submitted that the bank is looking into the matter afresh to ascertain as to whether the process adopted by the bank to declare the petitioner as fraud was in accordance with the circular of the Reserve Bank or not. The Paragraph, learned advocate for the petitioner submits that there is no provision which permits the bank
To have a
to
relook, my lord.
sit over the matter all over again once an administrative decision has been taken by the bank. Stop paragraph. The on the request of the now on the prayer of the learned advocate representing the bank to file now for extension of time for filing the report, comma, hearing of the writ petition stands adjourned till 3rd September 2025. Step next. Steps taken by the bank shall be taken by the bank to declare the petitioner as fraud shall be clearly disclosed in the report to be filed. Stop. Advance copy of the report shall be forwarded to the petitioner. Will you be able to do it within the 3rd?
We will try, Lordship. I hope we will.
Because
be able to.
advance copy to be given to him so that he also gets time to go through
The
it.
review is already.
My lord, another week may be granted in for the my lord. I'm appearing on with my learned friend on Srijoni Ghosh. Another week may be granted, my lord.
10th of September.
Much obliged,
My lord,
my lord. Much obliged.
Here we have protection in the meantime because this will not entails penal consequences.
Yes, let them come up and say because the writ is pending.
Milord, what Milord I am anticipating, Milord, if the review committee or whatever committee Milord my learned friend's client has constituted, Milord comes to a decision in the interim and Milord take a steps in accordance
Got
with that
liberty to mention, Likunta? Last, liberty to mention.
Grateful.
Much obliged, my lord.
Grateful to your lordship. Great.
But I be activated for the response number 6.
Petitioner Lordship,
Commission Lordship.
Mr. Raghunath Chakraborty, he is engaged in court number 11, Lordship. One habeas corpus matter is going on there. Praying for 1 day accommodation if it is.
Only not today?
Yes, Lordship.
All right. Next.
Correct, Lordship. Please, my lords, my lord, I appear for the petitioner.
Who is your other side?
My lord, the collector of stamp and revenue, Lordship.
That means the state authority.
My lord, it's a very short matter, my lord. May I explain? This already covered by.
Who is your other side?
We have served our affidavit of service.
Collector of Kolkata, Stamp and Revenue.
Lordship.
Who did you serve? Did you serve the AOR's office?
We have served the stamp authority.
Did you serve the AOR's office? No.
Oh,
That is the reason nobody is appearing.
Well, it may be kept tomorrow. There's a little urgency in the matter, but it's a very short matter. It's already covered.
Serve the AOR.
My lord, we'll come back
I'm
tomorrow.
making it only not today.
Grateful, Lordship. Grateful.
Don't call the hearing matter.
Well, may I permit you to mention, my lord?
No, this is not the time to mention. এখানে স্লিপটা কি Call 7. Item number 7.
Well, it's a transfer case, as per my instruction, the alleged part has been demolished by the respondent. Self-demolition has been done, my lord. And my lord, yesterday I have sent to the notice about the mentioning, my lord. Is the Moistana municipality. And my lord, I have the written instruction, my lord.
Let me see the written instruction. Why there was a requirement of the change of the council?
That, my lord, I do not know. They have.
You do not know. Somebody was
My lord, I have called for the
handling the matter, and all on a sudden, this is changed, and it says that the order has been complied with.
That is what municipality is required. My municipality will tell the actual truth.
No, no, no. I do not want to know from the municipality.
The client, my lord, what I have told, my lord, to written instruction given on me, my lord, that he has, my lord, given. That is on my part. My lord, I have asked why this the withdraw, my lord. He said, my lord, the respondent self-demolished the part. My lord, that's why I have mentioned the matter and sent the notice to the municipality.
Where is your no objection wakalatnama?
My lord, I have filed.
You have filed it, yeah. Shailesh, please check whether the no objection wakalatnama has been filed.
Yes, sir, my lord.
Yesterday?
Yes, ma'am.
All right. আছে? আছে? All right. Please take down. Learned advocate, Mr. Devoshi Brahmo, submits that he has received no objection wakalatnama from the petitioner and has filed the same in the department on 19th August 2025. Stop paragraph. The learned advocate has produced a written communication from the petitioner signed on 19th August 2025, mentioning that some portion of the unauthorized construction by the private respondent has been demolished. The petitioner intends to withdraw the contempt case that is pending. Stop next. In view of the communication made by the petitioner expressing his intention to withdraw the contempt petition, the contempt application stands disposed of. Stands dismissed as not pressed.
Or the letter kept in the.
Yes, yes. The letter will, the communicating letter of the petitioner be retained with the records. Signed on 19th August. Be written with the records. Next.
দিয়ে দিয়েছো তাই না
Item number 8, I am for the Union of India in this matter, my lord.
Directorate of Indian Army Veterans and others.
My lord, I am behalf of the respondent number 6, my lord. Mr. Kollal Kumar Basu was appeared in this matter on last occasion, my lord. Mr. Kollal Kumar Basu appeared in this matter on last occasion, my lord.
I do not see his name over here.
For the I think for the respondent number 225, I think. No, 6. Respondent.
You are there for 1 to 5.
I am for respondent number 6, my lord.
The lady was appearing in person.
Respondent number 6, my lord. I am for the 1 to 5. But my lord, they directed to
Oh, acha.
appear.
It will secretary. No, it's all right. There is. It has appeared for some correction. The member secretary DLSA. This will be changed, right? Only for this change that has appeared. What will be the correct designation? I will take information from the office and write it. All right.
Is there any order, madam?
There will be an order. I will make the necessary correction. The order will be uploaded in the net. Yes, yes, your name you give. Name you give. এইখানেতে মেম্বার সেক্রেটারি ডিএলএস এটা হবে না। এখানে যেটা হবে সেটা বৈশালীর কাছে কালকে লিখিত দিয়ে and only your appearance, the private respondent, you put in your name, not anybody else's name. Yes. And 9 to 19 also same.
9 I am for the state, madam.
Yes, give your name. 9 to 19. Same order.
For the district judge.
9 and 12 I am appearing for the commission.
Put in your name. Yes.
Well, item number 20 has appeared as under my instance. Because if this is with regard to ferry service, it was the query of the Honorable Court that whether this matter will be heard before this court or not. No, Lordship, it is not
Ferry service by?
Ferry service by the Judicial Department. Lordship, kindly come to page 23.
Judicial Department
Yes,
ferry
Lordship, kindly come-
service.
Yes. Page 23. I was under the impression it is either conducted by the Land Department by
Yes.
or by the Panchayat. Lordship,
Right.
kindly come to page 23. That is the
Murshidabad
notice
Estate.
tender. Estate officer, Murshidabad Estate Judicial Department. Because I cannot approach the Group 5 bench or the Group 1 bench. Now, when the tender was invited, under the tender condition, I was allowed to carry 4-wheeler, 3-wheeler, motorcycle as well as cycle. Immediately, my lease commenced from 1st September 2024. On 5th, an order was issued by the district magistrate.
Who is representing the Murshidabad Estate?
Mr. Ansar Mondal was with Tanvir Zamal. I have served it through WhatsApp. They have notified the notice that this matter will be taken up today.
All right.
Because my lease is still 31st of August.
All right.
In the meantime, they have again modified the condition of the lease that I cannot operate 3-wheeler. Even the subsequent tender which has been invited, that is not on record. Here also they have permitted 3-wheelers to be carried in the vessel.
3-wheelers means auto or what?
Auto rickshaw and
Totos.
van.
Oh, van.
Toto.
They are being ferried in the this
Country boat.
country boat.
Motorized country boat.
Lordship, Mr. Mandal is appearing for the state. Can it be a little pass over, Your Lordship? He's in another court, Your Lordship.
Will he be appearing representing the Murshidabad Estate also?
No, no, no. Your Lord, only the state. State authorities.
Check up.
So I believe the state can
Check up. Please check up.
Then
I'm passing it over. You please check up.
okay.
It's better. See, it's there in the to be mentioned heading. It cannot be hard. So let it appear in the heading motion.
Tomorrow, because my lease
Urgent motion. Urgent motion
August.
tomorrow. Tomorrow urgent
I've
motion.
suffered huge loss.
Urgent motion tomorrow. At a line likhe deben to let the matter appear in the list as urgent motion tomorrow. Let notice be served upon all the respondents.
Item number 21, this is my application. It is that matter, my lord, City Civil Court, my lord, where Mr. Basu Mollik was appearing on the last occasion. That records were to be traced, my lord.
Yes.
We have got the communication from the registrar City Civil Court suggesting that records are taken up for reconstruction. And although we have deposited our my lord, documents, my lord, the learned registrar had informed us if at all we have any other documents, we should put in those documents to the learned registrar so that the
Now,
reconstruction.
some steps have been taken for restoring.
Yes, some step has been taken, my
Will
lord.
the matter be disposed of, or further steps are required to be taken?
My lord, I was requesting, praying before your lordships, my lord, for 2 weeks time so that I can ascertain whether the reconstructions has proceeded in its proper manner or not, my lord. Just 2 weeks. Thereafter, my lord, kindly disposes of this matter.
No, no, my lord, I had a talk with the, they have supposed to come with the report, with the
Not
latest.
come.
I in the morning I had a talk.
Gunto, the let updated report by the Registrar City Civil Court, Calcutta, be placed before this court on the adjourned date. Stuff released. আজকে তো হচ্ছে 20 3rd of September.
Grateful.
সকালবেলা পড়লো রিপোর্টটা নিয়ে আসছে আমরা মিটিয়ে
Number 22.
Millers is the same West Bengal incentive matter, Millers.
Yes.
Revocation, Millers had already
Right.
granted us an urgent motion today, Millers. Last order is essentially all that Millers need to be
Yes,
passed again,
yes. Please give.
and the matters can be tagged.
Did you serve?
Yeah, Millers has been served already. Of course.
I am for the WBSCTCL authority.
Fully
The
served.
Incentive authority is different.
State?
State.
Sure, this is the last order Millers had passed of the Grasim matter. These two matters
Same order can be
same
passed
order
or
can
it will be
passed,
tagged.
Millers. Absolutely can be tagged, Millers.
Even if it is not tagged, when the matter one is taken up, the other can always follow.
Also follow, Millers. If it is tagged, Millers, there's only one reply because I know, Millers, I've drafted the same writs, Millers. Identical prayers are there. There cannot be anything different. 2004 scheme, 2008 scheme.
The
and
matter may not
revocation.
differ, but the councils may
I
differ,
understand, Millers.
and there are other reasons also.
No, understand. Millers, there are other matters also coming, Millers.
Let's
They're already
come
passed
one by
order.
one.
It will all come together.
It will all-
There is
one matter hurts, the order will be the same in all.
My lords.
এই
It's already
orderটা হবে।
coming up on the 7th of November. So
Right.
that's all, Millers.
Yes, yes, same order.
এটা দিয়ে দিই
হুম।
22-23 দুটোই তো।
23 will also be the same?
Same, Millers.
All right.
Millers,
Lordship, any appointed mediator in that matter?
When, which matter?
With this, that Kullan Krishnan on this matter? No.
There is a name of the member secretary. This has to be changed. And I will not appoint the mediation, the department, they will do it. So I will just change the name of the mediation. I am not appointing anybody.
That's very difficult to mediate. Very difficult.
Even I know it's very difficult. I do not know, maybe the court will have to act as the mediator.
Even on that matter, that Malvika Saha matter.
Yes, division.
When I convince Mr. Shekhar Basu, Mr. Shekhar Basu said, day after tomorrow, please come. I will. Then that lady said,
I'll give-
no,
Ashish,
that, blah,
Ashish
blah,
is-
blah. Justice Basak release the matter.
Achha, I'll do that. He'll just come.
Yes.
Millers, my learned friend is also suggesting, Millers, if it can be tagged together, all of them can come together.
Yes,
Learned
yes,
AG is
it
opposing it.
it will appear, do not worry.
My lord has already. Millers, I just travel every time, that's why.
একটা অর্ডার করে দিন তো ট্যাগিং এর, তাহলে পরে অসুবিধা হতে পারে। Let this writ petition appear along with যেটা দিলাম তার সাথে।
almost one matter it will cover.
One matter covering all.
All.
And AG will be there for the state.
yes.
He's already appearing.
He's already appeared, Millers. Grateful.
Yes, call the next one.
Grateful, Millers.
24 I am applying for the private response.
All right. দেখি কি মামলা?
But the classification of the land is jol,
Hmm.
but the application made that by illegal filling of the water body. In the Mednipur district, jol is the agricultural land.
Yes.
And I upon the conversion and with the sanction plan making construction. This is my case.
You are?
I have the private respondent.
Yes, yes.
Kindly see the prior.
Yes.
To restrain, edit in the nature of manner, respondent to take steps for restraining the respondent number 10 and 11. That is my client from making any illegal conversion of the wetland to the Vastu land.
The jol is not the wetland over here.
Jol, Midnapur district
Yes,
plot
yes,
number
yes,
that
I'm
is
aware.
the agricultural.
Bring your other side. Mr. Alok Ghosh. Raghunath Chakraborty and Monisha Nath. None is here. State is also not here. Who are you for?
24.
24.
For the state lordship, Jawaharlal De and Mr. Rudranil is appearing for the state.
You are not there. Then, where are the counsels?
They are engaged in another court, lordship.
Call the learned advocate for the petitioner. It can be disposed of here and now. Please call. Yes, pass over. What Dakun? Let me see. Let me see the file. Achha. Item 25.
My lord, I appear for the petitioner, my lord, in this matter. I am led by Mr. Kollol Basu.
Yes.
My lord, in this matter, the petitioner is aggrieved by the deactivation of his Aadhaar card. My lord.
Is there any reason for such
one moment, my lord. Yes, my lord, I am led by Mr. Basu. He will just address the court, my lord.
My lord, this is a case, my lord, where the petitioner before your lordship has already been charge sheeted, my lord, on the ground of suspicion that he is not an Indian citizen. Be that as it may, my lord, he was taken into custody. My lord, he is still in custody. And my lord, his Aadhaar card has been suspended.
Yeah.
Now, in a similar deactivated. Now, my lord, in a similarly situated matter, which was filed before your lordship, during the pendency of the writ petition, my lord, the suspension was revoked, and my lord, the gentleman, my lord, who was in custody and was placed with the similar facts and circumstances as that of the writ petitioner before your lordship, my lord, he has got the relief. I am praying, my lord, the same consideration by the authority that unless and until a man is proved to be guilty, my lord, the suspension of the deactivation of the Aadhaar card, my lord, that is absolutely, my lord, unwarranted.
Yes, yes,
Other authorities have been served or not, my lord, that is to be looked into.
Other authority have been served. Everyone has been served, my lord. Respondent's instruction is that everyone has been served. That is advocate on record.
What is your instruction? You will not appear for the.
I have to take instruction from the other authorities. If other authority will not instruct me, my lord, then I can appear. Normally, my lord, I cannot appear.
Do they engage other counsels?
Yes. Sometimes they also engage other counsels.
Who usually appears for the authority?
Amrita Pandey usually appears for the
Who
other.
appears?
Amrita Pandey.
She also appears for the Union of
Yes,
India.
yes.
Then you take instructions.
I will take instructions. I'll take instructions.
Here the petitioner is in custody still now.
Yes.
He's a foreigner, my lord. That's why, my lord, he has.
No, till
that is
submission.
whether I'm a foreigner or not, that is yet to be decided.
To be a foreigner, are you there for the state? What is your submission with regard to the status of the petitioner?
Page 42, they is similarly situated.
Not yet received.
Will at page 42, if your lordship kindly takes pen, will have to turn page 42 of your lordship's brief. Will
Right.
your lordship will be pleased, page 42. Will your lordship will be pleased to find that the gentleman, Millard, who was
Let the
arrested.
authorities take instruction because they do not have instruction. Please come.
42 kindly will takes pen, will have to turn 42.
Learned advocate representing the respondents.
State is yet to take this.
To take instruction in the matter. Stop. None represents the respondent numbers 2 and 3. Stop. Learned advocate representing the Union of India is directed to obtain instruction from the respondent numbers 2 and 3 and place the same before this court on the adjourned date. Stop. The respondent authorities shall keep in mind that the citizenship of the petitioner has not yet been
Not
proved.
decided.
The
Only Aadhaar, not citizenship.
Acha, only Aadhaar. Acha. No, but then why has he been taken in
There is
custody?
no question of citizenship. He is a foreigner. Kindly see.
That is why that is why my client has been charge sheeted and taken into custody because he's unauthorized staying in the country as per the Foreigners Act and the other provisions of law. Millard, he is an accused and investigation completed. He has been taken into custody. Be that as it may, that should be the outcome of. We do not know what will be the fate of such proceeding. But the question is, Millard, during the pendency.
Order was passed by a coordinate bench of this court.
Millard, coordinate bench did not pass any order. Page 42 is an instance, Millard, where your lordship will be pleased to find that a person who is similarly circumstanced, Millard, named in the same complaint, named in the same complaint, my lord, his other
There
deactivation
is no
has
doubt.
been restored by the same authority. Page 42.
Under similar facts,
Voter cards has been
order
directed
was
to be
passed
restored.
by
And my lord also, and not only that, kindly record my submission. This is my instruction. In the page 42, your lordship will please.
of 2023, annexed at pages 42 to 46 and 49 of the writ petition. Next Wednesday, it is 27th, list on 27th. Yes, call the next one.
Deeply obliged, my lord.
Petitioner lawyer in custody naki?
On screen.
Since here my lord lies, he is in custody. My lord, kindly come to page 160. Straight away. Then I will go to the facts and figures of that. This is an order which is subject matter of challenge. But without any tender, without any selection, this person has been allotted, and kindly important is, my lord, may I read it? In pursuance of file number such and such, Hasto Bhavan, Kolkata, the exercise eligible contractor engaged for supplying cooked diet to indoor patient admitted at Gauripur Leprosy Hospital, Bakura, shall be relieved from duty. The current cook diet contractor of Katwa Subdivisional Hospital, Bakura, shall be tagged in their place and will continue the supply at the existing accepted rates previously applicable to the relieved agency as detailed in the table below. The workman engaged by the selected agency shall be paid, not necessary. Then, my lord, Mr. Pratik Chandra Mondal was given allotment as a temporary measure for a period of 6 months for fulfill such and such. Next is important. The superintendent Gauripur Leprosy Hospital, Bakura, is requested to issue the work order to the aforementioned cook diet contractor in accordance with the existing terms and conditions, treating this as a special case. A person, my lord, has been engaged without any tender, without anything. Now, my lord, kindly go back to the history of this case. Tender was floated. My tender, I was technically not qualified. No decision has been given. Why not? Be that as it may. L1 candidate refused to accept. Initially accepted, thereafter refused to accept. Unwilling to proceed. Second one, dead. The second one, passed away. So now the what should be done? Either a fresh tender or from the person who has participated should be selected among themselves. This person never participated in a tender process. This person has been called on for somewhere and given the work order.
No, you participated, but you were found to be ineligible. Technically.
Yes, but no reason has been given. I asked for the reason why. My financial condition is much more better. I am doing this business in somewhere other hospitals, not supplied. But now the person who is not even applied with the tender has been called on and given the tender.
No, called on maybe from the neighboring district because it is mentioned over here.
No.
Yes, he is the contractor of Khatra Subdivision Hospital, Bakura. So he is there from the same district from a separate subdivision.
Why?
Now, diet
can
has
be
to be.
engaged?
Well, let me hear.
Yes, can hear him.
Today, my lord, I have to
Take instruction.
And my lord, the private respondent.
And Pratik Chandra Mondal has been made party.
Yes. That I have
Served.
Yes.
You take instruction as to why it shall be treated as a special case. And
but I am working in the Bakura District Hospital.
You are also supplying. All right, then why it should be treated as a special case? Please come. None represents the private respondent. Stop. Learned advocate representing the state respondents takes time to take instruction. Stop. The order dated 4th August, first paragraph korben. The order dated 4th August 2025, issued by the Chief Medical Officer of Health, Bakura, engaging the private respondent as contractor for supplying cooked diet to indoor patients as a temporary measure for a period of 6 months, or finalization of the fresh tender process, whichever is earlier, as a special case. is impugned herein. ঠিক আছে? Learned advocate representing the state respondent shall obtain necessary instruction. Next
What
Wednesday,
court has not been issued?
27th. Let us see, because I can see that it is a temporary measure, 6 months time, outer limit, or finalization of fresh tender.
No,
That
not outer
means
limit. Yes, Lordship is passing the order. Still says it, or prior to that. No, that is not the language. Language is 6 months or it may be 6 years.
no, or till finalization.
Yes,
of
will
the-
never
whichever-
finalize.
Whichever is earlier.
Never finalized.
Let
Then
us
6
see.
months will again extend.
Let us see, with satisfactory performance from the interest of the patients. Why the petitioner was
Why my
found
credential has not been considered?
ineligible, that also please take instruction. Bring the total sheet where the bid summary and everything is there, so you can get instruction from.
report will come with
Next. আচ্ছা fresh notice দিতে বললাম private respondent কে, ওটা বলে দিন. Let fresh notice be served upon the non-appearing respondent,
তারা কি করবে?
intimating the next date of hearing.
You are the government, you are the person
Next.
responsible for it.
27, 28 and 29 are identical matters.
All right.
To appear on behalf of the petitioner, Lordship, I led by Mr. Sobosai Chatterjee. He was instructed me to ask for the password, but I can proceed with it, Lordship.
No, you can proceed.
Yes, Your Lordship. The item number 27, I'm taking the item number 27, Lordship. In the item number 27, Lordship, the petitioner is a tenant of a property that is belongs to the KMDA, Lordship. I am the possession holder of the property. Lordship may kindly come to Annexure P1. Lordship will find that one notice has been issued in favor of the petitioner Arshad Hossain, that demand notice for the allotment of the vacant stall space in the fish market. That is the subject matter, Lordship, that is coming from the decision of 185th meeting by the authority, and Lordship will only consider that the stall number has been allotted at 144. That has been mentioned on the first line of the letter, Lordship. Now, subsequently, after this letter, Lordship, this allocation has been made. Your Lordship, come to page number 22. Lordship will find that thereafter they have revised demand for the past 10 years fees from me, Lordship. Page 22, Lordship, on the very next page, Lordship, that is Annexure P2. So this letter has been issued by the Kolkata Metropolitan Development Authority to me and asking for the revised demand draft for the rental from April 2010 to till date. Now, Lordship, I have paid the same. Lordship will find from page number 23 that the amount has been paid before the concerned authority. That amount to 2,26,846. I have paid. Now, subsequently, Lordship, what happened? That during the pandemic, I was unable to pay the rent time to time. Now, I made a representation before the concerned authority along with the all demands. Lordship will find from page number 24. That is the demand draft that has been issued in the year of 2022. There is 2 demand draft that is starting from page number 24, 25, and along with my letter that for supplying the tender rent of such and such. And subsequently, Lordship, I have acknowledged the same, and they have replied at page number 28.
1 minute, page 26. You have mentioned stall number 143.
Lordship, that
And
two petitioner,
page-
Lordship, that mistakenly placed, Lordship. In it will in item number 29, Lordship, this person is there. Maybe
29?
wrongly placed, Lordship.
Arshad Hossain.
Arshad Hossain is the petitioner number in petitioner in item number 27. 29 is the petitioner. He is Arshad. No, it's Lordship. Oh, that may be typographical error, Lordship.
Typographical error?
That stall number 144 instead of 144, it has been typed at 143.
All right, so it is Arshad's case.
Arshad.
All right, then.
Petitioner is the Arshad.
All right, then.
Now, Lordship, kindly come to page 28. What they have replied.
Yes.
Lordship, by memo number 332, they have replied
stall
that
143.
return back of 2 demand number of demand of such and such in connection your tender rent such and such. Fees market for year of 2020 to 21 is hereby returned back to your present address due to some unavoidable circumstances. That they have replied. Due to unavoidable circumstances, they could not receive the rent. Now, Lordship, subsequently, what we have find, we are in the possession of the property. We are still in the possession till date. On 19th/5/2025, without any affixation, without any emblem, without any seal, Lordship, this notice has been affixed beside my shop room. What has been stated as per the decision of the competent authority that those stalls are vacant. And to vacate the stall on such and such. So I am in the possession. They have asked me for the vacation. Now, Lordship, they have floated the tender notice without due process of law. They have floated the tender notice. I am willing to pay the entire rent, whatever is
till they can ask lordship. I have last occasion, I have asked them to take my entire rent lordship. They refused with by citing that unavoidable circumstances they cannot accept the rent. Now they have floated this e-tender notice by saying that this portion is vacant. Now lordship kindly come to serial number 6, the allotment of vacant stall number such and such, fish market came down license basis of such and such. So my grievance is that lordship, I'm ready to pay the entire amount lordship. If they want to
From
proceed,
20 till 25, you have not paid.
yes, your lordship. On last occasion, when I've tried to pay them, they have refused to take the.
That means it is not paid.
Yes, your lordship. Yes, your lordship.
So,
That is admitted fact.
can you hold on to a government property without paying rent for 5 years? And if it is so, if the authority declares that to be a vacant land, where is the error on their part?
So they cannot say it vacant because I'm in the possession of the property.
You are unauthorizedly occupying.
So lordship,
You
there
are
is a-
to vacate it.
Yes, your lordship. There must be a proceeding to vacate the property, lordship. In the meantime, if I am
What is
eligible,
the proceeding by which you are holding on to a stall without payment of rent?
no lordship, I am ready to pay the rent because last
Ready
occasion.
to pay is something
Yes,
else.
your lordship. But last
When in 2022,
lordship.
they returned the money,
Yes, your lordship.
February 22, did you approach the court?
No, no, lordship.
Why?
No. Well,
You
lordship-
sat tight.
Yes, your lordship. No,
Then you did not approach.
No, lordship, there is another thing that one writ application has been filed by the other petitioner where I am a private respondent.
Yes.
Whether they have asked in the year of 2019, one writ application has been filed by the other person who are saying that we are the most eligible to take the vacant possession.
Yes.
But subsequently in their 2018, in the year of 2018, we got the possession as per their allotment. They have allotted us, we got the possession. And lordship, this petition was pending. This petition is still pending, maybe still pending, lordship. Subsequently, lordship, we got this e-auction notice and we approached before your lordship. in
You
this regard.
participate in the auction process. Where is the difficulty?
But lordship, we are in the possession of the so far, lordship. If they want to vacate me, lordship, there must be a law proceeding should be taken by them, lordship, to vacate me. They have affixed a notice, but we do not know that whether the notice has been issued by them, whether that is authenticated or not. That is another question. Lordship may find we have got it from the wall, and then after lordship we have annexed the document. There is no seal at all.
If there is no seal,
So, lordship, we
don't
have
take
given-
it as authenticated and don't disturb
No,
the
no,
writ
lordship,
court.
subsequently,
No, if you say that this is not a proper
that is-
document, then do not come to the writ court.
lordship,
See your writ
so far
petition.
this, my humble
No,
submission.
you have to say that this is a valid document and this is the reason you are challenging it.
Lordship, that notice has been issued by them, and subsequently this e-auction notice has been floated.
Yes.
So my grievance is that, lordship, if I am ready to pay the entire amount, if they want to get, and they must be followed a proceeding for evicting me, lordship, from that possession, because I am still in the possession, lordship.
This is the reason the government is losing such a lot of revenue. Only for people like you who are occupying government property without payment of rent and the government is sleeping.
Lordship, I am humbly can
No, no, humbly submission. I have followed it.
22. I have
Yes,
signed
KMDA, what is
the
your
amount, but
submission?
they not accepted my rent, lordship.
KMDA.
My lord, regarding this fish market, may I tell you, lordship, in 1976-77, the fish market was constructed by the erstwhile Howrah Improvement Trust. And market was under the control of the HIT, which subsequently, my lord, the management and control was
Taken over by
taken over by the KMDA in 2011-12.
Alright.
After taking over, at the time of taking over possession, we found that 25 stalls were not allotted to anyone else. Yeah, but they are unauthorizedly occupied by adjacent stallholders. And since we have taken over possession from 12, we are unable to collect rent even. So process is, we are trying our level best to, several litigations were also made by unauthorized occupiers for regularization. Some writ petitions, some prayers were refused by the Honorable Court. One of such order I have brought. My lord, in the meantime, these petitioners, there are 4, one has not come. Approach the authority to allot them a stall to run a business. My lord, considering their prayer, my lord, what has been shown by my learned friend, P1, if your lordship kindly come to the terms of such allotment. He was allotted, this petitioner was allotted stall number 144. The first line of the lordship will find on
Yes, yes,
temporary
142
basis.
then.
On temporary basis, and which was renewable rent was revisable after 3 years. The last two lines, Lordship, kindly have a look. The KMD authority will be entitled to cancel the allotment without assigning any reason thereof and shall take possession of the stall. The lessee will not be entitled to any compensation on that. After that, my lord, he has paid initially, if your lordship sees the demand, at page 23, lordship, kindly come.
Yes.
This is the payment received by KMDA. Lordship, left-hand side particulars, Lordship will find that March 2019, thereafter no rent paid. And then what my learned friend was trying to show me, Lord, at page 26, Lordship will find that
See again, page 23, stall number 143. Left-hand side, second line in the table. For stall number 143, you allot 144.
Yes, there. This
Is he occupying 144 or 143?
144. According to us, 144.
That means he is occupying both.
Occupying both.
You
And
legally...
to page 28, why we have refused? Because he was allotted 144. He sought to tender rent
for 143. Obviously.
Page
It has
28,
been-
page 28, we returned back.
Mm.
And then, my lord, what we have decided, these 25 stalls should be
Put up in auction. Yes.
put it to auction. And they were not only verbally told, this notice was affixed on the wall of the shop.
Why are you
stall.
going? You are a state authority. Why will you do things verbally? Why will you not issue proper notices?
This notice, this was affixed on his stall.
Yes, but then
And thereafter this e-tender notice was issued concerning this. And in view of the allotment, the terms of the allotment, there, my lord, the petitioner cannot be said to have any equitable right accrued in his favor. That was allotted, my lord, purely on temporary basis, reserving the right to cancel at any time without any reason.
yes, yes.
And petitioner since March
2019
has
No
not
payment
paid
has
any
payment.
rent. We
Yes.
are unable to collect rent. We are losing revenue.
Right. Yes.
That is
Would
why
you
we
like
have
to submit
decided.
anything in reply?
Lordship, that the remarks of stall number 123 and 124, Lordship, that the petitioner number in item number 27, the petitioner is the Arshad Hossain, and another petition, that is item number 29, Lordship, that is Umar Hossain. They have mistakenly typed that one is 143 and 144. That is the two.
So your mistake is your mistake. The authority
No,
doesn't know.
I'm just
Please
indicating.
come.
Lordship, they have not issued anything for us to that notice has been affixed for the other stalls. I am not on that, Lordship. Particularly the stall number
The
143,
matter
144 is
relates to
concerned, Lordship. We don't have received any notice from their
tender
end,
notice.
Lordship, and we are ready to pay the entire due amount if they asked for, Lordship.
They may participate in the auction.
And so far as corporation is concerned, we are wrongly added, my lord. We have no role to play there.
If you
Corporation doesn't.
if you lordship-
Are you a party?
Yeah, I made them party, Lordship.
If you lordship sees paragraph
For your interest, you stay.
paragraph 1, lordship, one line, it has done mistakenly. It is a product of copy paste. I'm not on that.
Macher Bazaar schools have become fish market nowadays. What? The writ petition will be dismissed?
Lordship, I can correct, Lordship. We are
What you will correct?
That mistakenly, Lordship, I
Mistake?
In all
mistakes?
All three petitions. All three.
How many more mistakes will be there in the writ
Instead of that,
petition?
I have checked, Lordship. The first paragraph I failed to check.
West Bengal Board of Secondary
wait,
Education.
Maybe I why this has come, Lordship.
No, it has come rightly because the schools have now become fish markets. So it is rightly mentioned over there.
The tender apology for that, Lordship.
কি বললাম? Floated by the Kolkata Metropolitan Development Authority. Tender না করে e-quotation notice. Dated 14th July 2025. Stop. The petitioner claims to be in possession of a stall in the Howrah Fish Market. Stop. The petitioner refers to an allotment. Now, refers to a demand notice for allotment of stall issued in his favor by the executive engineer KMDA in March 2018. Stop. The petitioner has annexed the receipt issued by the money receipt dated 18th June 2018 issued by KMDA on account of rent for stall number 143 for the period April 2010 to March 2018 and April 2018 to March 2019.
144, Lordship.
It is written 143, page 23.
That was wrong.
That was wrong.
That was wrong.
19
143 would be the third petitioner. Yeah,
It will be
third
144.
petitioner.
I said 29.
It would be 144.
Acha.
Lordship,
That
it
is
has been
stall
written
number taken.
That is why we returned that.
Stall.
Sir, you have mentioned the unavoidable circumstances.
March 2019. Acha. Thereafter, the petitioner did not pay any rent for the stall in
Since May 19 onwards.
in 2022. Petitioner again forwarded a demand draft allegedly for the rent, allegedly for payment of rent for the year 2020 to 2022, which was returned by the authority.
Well, that was returned immediately, but that was not challenged.
2022, ঠিক আছে, which was returned by the authority.
With a remarks to due to some unavoidable circumstances, Lordship.
Stop. The
Page 26 is clear.
the letter by which the demand draft was tendered mentioned that the rent was being paid for stall number 143. ঠিক আছে? The petitioner thereafter did not take any steps in the matter. Stop. A notice was issued by KMDA on 19th May 2025 notifying that the stall occupied by the petitioner was vacant and
Unallotted, Lordship. It has been mentioned
and
allotted, but it was allotted.
the
Occupiers of unallotted
was treated as unallotted vacant, was treated as unallotted vacant stall and directed the occupiers to vacate the same within 7 days for KMDA to take possession thereof. Stop. Paragraph. The petitioner stresses on the fact that the stall was formally allotted to the petitioner and the same cannot be treated as unallotted vacant stall. Stop. The petitioner is agreeable to pay the rent, area rent, in respect of the subject stall. Stop. Next. Prayer has been made to direct the respondent authority to accept rent from the petitioner upon issuing proper receipt and not to give effect to the impugned e-quotation notice in respect of the stall occupied by the petitioner. Stop paragraph. Learned advocate representing the
3, 4, 5.
respondent numbers 3, 4, and 5
6, 7
opposes
should be
the
deleted.
prayer of the petitioner. Opposes the prayer of the petitioner. Stop. It has been submitted that the petitioner is illegally occupying the subject stall. Stop. It has been submitted that the stall was allotted in favor that stall number 144 was allotted to the petitioner on absolutely temporary basis. Upon payment of rent and the said allotment was renewable after 3 years. Stop. The petitioner
Rent.
did not.
My lord, here rent was revisable.
Oh, acha.
Rent was. I stand corrected.
কি বললাম ওটা?
The last two lines I have pressed.
একদম এখানটা বলুন। Upon payment of rent, stop.
Payment 20 charge 18%.
The allotment could have been cancelled without assigning any reason thereof, and the lessee was not entitled to receive any compensation.
Yes.
Stop. Next. It has been submitted that after March 2019, the petitioner did not pay any rent. Stop. Rent was thereafter tendered in the year 2022 in respect of stall number 143, which was not allotted to the petitioner. And accordingly, the tendered amount was returned to the petitioner. Stop. Rent
It has been
has
mentioned that
remained unpaid
they have not mentioned.
since April 2019. Stop. The KMDA is losing revenue for a considerable period of time. Stop. KMDA has floated an e-auction notice, e-quotation notice. Stop. Notice by treating the stall of the petitioner to be an unallotted vacant one. Stop. Upon hearing, upon perusal of the cause title of the writ petition, it appears that the respondent numbers 8 and 9 has been impleted in the writ petition, but there is no grievance of the petitioner against the aforesaid respondents.
6, 7 also be deleted because there is no
The
existence of harm.
respondent numbers 8 and 9 does not have any role in the matter. Paragraph number, next paragraph. The respondent number 6 and 7 have also been inadvertently impleted. Stuck. Howrah Improvement Trust does not have any independent existence as on date, and the same has merged with KMDA way back in the year
2023.
2023.
May I take leave, Mal?
Yes, yes.
No.
Next.
H80.
The paragraph number 1 is paragraph in the very first paragraph of the writ petition, it has been mentioned that the petitioner intends to ventilate his grievances against the West Bengal Board of Secondary Education by invoking the extraordinary constitutional jurisdiction under Article 226 of the Constitution. Stop. The entire writ petition is regarding allotment of a stall in the Howrah Fish Market by the KMDA. Stop. The West Bengal Board of Secondary Education. Neither the West Bengal Board of Secondary Education, nor the Howrah Improvement Trust, nor the Howrah Municipal Corporation is anyway related to the instant case. Paragraph. It is an admitted fact that the petitioner has not paid rent in respect of stall number 144 allotted in his favor since March 2019. Stop. The initial appointment made in March 2018 clearly mentioned that the stall was allotted on temporary basis for a period of was a temporary basis.
Temporary basis.
And rent was to be paid regularly. Stop. The petitioner paid rent only for
Up
1
to
year
March 19. One
and thereafter stopped paying the same. Stop. The petitioner has not been able to produce any document or law which permits the petitioner to hold on to a stall allotted in his favor without payment of rent. Stop. Submission of the petitioner that no steps have been taken against him for removal cannot come to his aid, as the petitioner does not appear to have approached this court with a bona fide intention with clean hands. Stop. The petitioner does not have any right and or authority to occupy a stall without payment of rent to the authority. Stop. The authority has floated an e-quotation notice. Stop. It will be open for the petitioner to participate in the tender process. Stop. No relief can be granted to the petitioner to permit him to hold on to the stall upon payment of rent. Writ petition fails and is hereby dismissed.
Lordship, only one remark, Lordship, without due process of law, they can.
And next,
Because so far they are noticing.
next
upon
one
that,
is
Lordship, they have taken-
28 is in respect of stall number 145. And 29 is 143.
28 is little different, Lordship, because they have not attempted to pay any area rent. That in item number 27, Lordship, the petitioner attempted to pay after the COVID.
For it,
But in that matter, Lordship, that is not
stall
done by the
number 145. এটা হচ্ছে 28 হচ্ছে stall number 145.
145. Here then they have not attempted to pay any area rent.
আর 27 যেখানে 22 সালেতে টাকা দেওয়ার জন্য দিয়েছিল সেই প্যারাগ্রাফটা ডিলিট হয়ে যাবে। Rest is same.
Same, all are same. Here only
হ্যাঁ ওইটাই 143 বলা হয়েছিল যেখানে ও 22 সালে টাকা জমা দিতে গিয়েছিল সেই প্যারাগ্রাফটা হবে না।
third one is 143, stall number 143. Here same as 27.
Yeah,
প্যারাগ্রাফটা
in
আছে
this
সেটাও হবে
Lordship,
না।
they have mentioned as 144 in their
এখানে
in his letter.
29টা হচ্ছে স্টল নাম্বার 143, ঠিক আছে? আর এখানে দেখছি here also in 22 did you offer rent?
Yes, your Lordship, I offered rent.
Where is it?
In respect
Number 26.
in respect of
stall
different
number 144
different stall.
এখানে স্টল নাম্বার ওখানে বলা হয়েছিল যে 143 নম্বর স্টলে টাকা জমা দিতে গিয়েছিল।
Respect of 28, no tender was made. Only that part.
Next.
Much of that. না রেন্টটা দিতে চাওনি আর কি
Lordship, what? Get first.
For the respondent bank. I pay for the respondent bank, Your Lordship.
You are for the
Respondent bank.
petitioner? Urgent motion, the petitioner is not here. Oh, yes.
This is a very peculiar circumstances under which my lord, the petitioner have come up with, your lordship.
Yes.
Petitioner, my lord, had actually purchased a flat through my lord executing an agreement.
What
for
about the private respondents?
I have served my lord all of them because
They have received it?
yes, my lord. No, private respondent, they are my lord constantly avoiding the process of law. I shall indicate why, my lord, I am saying this. There is a my lord agreement. I shall, my lord, first of all, my lord, indicate the short facts. There is
What is your prayer, you tell me?
Stay of the DM order, Your Lordship. And
Stay of the DM's
because my
order.
lord, the petitioner before your lordship is neither a my lord a borrower nor a guarantor. Certain relevant dates, my lord, kindly have a look and my lord, kindly take note of those.
How are you related to the secured asset?
Because my lord, I have purchased this through a process that has been initiated before a consumer court. I have purchased this property from a promoter. Initially, there was an agreement for sale that has been executed on the basis of a general power of attorney that has been granted by the landlord to the promoters. Thereafter, my lord, I have, my lord, executed agreement for sale. I have paid 90% of the amount of the money.
And the
Then they
private
have-
respondents are the borrowers?
Yes, Your
Yes,
Lordship.
no, they are not. I shall canvass, my lord, how this is, my lord, whatever, my lord, I am getting to see, my lord, that is from the DM order. I have got no other notices, but I shall indicate, my lord, the name of the promoter, my lord, that is appearing in that my agreement for sale. Kindly have a look at, my lord, my agreement for sale. That is at page 20 of your lordship's brief. Your lordship, kindly turn to page 21.
Yes.
Your lordship would get one, see, Devobroto Sarkar, that is constitute, that the fifth line from the top, represented by their constituted attorneys, Sri Devobroto Sarkar, and then, my lord, Sri Pintu Pakira, appearing in the same page.
Yes.
These are two, my lord, appearing to be the person who has represented, my lord, the borrower, sorry, my lord, the landlord, as their constituted attorney, and they are also, my lord, the partner of a development firm. Now, my lord, kindly see the DM notice. That is, my lord, appearing as page 83.
Yes.
The first paragraph of, my lord, the order, 8th August 2024 order, my lord, I am looking at. Seeking administrative assistance for taking financial possession on the secured asset property of the proprietor and guarantor Aradhana Sarkar and Somnath Pakira. So, my lord, here from I get to see that some Aradhana Sarkar and Somnath Pakira was, my lord, the borrower and, my lord, the guarantor. Now, my lord, how they are related with this? Because, my lord, I have got, my lord, only these two persons, Devobroto Sarkar and Pintu Pakira, who has, my lord, represented themselves as, my lord, the constituted attorney of the landlord. Now, my lord, certain dates are relevant. Kindly take a note of the date 29th November 2011. That is the date when, my lord, I have, my lord, executed this agreement for sale. Thereafter, my lord, consumer, I had to, my lord, approach to the consumer forum to have, my lord, my sale deed executed. Consumer forum, my lord, on 17th of March 2020, my lord, have passed an order in my favor indicating that the sale deed should be registered in my favor. But, my lord, they have, this promoter, my lord, was made a party before the forum. They have, my lord, constantly, my lord, ignored, my lord, didn't appear before the consumer forum. They have, my lord, avoided the process of law. Then, my lord, I had to put, my lord, the award into execution. By the process of execution, by the order of the consumer court, my lord, my sale deed got registered.
Nothing, whether the fact of the loan
Yes, Your Lordship.
was reflected in the Sarsai portal.
Yes, Your Lordship, it is there with me. I have, my lord, the mortgage was created way back in 2012, Your Lordship, and the Shankar Enterprise, my lord, is the borrower before the bank, Your Lordship. The bank has got no connection with the writ petitioner.
Petitioner.
my lord, what the developer has done, whether the developer has sold the property to them or not, my lord, that is not the question that the bank is concerned about. My lord, by a registered deed of sale, which was mortgaged with the bank, my lord, the credit facility was, the loan was disbursed. My lord, bank has taken proceedings under the SURFACE Act. My lord, 13(4) notice was also served upon the relevant address, my lord, back in the year of 2022. No challenge preferred, your lordship, till date. My lord, now today is the day of the possession, your lordship. The bank is at the place, my lord, taking the possession. My lord, it is reflected in the SARSAI portal. I have a copy. If your lordship,
When was it
lordship
put up in
2000,
the portal?
lordship 2012, my lord, is the date of creation of mortgage.
And was it there in the portal since 2012?
Yes, your lordship. Lordship, it is there. And my lord, in 2011, the petitioner is saying that the petitioner has purchased the property. The sale deed was not registered at that point of time.
He had to approach the
He
consumer
had to approach the
forum.
consumer forum, and the bank was not a party there. Bank is
How
not
do we
aware.
know? The
Lordship,
petitioner is no way aware of the proceeding.
lordship. Neither the bank knows,
Well,
your
that was
lordship.
my lord
The
only
bank is
registered with the
proceeding as per the law.
Promoter. So, my lord, the most important part is that the loan was sanctioned, as I am getting it from my lord, the DM order on 2012. And my lord, my agreement for sale, that was my lord executed in the year 2011, prior to that. So my lord, after my lord, my agreement for sale being executed.
Listen, agreement for sale does not always materialize to
I understand,
conveyance.
I understand, madam.
Right. In the meantime, the loan was taken and this has happened.
This
What
is
can
possibly
the
my lord a foul play that has been my
And
lord
my lord,
played
this
by
is
my
the
lord the
registered
promoter.
deed of sale, my lord, which was
Upon
mortgaged with the
executing
bank.
an agreement for sale with me, my lord have taken 90% of the amount from me. Then my lord, in the back of the petitioner, my lord have transferred the property to a
You
third
are
party.
not in possession.
I am in possession by virtue of my lord, the order of the consumer court, because my lord sale deed has been my lord executed in my favor by the order of the court. And therein, my lord,
My
I
lord,
have
in that
also made
case,
my
so
lord the
then they
promoter
ought
a
to
party.
have received, my lord, the possession notice, my lord, because that was served in the year of 2022 after the order was passed. My lord, they ought to have challenged it.
Which possession notice?
My lord, the possession notice that was affixed at the conspicuous place of that building, where the petitioner is claiming
Symbolic
to
possession.
yes, your lordship. They ought to have challenged this. No challenge thrown.
I was not aware of this. The only document, my lord, which I am coming across of,
My lord,
that
today
is of
possession is going on, and I am
page-
instructed, my lord, to
page
the verge of the
86.
completion.
page 86, my lord, that is notice dated 4th of August 2025. That is the date, my lord, wherein, my lord, I am my lord, being apprehended. And my lord, your lordship kindly take page 86, wherein, my lord, this foul play would canvas. Kindly see, my lord, in that
No, foul play, even if there is any, there has to be a remedy.
Yes.
And there has to be a
No, my lord,
forum
kindly
where you
ensure,
can
my
go
lord,
and challenge it.
this is my lord apparent on the face of the document, my lord, which I am, my lord, placing before your lordship, my lord, that these two persons, if your lordship kindly take the trouble to come into page 86.
My lord,
Yes,
one
we
more thing
received
I'd like
page
to
86,
indicate,
my
my
lord,
lord, today an
property one.
essay is pending by the borrower. Essay has been filed by the borrower along with an interim application. It is listed to them, my lord, as item number 3.
What is happening over there?
That's what you find it. My lord,
For the tribunal,
kindly
my
turn
lord.
to page 86. Your lordship would get property one. That is the descriptions of the name of the owner. Property one owned by Srimati Aradhana Sarkar. And property two, see Somnath Pakira. There is, my lord, the nexus. This Aradhana Sarkar happened to be, my lord, the wife of the Debabrata Sarkar, who was a party to my agreement for sale. And this Somnath Pakira, kindly take note of his father name, Ananda Kumar Pakira. Now, my lord, kindly turn to my lord agreement.
Brother
for-
of Pintu Bakira.
Yes. So there must be, my lord, a sale deed that has been executed by, my lord, this constituted attorney in favor of these persons. And that deed must have been deposited with the bank, which, my lord, petitioner is absolutely not aware of. In one hand, my lord, they have taken money from the petitioner. Then, my lord, they have not taken any endeavor to, my lord, get the sale deed executed. I had to rush to the, my lord, the consumer court. Then, my lord, by order of the consumer court, my lord, my sale deed got executed. Now, my lord, they are enjoying the amount.
What is the property? Is it a flat?
It is a flat.
Yes, your lordship. Lordship, there are two parts, plot A and plot B. My lord, both are mortgaged with the bank. My lord, I'm carrying the sale deed, which is mortgaged with the bank also.
No, the page 86 mentions the schedule of the property, and you are holding which property?
Property two.
Property 2 they are holding.
Third floor flat.
Yes.
690 square feet.
Possibly, my lord, the number of the flat is wrongly written. That should be flat B. In
Plot B.
both has been written as flat A. It should be flat B. property 2,
Western side,
western side. Right? Western side.
plot B, flat B.
It should be flat B because it would be clear.
If it should be flat B, then I will say that you cannot go and take possession of flat B because your document says
Yes,
flat A.
yes.
If the property is not properly described in the schedule, you cannot go and take
Lordship, we have
possession.
both the deed mortgage and we have obtained order in respect of both.
Flat A or B?
Flat A and flat B both.
Where is flat B mentioned over here? If the schedule is incorrect, you cannot go and take possession.
Lordship, I'll just place the DM order once.
The DM's order mentions flat B.
Yes, Your Lordship. It was, yes, Your Lordship. This page number 83.
83
Second last
is
paragraph,
flat B.
two flats were there. Flat A and flat B. Both are mortgaged with the bank.
DM's order is all right, but your communication is incorrect.
Yes.
How can you take possession? Flat B, you cannot take possession of flat B by issuing notice in respect of flat A.
My lord, I think this is a technical mistake because, Your Lordship, there are two properties mentioned, property 1 and property 2, just happen to be, my lord, flat A and flat A. If Your Lordship sees, it's property 1 and property 2.
can
Two
see that.
properties cannot be the same, Your Lordship. It had to be flat B.
So this is a typographical
Because,
error.
Your Lordship, it is mentioned that one is on the eastern side and other is on the western side.
All
So we have
said and done, flat A is not there in the western side. You cannot go and take possession of flat A.
My lord,
No.
flat B. My lord, it had to be flat B.
Whatever, you make your
Yes, Lord.
corrections.
Lordship, my lord,
The
pass
matter-
any order. Lordship, kindly consider, my lord. The
The
TM order is a never challenged before any court of law, my lord.
yes.
My lord, the 13-4 notice, my lord, we have
Provided
prescribed
he
the
gets to know.
I mean, difficulty. The bank also is not aware of the fact.
Yes.
I mean, now, my lord, very kindly consider this fact, my lord. If maybe, my lord, there is typographical mistake in the order, but this notice, my lord, but in the my lord, possession notice, there is no mistake.
The petitioner is aggrieved by the notice issued by the Punjab National Bank on 4th August 2025 for taking physical possession of a property described as residential flat A within bracket western side on the 3rd floor of a G+3 storied building named Uma Apartment at Mohashtala, situated under the Mohashtala municipality. Stop paragraph. The said vacation notice was issued in compliance of the, not compliance, in furtherance of the order passed by the district magistrate on 8th August 2024 under section 14 of the SURFACE Act 2002. Stop. Next. It appears that in the proceeding under section 14 of the Act, the property in question has been described as flat B within bracket western side. Whereas in the vacation notice, the property has been described as residential flat number A within bracket western side. Stop. The bank cannot proceed to take possession of a property which is a property which is inconsistently mentioned in the vacation notice. Incorrectly mentioned in the vacation notice. Stop paragraph. Learned advocate for the petitioner. Petitioners stresses on the fact that the petitioner was never made aware of the proceeding under the SURFACE Act in respect of the subject property. Stop. An agreement for sale was executed in the year 2011 And as the sale deed was not registered, the petitioner had to approach the consumer forum for obtaining necessary order. Stop. It was only after order was passed by the consumer forum that the property got registered in the year 2022. Stop. The petitioner is no way connected with the loan. Stop. Next. Prayer has been made to restrain the bank from taking possession of the property. Stop. It has been submitted that as on date, the bank is executing the order passed by the district magistrate on 8th August 2024 under section 14 of the Act. Paragraph, learned advocate representing the bank admits that the petitioner is no way connected with the loan. Stop. It has been submitted that loan was obtained in the year 2012 and thereafter proceeding was initiated for recovery of the loan amount as the borrower failed to pay off the same. Paragraph. It has been submitted that the petitioner did not challenge the order of the district magistrate passed under section 14 of the Act. Stop. Today, when the bank is taking steps for taking physical possession of the property, the instant writ petition has been filed. Stop. It has been submitted that the existence of the loan amount in respect of the property was mentioned in the portal of the Central Registry of Securitization Asset, Reconstruction and Security Interest of India.
One more thing, may I just point out, Malad?
1 minute, 1 minute.
Yes.
See, the Sarsai portal document which has been placed.
Yes.
Where is flat number B mentioned? I can see flat number A. Where is flat number B? Flat number B2 is there. There is no flat number B. So there is a confusion with regard to the property. And flat number B is described of having 700 square feet.
Yes.
Here the petitioner has 600.
The description may be differ, Malad, whoever going to take possession of a property, Malad, which is as per the district magistrate order. What they have purchased, Malad, the schedule may differ, Malad. It's my submission. Malad, and one more thing, Malad, may I just pointed out, Lordship kindly turn to page 60. It's 80. Malad, the notice has been addressed to the borrower, not to them. So, Malad, there is a connivance. Of course, kindly consider. They came to the notice on the 4/8/2025.
How did they came to notice?
Yes, kindly consider them at page 86.
Yes.
86 though. 86. The notice has been addressed, Malad. It's not a mandatory notice, Malad. As per the order passed by the Malad, it's passed by the Malad, the tribunal. Malad, we have sent a notice to the borrower. They are aware of the notice on 4/8/2025. On the date, Malad, we are executing the Malad order. They are before your Lordship.
Has been affixed on
They
the door
could
of
have,
my
essay is pending, they could have filed an application by raising this
This
objection.
has been affixed on
Well,
the
all
door
the
of my
disputed
flat.
questions are involved over here.
Property was then sent in the portal of the central registration of securities and security interest of it.
On a perusal of the document placed before the court by the learned advocate representing the bank with regard to the disclosure of the loan in the portal, it appears that flat number B occupied by the petitioner is not mentioned therein.
I'm grateful, madam.
Stop. Paragraph. Learned advocate for the bank submits that there is connivance between the borrower and the petitioner. Stop. The petitioner was aware of the notice on 4th August 2025 when it was issued in favor of the borrowers. Stop. The petitioner chose to approach this court only on the day physical possession was sought to be taken. Paragraph. Upon hearing the submission made on behalf of both the parties, it appears that, admittedly, the petitioner is no way connected with the loan amount, with the loan. Stop. The petitioner has shown before this court. Now, the petitioner has annexed to the writ petition document to show the agreement for sale, which was executed in November 2011 prior to the creation of the loan. Stop. The petitioner had to rush to the consumer forum for registration of the deed of conveyance as the vendors were not taking steps for execution of the deed in favor of the petitioner. Stop. Order was obtained by the petitioner, and only thereafter the property stood registered in the name of the petitioner. Stop. The petitioner was never made aware from any of the parties whatsoever with regard to the existence of the loan or the fact of mortgage of the subject property to the bank. Stop. The bank proceeded under the SURFACE Act to obtain order under section 14 of the Act for taking physical possession. Stop. At that stage also, the petitioner was not communicated. Stop. The notice of vacation dated 4th August 2025 as claimed by the petitioner, 2025, as claimed by the petitioner, was affixed on the outer wall of the petitioner's flat. When was it affixed?
7th of August, I think.
7th is the date of the notice.
Date of the notice is 4th August.
Fourth
It was
August.
On 7th August.
Yes.
690 square feet, which is the
And it is only thereafter that the instant writ petition has been prepared and filed on 18th August 2025. Stop. Paragraph. It has been brought to the notice of the court that an application under the Securitization Act is pending consideration before the Debts Recovery Tribunal at the instance of the borrower. Stop. The
Number 3.
And the said matter is appearing in the list of the tribunal today for consideration. Stop. Paragraph. As the petitioner has been able to show at least some document in support of his submission that the petitioner is in possession of the property which was purchased by her upon payment of valuable consideration, and the petitioner had to approach a judicial forum for getting the sale deed executed in her favor. Accordingly, the court grants liberty to the petitioner to approach the Debts Recovery Tribunal for further relief. Stop. The bank is restrained from taking any coercive step against the petitioner till 26th of September 2025 or until further order, whichever is now, or until take it in till 26th September. Stop. The 2025, provided the petitioner approaches the tribunal by 29th of August 2025. It will be open for the petitioner to pray for appropriate interim order for her protection before the tribunal. The writ petition stands disposed of. Affidavit of service is taken.
I'm
up
getting
before.
no. The tribunal may consider the fact and circumstances without influence of this order. Otherwise, they will place the same because without affidavit it has been decided.
Nothing has been decided. I have just simply
Kindly
referred it by
regular line tribunal will
minimum
decided
protection.
as per the record and evidence. Kindly record a line.
It will be open for the tribunal to decide the
That will go.
prayer of the petitioner on merits without being influenced by any observation passed herein above.
I'm grateful, man. I'm grateful, man.
My application.
Lord, I beg to appear.
I'm appealing for the respondent court.
My Lord, I appear for the Union of India. I have now been instructed, just now been instructed to appear, my Lord, about half an hour through mail.
You do not have a copy of the writ
I do not
petition?
have because just within half an hour before I was given a mail.
Anyway, let me do. You are for the port.
You are for
I'm
the
for
port.
the port.
My Lord, I am for the
MSTC, who is going to represent?
Port
I am
is
for the
answering
Union of
respondent,
India.
Port.
Port, yes.
All right,
Nobody
yes.
else. My reliefs are against the port. Well, the issue is very short. I might be able to make it shorter. Look, this is about Howrah Mills. The disputes have arisen with regard to whether I'm a tenant, whether the Public Premises Eviction of Unauthorized Occupants Act apply. All that is separate. There's an order of eviction under the Public Premises Eviction of Unauthorized Occupants Act that has been passed against me. Well, Howrah Mills was occupying a very large portion of land, all into several different plot numbers. So there's an order of eviction in respect, separate orders of eviction in respect of separate plot numbers. One such plot number is under the statutory appeal is pending, and that particular plot number supposedly is now the subject matter of a tender. This tender is assailed before your lordship in this writ petition. Port is now, after an enormous amount of time, seeking to go ahead and invite the general public to now get into this plot by way of a lease upon payment of certain rental. My prayer is only one, and in fact my ground of challenge is only one. Well, the plot that is the subject matter of this particular tender is actually wider than the plot which is the subject matter of my order of eviction. In respect of other plots, I already have an order of stay. Now what they're doing, and if I may use the term, Port very smartly changes the plot number. So what the two plots is H247, H by 285, and there's one of H by 284. Both are mine. I'll just show these two discrepancies. One thing I'll indicate, my statutory appeal is pending.
In respect of that plot also?
In respect of that plot only, which now they are saying they're going to enter into this through this process of tender. This is scheduled to come up on the 22nd of August. Right? 22nd of August. Today we are on the 20th. Insofar as we've been able to understand that the port will be able to clarify, today was the last date for receiving these bids. Most likely it's been extended till 1st of September, that they'll be in a better position to indicate. This is the information that we have. My only prayer, my lord, if they don't oppose, is your lordship will direct my statutory appeal to be heard out as expeditiously as possible. Until then, port will not create any third-party rights.
Please show me the order of eviction.
Yes, my lord. Then I'll show this two things, my lord, where they've gone wrong, and in the tender. Lord, kindly have a look at page 40. I'm just showing the gist of the order to be able to just show to your lordship what the schedule was. Lord, the merits I'm not troubling your lordship with. Page 41, kindly have a look at. Schedule, plot number, HL or plate number, whichever. HL 285. The piece and parcel of land measuring 1243.04 square meters, thereabouts, situated. No, the rest will also be important. It is bounded on the north by the trustees' open land, then trustees' land occupied by so and so on the south by Southern Spur, on the east by trustees' land occupied by Howrah Mills, on the west foreshore trustees' land Shamapur Port. So the plot is HL 285 1243.04 square meters. Now your lordship will just have a look at. Lord, please have a look. The tender. Well, it's kindly come to 90. It starts at 90 and 90. Here, well, the plot is described differently. Kindly turns over to 93.
1 minute. Page 90 is plot number 94 by 25A.
94 by 25A. But they've changed the plot number. But this is my plot. Because this entire plot is mine. From the map, I'll be able to show to your lordship. But kindly have a look at 93 once. And see the area that is now. So your lordship has seen that eviction order is in respect for 1243.04. Please have a look at the area that is the subject matter of the tender. At page 93.
Yes. 94 by 25 is the plot number.
And 1293 square meters. At the fourth column, serial number 4.
There may be several plots with the same square meter measurement.
Now turns over, my lord. I'll show you your lordship. 142 is a part of the tender. Well, this is a way to obviate the stay and to give out more than what they can do. Kindly have a look at 142.
Yes.
Well, your lordship had noticed from that schedule that the east side property is mine. Page 142, kindly have a look. The plot is identified. This is also my plot. The one immediately under that.
No, on the east by the trustees' land occupied by Howrah Mills. Land is
142. But the lordship will not go by that schedule. I am going by the map, part of the tender.
142.
142.
Yes.
The plot that they're now trying to sell off is delineated in the middle. There's a, your lordship will find the name of Howrah Mills Company Limited.
Howrah
in
Mills
the center.
have got several
Just
plots.
above that, there's a delineation like a small box.
Right.
That is the box that is being now sold.
All right.
Immediately under this is Howrah Mills.
All right.
So if it is 1243, if it is 1243, then 1293 they've come into my plot. Because this entire thing is Howrah Mills.
I didn't get it.
Well, my plot, the piece and parcel of land is 101,243. Yes, this your lordship will find is bounded on the north by trustees open land.
Right.
If your lordship compares it to 142, it will come.
Yes.
Then
page
bounded
1.
on north, then trustees land occupied by Surajmal Bajnath on the south.
Page
Kindly
142. First show me which is the north.
That is true. Foreshore Road. Well, if I just compare it.
And on the west by Foreshore Road.
West is
So
Foreshore Road.
On the west is Foreshore Road.
Then-
My property, 41.
Then it should go this way. If west comes to
West by Foreshore Road. If your lordship looks at 41, west by Foreshore
41
Road.
compared with 42, 142.
142, yes. So
Right.
west by Foreshore Road. Foreshore Road is
North
identified
by
on
the
142.
trustees open
So
land.
this property is west is Foreshore Road. East is Howrah Mills. Southern is Surajmal. and right is open land of trustees. That's the north. So what they do is they get an eviction order 1243 and one more document will not be brought on record by way of a supplementary affidavit. Allows us to just bring on records, it will clarify. Well, there are adjacent plots of which we were in possession. This is 285. In respect of 284, there is a stay, which is immediately under this. Kindly have a look at the supplement. Key question. Eta key.
Supplementary.
Well, kindly have a look at the supplementary affidavit once. আমারটা এত বড় জচ্ছা বেটা তো এই করে কেন কি তুলে দিলি ওটাই তো If your lordship looks at page 14 once,
of the supplementary.
I know something else has been.
Supplementary has 5 pages. Where can I go to page 14? It has only 5 pages.
Supplementary affidavit. Lord, may I just hand over my copy, my lord? Supplementary affidavit document.
Tell me, your contention is page 41 is the schedule which you are occupying.
Yes.
And page 140 is the property that is being put up in auction.
Yes.
And
my occupation was from schedule. I am going by the respondent's document. Page 41, the plot is 1243.
Yes.
It clearly says that on the south, I'm sorry, I said it. On the west, it is by Foreshore Road. And on the east, it is Howrah Mills. So 1243, then anything on the east is Howrah Mills by their own map.
Alright.
So when it becomes 1293, which is the subject matter of the tender, then that extra 50 comes within my plot, which also they are now giving a tender of.
But then you claim only 1243. So why?
No, all that is mine. This entire, I'm going by his map. 142, they're identifying this, the rest of it is Howrah Mills. This is their map in the tender.
Maybe there are several plots which Howrah Mills own or not own, leased in your favor.
This is the plot. This is the stretch. 142 is their document. I'm going just by the tender document. Kindly looks at it once more. I understand.
Yes,
At least for me, it took some time.
142.
I am
Get Howrah Mills.
Yes, I am simpliciter going by this block.
A portion of it is being put up in auction.
Yes. Now the rest of it, disregards this portion. This entire block is Howrah Mills.
Right.
A portion of it is now being sold by a tender. Lease is being invited. This is separate. The eviction that they get is 1243, which they say rest is belonging to Howrah Mills because they say rest is butted by Howrah Mills. Now tender plot is 1293. So which they have no order, they can't go and sell.
My lord, may I have to cut short the matter? My learned friend showing.
Will you really cut it short or you?
Cut short. What happened? This 142.
142.
This area I am saying his land is two land 284 and 285.
Yes.
I have inducted them.
Yes.
They did not pay the rent. Eviction proceeding there. They have filed 2 appeal. 1 appeal there is an injunction order that is 284. I am not touching that.
All right.
So for the 285 is concerned, that I have put in
up in
tender.
auction.
And that is while a petition is there, some area has been increased, not his land. My petition, my road is there. I have not encroached his land. Record that I have not taken any land from here. 284. Number 1. Number 2, my lord, 33 crores is due in respect of this property. And I will show they approach before the before the appeal court. Appeal court that has been that no order has been passed.
No, that is
Twice.
pending.
That is
pending.
No, this tender they have filed an application. Kindly see. Page 245.
I'll indicate that. That is not
287.
But now you lordship.
Now we are in lead petition.
Now you
No order
lordship
has
understand.
filed in the appeal court. Now here comes
Why
to
is
the
he
writ.
getting so
Appeal court.
aggressive?
Section 9.
In that
Section 9.
section 9,
Section 9 appeal
we
before
filed
the-
an application, my lord, under 151 for stay of the tender till my appeal stay was heard. That was refused on the ground that the stay
Now
has been
here-
pending. No, naturally, because I'm assailing the tender itself. That was only to stay the
20%
tender till
already
my appeal was
participated
being
in the
heard.
tender, my lord. 20% approximately.
Maybe
Now,
All right, do not create any third party interest till he gets his appeal heard.
that's all.
No, my lord. Only this portion only, 284. Kindly record that. HL 284. No, I will not create any, put in the tender.
285 also my appeal is pending.
285 I have put in the tender. How can
285 it's fixed on
My lord,
22nd
they have
of April.
three
Lord, in case I
crores
succeed.
They,
Statutory
my lord,
appeal
you
is
kindly
there.
appreciate. They did not pay. They parted with position. Eviction notice was there.
Lord,
let me
His
finish.
appeal is pending.
Yes, it's
Appeal is
pending
so,
there.
so long. I will not. I
No,
will
no, it's
stop.
fixed on
22nd
22nd.
of
No, my lord.
today's
Since long
20th.
it is appeal is pending.
What is my
They
learned
filed
friend saying?
an
Out of that,
application recently. One application for stay was filed, that was rejected. When I put in the tender, he filed an application for stay of the. That was also rejected. When the tender was issued, he filed an application. Now appeal is pending.
He will take steps to protect his
Whatever
property.
may be, my lord, you will
all right.
cannot put the tender cannot be my lord, stalled.
No one is stalling
the
it.
court what is going
He
to be
is
done.
the court is not stalling it, but then his prayer is only to adjourn or not to create any third party interest till his appeal is disposed
My
of.
tender will be stopped.
I have one.
My tender will stop. My tender will stop.
Yes, if you have gone beyond the
20%
schedule,
already participated in the tender.
Wait.
Lord,
Yes.
only one
My lord,
request, Lord. Your Lordship will
Well, he
direct-
will not. 3 crores is due, my due, in
Yes,
respect of the
This
land.
act doesn't apply to me.
Nothing
You all
will
know
pay
it
to
very
them.
well.
Yes.
They will not take step in the appeal.
Wait. Yes, please. Wait, yes.
Kindly direct, it's fixed on 22nd of August, the order is at page 145. Kindly direct him to finish it by 1st September or 2nd September within a week. Because kindly have a look at page
When
145.
was the appeal filed?
The appeal was filed in 22.
225.
And then we have to come.
3 years the appeal is pending.
Yes, my lord, which is why I am. Oh, sir, একটা minute, কেন রেগে যাচ্ছে না তো?
Assuming that the appeal goes in his favor.
That's the
then
only.
what is going to happen?
Appeal is going into in his favor. The property may be restored. That is my responsibility. That is
can
my
you
responsibility.
how
My
can
lord,
you restore
supposing the
property in that way?
22 appeal is filed. We are in 2025.
How much is due from him in respect of
crores.
this?
Act itself doesn't apply.
I
Because I'll
have
tell
a
you, let him, let him not shout. Well, I'll tell you.
Show your bona fide, at least pay something.
3 crores.
So
I'll
that
tell you
they-
why. This
3
3
crores,
crores, they
24
have-
lakhs.
This
3
3
crores
crores
that
has never been accepted. I don't know
3
what
crores,
he's come up with.
3,
The
4.
act itself
My
does not
module,
apply.
my module payment.
Well, your lordship is
Which act?
the Public Premises Eviction of Unauthorized Occupants Act. I'll
No,
tell you
but
lordship
then
why.
there,
Because
are
the
you paying
property.
me rent or not?
No, Manoj, I'll tell you, Manoj, they have gone ahead and taken
No,
possession.
last 10 years,
Manoj,
nothing has been paid.
Manoj, I can't deal with this aggression.
I have followed. Tell me, are
I'll
you
tell you,
paying anything
No,
or
Manoj,
not?
I don't know what chart is handed over. They go and take possession under the Public Premises Act, Manoj, which is because of the paramount judgment. My
I
status.
take it, assuming I take it that the act is not maintainable, you are required to pay something. You cannot hold the land for free.
The land, no, it doesn't become a monthly rent. I'll tell you, lordship, why? Because from 1800s, this land belongs to Howrah Mills. Then there is an acquisition that happens. Under the acquisition, Kolkata Port Trust comes in. So because of that, he's completely aware of the law. Your lordships have held, but because it precedes the act, and my relationship precedes the.
What will be do you claim to be the owner of the property? You don't. That means you are to pay some amount of rent. If the port trust is there, there is schedule of rate is there.
I have a long-term lease in the nature of Morari Mokrashi. These are the 1800 ones. Then, which is why they also don't, they kindly direct the appeal to be heard. They've extended till the 1st of September. This act cannot apply. There are 2 judgments of the Supreme Court. It squarely covers Kailashnath.
Does
not
it
Kailashnath,
say that you are to hold the land free of cost?
As a long-term lessee. Or
Long-term lessee, what will
premium
be the
for which
premium?
I paid that.
When did you pay?
When I got the lease for 99 years, na?
Last 10 years they have not paid. Last year, I am my instruction. Last 10 years, nothing has been paid.
I'm out of possession.
Is it only one-time payment when you take leave?
That is no. I'll have to check that.
Monthly.
I'll have to check that.
One-time
What
premium is
one
different
time
issue.
or how much
That is
time? I'll have to
something.
check
That is something
Because my
different.
only
Their
thing is,
conduct kindly, Lord.
No,
Can
man,
appreciate their conduct.
he can't wriggle
Appeal filed
something out.
2022.
No, Manoj, that he has not filed an
Now auction
application.
is there.
Manoj,
This
this
don't
kind
take
of
steps.
Manoj, kindly directs the appeal to be heard out. Let them. They've also waited for 3 years.
3.25
He can't get
crores is
something
due.
out. He's not made an application before the city court asking for payment to be made. They've not taken any steps for payment. And
And
he can't accept it also, they're bound by the stamp,
The
the SOR rates. He has to
petitioner-
accept it according
Yes,
to
yes,
that.
I
It's not
saw.
enough to come and tell the court, make the payment.
petitioner
Section 48 stares at his face.
claims to be in occupation of plate number HL/285, measuring about 1243.04 square meters, situated at Ramkrishnapur. Set out the whole thing. Page 41. ঠিক আছে? Steps were taken by the estate officer Shama Prasad Mukherjee Port, Kolkata, for evicting the petitioner under the provisions of the public premises bracket open eviction of unauthorized occupants bracket close Act 1971, and an order was passed. Where is the order? Order of the estate officer, page
Yes, it's 22nd June.
page
22nd June 2022.
page
But you will find it at page 40.
Yes.
page 40.
22nd, 21 June 2022
Oh.
and 7 July 22. There is a correction. Thereafter 7 July it was corrected.
21st
regard to
June
the PS.
2022. Stop. The petitioner preferred a statutory appeal, and the same is pending consideration before the learned additional district and session judge, fast track, third court, Howrah.
Stay application was filed. Subsequently, another stay application.
The petitioner is presently aggrieved by the steps taken by the Port Authority to put up a portion of the subject property on auction. Stop. Next. The auction notice mentions about a plot being number 94/25 within bracket cap say.
Or may I interrupt? That there is no plot 94/95. That is a tender number plot.
No.
Plot. There is no plot.
In
94.
page 90 mentions being plot number,
Tender
allotment
number,
of
say
land
tender
being plot number such and such.
Page 90
Tender number.
mentions that.
90. Tender number plan.
No.
The plot number 93.
Plot number.
Port will also come and scream and shout, and then plot number and then 94/25. Plot number.
And what is this? 94.
This is plot tender number.
No, but whatever the officer is written,
Maybe
93
not a
also
plot
says that.
number. My instruction 90/25 is not a plot number.
I was trying to find out where is this 285, the one that
285
is
is
at
the big, 285 is smaller one, my lord. They indicated there.
Well, let them say that 284 they're not selling.
Yes. 284 is not selling. Not selling. You record
285
Not
also.
selling.
285 is mine.
No, 285.
there is nothing with relation to 284. It is the writ petition with about 285.
285. So they let them say that plot. This is not 285.
My lord, I am concerned that the tender is 285. I repeat. I am not
285.
concerned.
Then how does
I am not concerned with the 284.
No, 284, nobody is concerned.
But
Just
I am concerned with
285.
285. Smaller one.
Smaller
Smaller one.
Yes, 285 is 1243. And you go and sell 1293.
That is my land. If
No,
it
this is not your
extended-
land. Don't say that.
No, this is not the. No, this is-
Absolute. Don't scream
I-
unnecessary.
You are a tenant. I admit
No,
it,
I'm
you
not
are
your
saying you are
tenant.
The plot being number 94.
Capital A.
Positionটা was.
তারপর হচ্ছে though the learned advocate for the Port Authority submits that the number mentioned in the notice inviting tender, the plot number mentioned in the notice inviting tender is not the plot is not the number of the plot. The same is merely the
Tender number.
tender number of the plot.
Right, so-
Stop.
Wow,
The
data go-
plot number is actually 285. And this will be plot or plate?
Plate, PLAT.
Actually,
plate.
it will be plate.
And here is the plot. 90 is mentioned plot. And here is the
Yes.
plate. Actually is the plate number.
So this,
Plate number.
Plate, always plate. Plate, to the- Always
what
plate.
is happening? So the plot tender
No, no.
doesn't mention
No, no, no.
anything. There's no plate, no.
How can you relate page 90 to page 41? How will
Yes.
one
141. 141.
141? Where is this mentioned
No,
number?
number 90.
285?
My plot will be auctioned without any particulars, higher figures.
Where is this 285 mentioned in page 142? The map is there. Where from can you relate that you are putting up a particular plot in auction?
Yes, for a particular plot in auction is the demarcated.
Where?
That is my 142.
Where is, I cannot see the figure.
A figure.
285, where is it mentioned?
285 is a figure.
The entire tender document doesn't mention 285.
No, it's a vacant plot. We have not indicated plate number mentioned in respect of his case number.
That is separate.
But I have indicated that what I intend to put in auction, that is the demarcated portion. Demarcated portion.
Which portion? Mullah, there are
The demarcated portion is there.
So this is so now he falls for that folly.
That is a vacant
Now,
plot.
moment
That
he
is a
becomes
vacant plot.
demarcated, it's not a. Please don't say all this. You're a port trust.
Wait,
No,
please
He
wait.
comes on.
Please wait. Page 90 is the notice inviting tender.
Yes.
When you put something up for tender, there must be some specification of the place or article or whatever you put up for tender.
Yes,
The
Malay.
schedule
Area
of
page
tender.
93 is mentioned. Page 93 area
yes.
is mentioned.
Yes, please show.
No? Area is mentioned.
Plot detail page 6.
Area is mentioned.
Plot.
1293.
Same
Take-
mentioned
No, no,
plot number.
column 2 A. Plot number 9425A. Your Lordship can see.
No, no,
Page-
my lord, may I
No, no,
just
put the
indicate one
number.
thing now?
No, let-
Please have a look at
Lordship
page
can see,
92.
see, here, 94,
He
93,
screamed
here.
enough. Please
Your
have a look
Lordship
at page
can see.
92.
Now he has here. 93.
Serial number 2, plot
Lordship can
details.
see 93.
Turns over
Page
to
93.
93.
Lordship can
It's
see page 93.
Please
Page
don't.
93. Lordship can see page 93.
Yes, 93. I'm also
Left,
showing.
left side.
94 by 25.
94 by 28.
That's plot details.
The disputed question. That is
Tender number.
that is tender number. Now the
What is
area.
the tender number?
But let me finish. The area is
Mentioned it as a plot number,
area
sir.
is there, my lord. Area is there. 1293.
Which is area?
That column.
Listen. Port Trust has got huge chunks of land. 1293. Where is this 1293?
1293 indicated in the sketch plan. That is here demarcated vacant land. Here is the
Vacant may be so many lands.
no. Here is the vacant.
Where is
No,
this?
demarcated is there.
That is into Howrah Mills land.
No, Howrah Mill is
142. It's
Howrah Mill
clear.
is not demarcated. Howrah Mill is not demarcated. Lordship can 142.
You
No.
have demarcated
A
this.
dark portion. Your Lordship a dark portion.
Well, the tender has been.
You are
No,
simply,
no, madam, in
it
that
appears.
all the 20 bidders, they are so foolish. They have participated in the tender.
Well, this
All
was
the 20 bidders.
This was to.
Whether somebody is foolish or clever, let us not go into this.
I am
Just
foolish.
show me. Let us understand. Suppose your officer is not there behind you.
No, just now I received the brief. Half an hour.
I understand. You and I are third persons, nowhere related to this tender, right? Now tell me, how will somebody understand that this is exactly the place or the plot
Very well,
that
madam,
you
coming
put up
to
for
what-
auction?
This is ঠিক আছে আমি ভালো করে বুঝিয়ে দেবো কালকে tomorrow I will come with the details. Okay. If your lordship so desire, I will explain this.
It's not a matter of desiring.
matter of- this
Thing
is
is,
my lord,
your
my
tender
only
should be
My
specific.
simple contention is this 285 and 284.
Where is this
No, I'm saying
285 and
this is-
284
this
reflected in
this-
page
this is
142?
This is the 284.
Where is it
No,
written?
I am not tendering 284. I have
Show
tendered
me
vacant
it
land.
is written. Show me it is
My lord,
written.
Supposing, my lord, this is a 284 is a land.
Supposing it's your tender, it's your
The
sketch.
new intending bidder came to learn this is a plate number such
No,
and
no,
such.
after all, this is my
This is my
plot
vacant.
that you're giving away to someone. I'm
He is
entitled to
plot.
know.
How is
How he is.
Somebody
I
will
have inducted him as a
Let's say
tenant.
he has an eviction
Admittedly,
decree
he
against a
didn't
tenant.
pay.
He's selling the
Eviction
tenant's
order has been
property. He's
passed.
not identified. Tenant has an appeal pending from the decree.
Appeal
He's
is
selling.
pending years together. I cannot take
Sir,
any
we've
step.
all grown up from those points of
steps.
prejudice.
Take steps. Nobody is standing in your way.
When
The
your lordship,
thing is,
I have to
why
satisfy.
will your tender document not clearly specify that this is the land which is being put up for auction?
Clearly না বলছে এটা নাম্বারটা কত কত
Actually, আমরা vacant plot tender এই plate number দিই না।
my instruction is
Yes, had this instruction not been there, how could you identify that this is the plot that
identify
you
will be
are?
I block
Instruction নেই।
deep color block identified
This is
land.
why
Where is it mentioned that it is a deep colored block that is being put up in auction?
My lordship, can you see the left side coordinates 22 such and such.
কোথায় কার left?
My left side. Where is your lordship?
কার left?
Land Foreshore Road
That is longitude.
longitude. এই যে
Longitude had been mentioned.
mention.
So it is
Where?
Most
Where?
specified.
Which portion?
Page 93,
Page
second
9
column, left side.
Page
last.
93.
Longitude has been mentioned.
Yes.
Longitude.
Yes.
22.
Yeah.
Identify the plot.
The coordinates. Coordinates. It's a specified.
Coordinates, only certain figures are mentioned. What
Yes.
does these figures
Coordinate
indicate?
is of this portion, my lord.
How?
My lord, one thing, my lord. If a longitude and latitude is proven, my lord,
You have a copy of the writ petition?
my lord, where
Where is the longitude mentioned? Please show me.
These
Mention.
figures are longitude.
Where from? Which is the
My lord,
longitude and the latitude?
My lord, it's a general common sense, my lord. This is longitude and latitude.
Which one is the longitude and which is the
My
latitude?
lord, 22 is longitude. When a figure represent, my lord knows, my lord,
No,
the
I
longitude and latitude are
No,
strong.
no, sorry, sir.
When a longitude and
know
latitude
what
matter,
Sorry,
my lord,
sir.
that
Sorry,
is a
sir.
specific thing.
Latitude, longitude. I've seen
No.
this in National Geographic, my lord.
My lord, this is how it is. I do
Plot
not know
of
that
land
this
is
is how
sold.
it is given. Coordinates
You are selling
and then
my
a
land.
longitude and latitude. are
Where
My
to
lord.
find the tiger, latitude, longitude.
Only the thing, my
look for the
lordship,
tiger.
kindly
It's not
appreciate.
National
No,
park.
no. Yes, that is why
Check
land is given in a
something must
longitude
be
and
there in
latitude.
your document to show that this is the particular plot that you are putting
Land
up for
is
auction.
I'm not touching
Longitude
its
and
plot.
latitude is
I'm not
in the
touching
land.
its plot.
284 is my plot. Well, 285.
284 I am not touching. Your lordship, kindly
285,
record
the
that.
appeal is
I am
pending.
not touching.
কতদূর বলেছিলাম?
284.
285
Record
is
that.
285
What
is
is
my
this?
land. You've
What is
unauthorizedly thrown me out.
Latitude is there. Then it is very specific.
Remark.
Please come up with better
block.
research.
Maybe the layer is there, but
My
when
lord,
there is
before I
longitude
want
and
to
latitude,
pay,
this is very specific.
Don't repeat the same thing. Please take
come
steps
with
in
a
accordance with
tender.
the law.
Who is to
Please set your own house in
Tender
order.
number of the
Defaulter,
plot.
defaulter.
who are you to
I'm not
instruct me?
farming that word, defaulter.
Can I have a tender
the-
keep or a new tender?
The plot details as mentioned in the plot details as mentioned in the notice inviting tender, however, mentions the plot number as 94/25 within bracket cap C. Stop. Next. The petitioner prays. কি বললাম সব তো ঘেঁটে গেল।
Number 94/25 capital E. The same is accordingly
Actually, the tender number
as mentioned in the
is such and such. Actually, the petitioner prays for a direction upon the authorities to cancel the notice inviting tender. Stop.
My lord, latitude longitude mentioned in the plan
And
at the bottom.
It has been brought to the notice of the court that the petitioner has already filed an application for stay of the tender process before the appeal court, where the appeal against the order of eviction is pending consideration, and the petitioner has failed to obtain any order therefrom. Stop. Next. The
Sketchman longitude latitude mentioned in the sketch.
the it has been submitted that the petitioner is enjoying the land for not paying rent for a considerable period of time. A huge sum of money is due and payable on account of area rent from the petitioner.
Occupational charges, not rent.
Acha, rent na occupational charges from the petitioner. Stop. The petitioner denies the allegation of the Port Authority. Stop. Paragraph. As it appears that the appeal preferred against the order of eviction is pending consideration for a considerable period of time before the additional district and sessions judge. Accordingly, the appellate forum is requested to consider the petitioner's prayer for early disposal of the appeal. Stop. The additional district and sessions judge, fast track, third court Howrah is requested to make an endeavor to dispose of the appeal, preferably by 26th September 2025. Stop. Any steps taken by the Port Trust in furtherance to the notice inviting tender shall abide by the result of the appeal. The writ petition stands disposed of. Supplementary affidavit I'm not taking on record because
The only thing, let them not allot the land in favor of someone else. The thing is, let him not scream. If allotment happens, I will at least let them put this in the tender then, Milord. Otherwise, everybody will come up and say bona fide purchase of a value without notice. Let them in. Let them put this in the tender. Let them put this in the tender at least. Otherwise, whoever purchases it, I will have to come back to your lordship again. This fact should be put in the tender that this is subject to the outcome of that. This much your lordship will direct them. Otherwise, everybody will come and say bona fide purchase of a value without notice. We did not know the appeal was pending.
This takes steps so that third party rights, even if the appeal goes in his favor, then so that the third parties do not let this be made known.
Kindly direct
to all the bidders.
Your lordship will kindly direct that. Kindly put that in the order.
Last week, Amarchand Mangaldas, your lordship did not.
No, I don't know what Amarchand Mangaldas did.
No, pass order for what?
Tender was stopped. They were asking for tender. They are all civil.
No, I am saying, I don't mind this. Lordship be
It
very
will abide by the result.
Let this be known to all the prospective bidders. Kindly add this.
একটা line add up করে দিন তো, the Port Authority shall intimate this order to all the bidders.
Grateful.
Yes, next.
Very good.
21, I appear for the petitioner.
Yes.
Well, this is the short matter of the, it was initially moved before the public interest as a public interest litigation. Thereafter, the court said that it should be made with this forum.
You say that the private respondent is filling up the wetlands?
Yes, well, that is my point. Well, I filed there is a 1 month.
How do you say it is a wetland?
Because the documents are there.
Please show me.
Well, I see the supplementary affidavit which I filed.
Supplementary affidavit?
Supplementary affidavit there.
Page 5, supplementary affidavit, small one. Mr. Ghosh resides in South Calcutta. He doesn't know what is called jawl in Mithila.
No, that's very good.
Yes, please.
But I'm saying, you see the document.
Yes.
And there is only one dag number 8. You the left hand side.
Dag number 8.
Under different quotidian numbers.
Yes, yes.
This is one of the one plot of land, 54 total. Next page, you 54 decimals of land.
Yes.
Total 54 definite land ballot owned by several numbers of parcels.
Yes.
Now the 2 parcels were in the first document at page 5.
Who are you? Are you one of them?
I am ballot 87. Quotidian number co-owner of the plot.
87.
Co-owner of the plot.
All right, co-owner of the
One
plot, Sheikh Kasimuddin.
10,
Sheikh Kasimuddin is the.
yes, my lord, it is my father, my lord.
All right, your father.
Now the years you see, my lord, the 1003 and 1010 in a Khodian number.
Yes.
These are the two gentlemen, my lord, who are also my lord, co-owner of the property.
Yes.
These are not partition property. These are not be identified. One DUG number. These my lord, persons have been, my lord, filled up that land and, my lord, put up the construction. Now one gentleman, I have come to know later on that this is a noting, and thereafter I collected the order. One gentleman, that is, my lord, 24, you logically see that the right hand side is the noting.
Yes,
is there.
2024 5 number conversion.
Conversion.
Yes.
That conversion, there is a rule, my lord, under 4C, that so far as the water body and jolayome, that cannot be, my lord, permitted to be done unless the state government permission is there, compensated.
Yes,
all these
yes,
are
but
there.
then Jol is not the water body.
Jol, my lord, Jol, I'm saying, my lord, Sapir, my lord, the Jol is not a, Malayalam says the Jol is not a water body.
Yes.
But it is a wetland.
No,
It's not a wetland.
If it is a shally land,
Wetland.
if it is a shally land, my lord, shally land cannot be converted, my lord, if it is converted for, my lord, the wet.
Well, suppose the conversion is erroneously given. This is not the forum.
I have challenged my without giving any notice and hearing.
Go before the forum.
Before I go to the forum, my lord, before you can see if it is, my lord, done.
It has been done. 2024 সাল 522 নম্বর conversion case.
I have come to that
You have come to know lately, but then that does not give you the right to invoke the
I have got the
jurisdiction.
order. I filed, my lord, the supplement evidence to this because, my lord, the procedure which has been followed. If that is not followed, my lord, I cannot go to other forum because
You can definitely go. Please
well,
come.
I can, then and so far as the other person is concerned, that has not been done.
Which one?
Well, the
1003 Sheikh Nobirul Islam. What is he doing?
He has also put up the structure.
He has put up a structure. You take steps for removal of unauthorized structure. How is the writ petition over
Or
there?
one of the another structure, evolution of the illogical, the environmental document there.
You are going under a wrong premise.
There, my lord, is a land, my lord. He converts, my lord, in that way without giving any notices. Is a joint land. Now, my lord, the put up, my lord, is on the identified partition land is given.
The petitioner is aggrieved by the action on the part of the private respondents in raising construction over lands recorded as jol. Lands korben na land. Plot of land bearing Khotian number 1003 in dag number 8. Khotian number 1003, dag number 8. কি বললাম? Which is aggrieved by the yes, right. Without obtaining necessary permission for conversion of the classification of the land. Step next. The petitioner also challenges the illegal action of the private respondent in raising construction over Khotian number 1010, dag number 8, classified as jol, over which classified as jol and conversion of the same has been made to bastu without following the due provision of law. Paragraph. The learned advocate for the petitioner submits that the construction is being made without following the environmental laws.
And also Land Reforms Act, my lord,
and also in violation of the provision of the West Bengal Land Reforms Act, 1955.
Land Reforms Act, তাই তো করেছি, প্রস্তুতি তো করেছি।
Paragraph.
কেন?
প্রস্তুতি তো করেছি।
করবে তো, কিন্তু জল তো নয়।
From the record of rights annexed at page 5 in the supplementary affidavit, it appears that Khotian number 1010 has been permitted to be converted to Bastu. Void conversion case number 522/2024. Stop. Raising construction over Bastu plot of land. Now, over a plot of land classified as Bastu cannot be an illegal one, provided the construction is being made in accordance with the sanction granted by the authority. Stuff. If the petitioner is aggrieved by the conversion being made, comma, then the petitioner ought to approach the competent forum for relief. Stop. Writ court will not be the proper forum where the challenge can be laid to the conversion of classification of land. Paragraph. As regards Khotian number 1003, comma, it will be open for the petitioner to raise appropriate objection before the competent authority, alleging illegal construction made over plot of land which is recorded as Jol. Paragraph. Be it recorded that in the district of Purbo Mednipur, the classification Jol does not necessarily mean that the plot is a water body. Stop. Has the state forwarded any instruction? BLLRO. Acha.
Report of BLR.
The Block Land and Land Reforms Officer, Bhagawanpur 2, has forwarded a report clearly mentioning that the plot is not a wetland, but the same is an agricultural land. Stop. Next. What were you submitting?
My submission, my lord, after obtaining the conversion and when I obtain the sanction plan, there are.
No, that is in respect of the other plot.
In this way, which plot?
Where conversion is being. No, the Khotian is separate. 1010 there must be
identified portion.
Demarcation.
Name of the respondent number 10, Sheikh Ilyas. Sheikh Ilyas is the son of Sheikh Ismail. Now,
Yes.
Sheikh Ismail's Khotian is
1010.
1010.
But identified portion is not there. I do not know where.
1010 is all right. What about 1003?
No, not 1003. Man, I'm mistake, my lord. 1480. 1480. Next page, my lord.
Oh, তাহলে 1003 হবে না 1480 হবে
1480.
Sheikh Tariq Aziz.
Sheikh Tariq Aziz. Who is the private respondent?
It's not made.
It is number 11.
Yes, yes.
Who is the private? Tariq Aziz is a private respondent or
Number
not?
11.
11.
I to Tariq Aziz is there. How are you making construction over 1080? Not making construction. তাহলে ওটা লিখে দিন একটুখানি learned advocate
1480.
representing the private respondent. Number 11 submits that no construction is being raised. How can you obtain sanction plan over a plot which is described as
Where is the conversion?
That may not be an entry, my lord, here.
but then there is a conversion.
No, conversion certificate is certificate.
আচ্ছা ঠিক আছে তাহলে ওটা লিখে দিন যে is raising construction after obtaining an order of conversion. Are you sure? 1040 converted? আচ্ছা লিখতে হবে না লিখুন
Document my lord from
may not be updated. Our record of rights are not updated on regular basis. আচ্ছা আপনি লিখে নিন ওটা 1480 তে হ্যাঁ 1480 তে লিখে দেবেন যে the allegation of unauthorized construction is being denied ওইটুকু বলে রেখে দিন the writ petition stand disposed 100
তোমার যে কনভার্সন
1480 হবে
আছে
হ্যাঁ
সব আছে
what
1480 he can't produce the right now
he has got a sanction plan
sanction plan
now whether it is after conversion or before conversion he must be having documents must be otherwise how can you raise construction over an agricultural plot of land or maybe money speaks for everything
Mr. Bose can say something
what regarding what
regarding
he can he can no this is in Mednipur he's in Kolkata he's not there in Mednipur
valuable place
knows about the environmental pollution regarding this pilot, regarding conversion right.
yes that I know
deeply obliged, madam.
Union of India,
Union of
1 and 2.
1 and 2, I am led by.
I
Yes,
represent
and
respondent number
3?
1 and 2.
3, CBI?
But I have served upon the CBI also, my lord. But my only relief, my lord, that I am praying for is as against, my lord, the ECI, the Election Commission of India.
All right, yes.
Now, your ladyship will find, but in fact, a few days back, your ladyship was dealing with a case pertaining to fake birth certificates and death certificates under a particular panchayat in Goshaba. That particular panchayat, upon submission of report before your ladyship, it transpired that around 510 death certificates were fake and 3,558 birth certificates were also fake of this particular panchayat. This is, my lord, and judgment and order dated 14th of July
Yes,
2025.
yes. Is it relating to the same panchayat?
This is all, my lord, these are all interlinked. Why, my lord? I'll come to that one after the other, my lord. The design is, my lord, not only to introduce fake voters. I am a whistleblower, my lord, so I am made to suffer. There is an FIR, my lord, which has been, my lord, registered against me. I am not challenging the FIR here. For that, my lord, he has preferred a separate anticipatory bail petition. I am, my lord, seeking for, as a citizen of India, my lord, being constitutionally, my lord, entitled under Article 327, my lord, because, my lord, representation is on the basis of, my lord, adult suffrage. I'm sorry, 326. Elections to the House of People and to the Legislative Assembly of every citizen of every state shall be on the basis of adult suffrage. So, my lord, what is happening is, in these cases, an inferior government officer, he is made, my lord, the scapegoat. Here also, my lord, after, my lord, this particular writ petition, the one I am moving, but I have also gone through, my lord, the live streaming of, my lord, this matter, which was heard by your ladyship, my lord, Kaushalya Rani Charities Trust. But I found, my lord, the state submitted that a particular inferior officer of the panchayat, my lord, he was the person guilty. He has been also arrested, etc. And thereafter, my lord, 510 death certificates and 3558 fake birth certificates were issued online from this particular portal. My lord, I further heard the state submitting that we are filing this report. My lord may not, my lord may kindly keep the report in sealed cover.
No, but then what is the relief that you are claiming here?
My lord, I am claiming for a court-monitored probe to be conducted by the ECI or by any, my lord, impartial investigating agency as the ECI may deem fit. Because under 324,
investigation of what?
my lord, investigation now, my lord, kindly takes the averments contained in the writ petition. Kindly takes, my lord, paragraph 4 and onwards. Page 4. Your petitioner states that upon assuming charge in Kagdeep, the petitioner became alarmed at the extensive and systematic irregularities being perpetrated under the guise of electoral roll revision and continuous updation. The petitioner at various instances flagged concerns regarding the inclusion of non-citizens and foreign nationals in the electoral roll through unscrupulous use of Form 6, that is new addition, Form 8, that is modification and migration, Form 7, that is deletion in assembly constituencies such as 130, 131 and 132. Your petitioner states that the modus operandi involves a well-oiled and nefarious network of clerical level officers, contractual operators, data entry operators, and outsourced agency personnel working hand in glove with political elements and high-ranking government officials to manipulate voter rolls. The EROs and AEROs, who are mostly busy with their substantive administrative functions, delegate their statutory duties to junior staff and unauthorized operators by merely passing the one-time password credentials, thereby compromising the sanctity of electoral process. Your petitioner states that in particular it has been found and digital footprints can corroborate that certain officials such as the cooperative inspector of Namkhana, election clerk of Namkhana block and other subordinate staff were routinely accessing Euronet by misusing the login credentials and OTPs of the AEROs of other jurisdictions. The disposal of forms belonging to one assembly constituency was being carried out from block officers outside the competent territorial limits.
How
in-
does the petitioner get to know all this
My
information?
lord, I am, my lord, the whistleblower, my lord. I, my lord, will find.
What do you do?
My lord, I am the assistant system manager
Of?
under Kakdeep subdivision, my lord.
Kakdik subdivision, you are working under the state government?
Yes, I am working under, my lord, the AERO, Kakdeep Assembly Constituency, and the Joint Block Development Officer, Kakdeep Block.
All right.
Thereafter, my lord, the petitioner states that despite the petitioner having no statutory access to Aeronet system independently, and any activity requiring the login of an ERO or AERO necessarily needing endorsement and OTP from the concerned ERO, the petitioner was maliciously implicated for inserting his own mobile number into the AERO profile for the purpose of processing 2 electoral forms at the behest of the SDO Kakdeep, who verbally instructed and endorsed such limited activity. Needless to state that the petitioner has been made a scapegoat for raising his protest, and a malafide criminal prosecution has been initiated against the petitioner, culminating in registration of Harwood Point Coastal PS, my lord. I am not, my lord, even touching, my lord, that FIR, my lord. Petitioner states that the petitioner is made the scapegoat to shield a large-scale corruption racket involving numerous officials and agency personnel to manipulate the electoral rolls to include Bangladeshis and Rohingyas. Your petitioner states that on or about 2025, the local MLA raised a complaint regarding inclusion of fake voters. Subsequent meetings and a fabricated complaint by the joint BDO Kakdeep led to an atmosphere of victimization. On 8th March, during a purported inquiry visit by the ATM election, South 24 Parganas, the petitioner was coerced, intimidated, and forced to make a self-incriminating statement under duress in presence of armed guards and senior officers. Your petitioner states that the petitioner's attempt to show digital proof of the real perpetrators behind the illegal inclusions, including the cooperative inspector, election clerks, DEOs, and agency personnel, was deliberately ignored. While a show cause letter was served upon the petitioner, no similar action or inquiry has been taken against the aforesaid officials who are directly responsible. Thereafter, my lord, it speaks about the FIR. And my lord, may kindly take, my lord, yes, para 14, my lord. Para 13 and 14, petitioner states, page 8, my lord, that the infiltrations of the criminal proceedings by the state police is only an attempt to create an eyewash and cover up the entire conspiracy. That Mr. Chatterjee, my lord, will address, my lord, that's pertaining to the anti-bail, my lord. Your petitioner reiterates that such modus operandi is being followed all over the state of West Bengal to manipulate electoral rolls across assembly constituency, and is not only limited to the above-mentioned assembly constituency. Thus, there is a requirement to conduct a holistic probe by the ECI, if necessary, by involving the CBI, to unearth the larger crime and conspiracy being committed to influence the electoral process by manipulating the electoral rolls in the state of West Bengal. Now, my lord, this particular design, this started the superior officers coercing, my lord, the subordinate officers, my lord, to enter into this compromise. When it transpired before the Honorable High Court for the first time as to what is happening, it is all about generating fake birth certificates, death certificates, domicile certificates. So, my lord, there was a petition moved by a whistleblower again. This is, my lord, an unreported decision, my lord, that I will be relying upon, my lord. Effective Devin, kindly show that. Here the case was that in, my lord, the Central Armed Paramilitary Forces, foreigners, that is, my lord, Bangladeshis and Pakistanis, by, my lord, exploiting the machinery available in this particular state, were getting, my lord, fake domicile certificates. Because West Bengal being a bordering state, the cutoff marks for entry into, my lord, the Central Armed Police Forces is lesser than, my lord, the other states. So, my lord, what transpired is, my lord, the state also said that we will not stand in the way because this is a matter of national security. But the second paragraph onwards, I'll place. The petitioner appearing in person submits as follows. Petitioner has been coerced and intimidated to join one Mahesh Kumar Chaudhary and one such and such in committing number of crimes in the state. He might have participated to some extent in these crimes at the behest of these two persons. In the process, he came to know about certain facts which amount to no less than a big scam regarding recruitment of personnel in army as well as some other central paramilitary forces by preparing false documents. Even Pakistani nationals got benefited. This prompted the petitioner to approach the respondent authorities with representations for necessary action being taken into his complaints. However, the respondent authorities have not taken sufficient steps in this regard, nor was the petitioner initially granted any police protection. It was only after intervention of the court that some police protection was granted to him. Quite naturally, he feared of his life as he has acted as a whistleblower. Learned such and such, representing the Central Bureau of Investigation, submits as follows. This is no more an adversarial litigation, especially so far as the central and the state agencies are concerned. Pursuant to a direction passed by this court, a preliminary inquiry was conducted into the allegations. As would appear from the report filed by them, no irregularities have yet been found in regarding recruitment in the armed forces. However, as regards employment in the central paramilitary forces, some irregularities have already been detected. During preliminary inquiry, at least 4 such instances have come to light. The state of West Bengal, being a bordering state, provides for less cut-off marks in examinations for employment in central paramilitary forces. This seems to have prompted people from other states, especially from the northern part of the country, to forge documents to show that they were domiciled in the state of West Bengal. Domicile certificates, matriculation certificates, and caste certificates have been forged. It will be a matter of more in-depth investigation whether foreign nationals have also taken recourse to the same modus operandi in applying for jobs in the Indian forces. In one case, the subdivisional officer, this is very important, my lord, who had issued the domicile certificate to one such applicant was approached to check whether it was his signature, which appeared to be so. The subdivisional officer flatly denied. However, it was the same subdivisional officer who had issued an OBC certificate to the same candidates. Therefore, an FIR needs to be registered and the matter properly investigated to find out the true extent and gravity of the allegations level, which could have a national implication. Learned Counsel, on behalf of the Union, adopts my submissions of the then Deputy Solicitor General. Learned Senior Counsel, representing the state, relies on their report and submits as follows. This is clearly not an adversarial litigation. The investigation may involve taking necessary steps, be taken in other states, and even information to be obtained from the Interpol, if necessary. Therefore, the state has no objection if the CBI investigates into the alleged offences. On this score, my lord, the CBI was directed, my lord, to register an FIR because the sanction has been withdrawn. Now, here I say, my lord, in my understanding, my lord, this design, including, my lord, that Goshaba police station case, my lord, pertaining to the panchayat, which was before your ladyship, my lord. These are all, my lord, arising out of the genus being, my lord, this particular larger conspiracy to include Bangladeshis, Rohingyas, foreigners, my lord, as voters. Now, my lord, what happened, my lord, I also have, my lord, the opportunity of appearing for a YouTuber. Now, he had covered that particular decision, my lord, which was the judgment delivered by your ladyship, my lord, in that cancellation of fake birth certificate case. Now, he had covered it. Just because he had covered it, the police registered a case against him. And he was being hounded. So he had to also knock the doors of justice. But now, my lord, there is a direction of, my lord, not to arrest, of, my lord, online interrogation in connection with the 41A notice or the 35(3) notice, my lord. So this is continuing, and my lord will kindly appreciate. I have seen the stand taken by the state in that matter also, my lord, in that Kaushalla Rani Charity Trust. The state categorically urged your ladyship to keep the report in a sealed cover because there was things, he said, which should be kept in a, which prompted him to submit, the state to submit the report to be kept in a sealed cover. My lord, I say, my lord, in my humble submission, but this design is the same, but it will be seen, the ECI will be in a better position to apprise. But in the state, insofar as the percentage of enhancement in the number of voters is concerned, the enhanced percentage has always voted for only one particular political party. The
All right,
statistics.
just wait. Tell me
Yes,
one thing.
my lord.
Was any representation from your end?
My lord, I'll tell your lordship, my lord, since I have filed this writ petition, because I threatened that I will not cow down the petitioner, that I will not cow down. I still have a spine, unlike many of my colleagues who are very, very frightened or intimidated. My lord, the police started a persecution. Therefore, my lord, he was constrained to file, my lord, a petition for anticipatory bail, despite the fact remaining, my lord, that the sections which have been on which, my lord, the FIR has been registered, these are, my lord, admittedly, my lord, bailable, below 7 years, warranting, my lord, 35(3). But, my lord, going by the mode and manner in which the state machinery, my lord, is functioning or has functioned, the usual practice is issuance of notice under 35(3), asking to appear for interrogation, by then moving the magisterial court for addition of, my lord, graver offences, and thereafter taking the person into custody. So this person, being a whistleblower, but he is being hounded, and, my lord, to be very fair before the honorable court, my lord, he also fears for a security of, my lord, pertaining to his life and limb. But all he has done is, my lord, he has made this petition. The petition is with this, my lord, with the ECI also. The ECI should indicate their stand before your ladyship, because I have categorically, my lord, asked for a probe to be monitored by your
All right,
ladyship.
let me hear the ECI once.
My lord.
But insofar as we are concerned, as regards the criminal propensity of action, we are not the competent authority. But the exercise which is undertaken, which is to be undertaken in the state, the compass of this is, the canvas of that exercise is to find out or fake voters and to prepare a true and correct electoral roll.
You file a report by way of affidavit disclosing what
Yes,
steps
and
are
not
you
if
taking?
the petitioner so desires, not the writ petition, the allegations are too sketchy, does
Yes.
not identify a particular area, does not mention a
Certain blocks have been mentioned.
if there are certain allegations, he can certainly make a comprehensive representation for us to go into it. But so far as his role is concerned, there are allegations which has prompted us to take a certain action against him.
All right, that is all right. But then page number 4, paragraph number 4, I can see the numbers 130, 131, 132, and the blocks are also there.
Yes, if your
Assembly
lordship
constituencies
kindly have a look.
blocks.
Paragraph 4 at page 4.
Yes.
Upon assuming charge in Kakdeep, the petitioner became alarmed at the extensive and systematic irregularities being perpetrated under the guise of electoral roll revision and continuous updation. No particulars furnished. The petitioner at various instances flagged concerns regarding the inclusion of non-citizens and foreign nationals in electoral roll through unscrupulous use of form number 6, form number 8, and form number 7 in ACAs such as 130, 131, and 132. This exercise will be done through SIR.
Yes. So you all are taking steps.
Yes, yes. As soon as the SIR exercise, we have started inducting the BLOs. As soon as the exercise will be implemented here, this is the exact purpose for conducting SIR.
All right, you take steps and
if he wants to furnish further details,
Specific report before your ladyship.
let a report come.
Yes.
Now, if he wants to file, that is his choice.
Yes.
The court is neither stopping him nor granting him liberty. He can always do so. So the court is not standing in the way since.
Today, in so far as the role of ECI is concerned,
right.
We have to uphold the sanctity of an election.
Yes.
And that's the purpose for which that exercise is being undertaken and will be undertaken.
If the ECI wants requires my presence, I am ready and willing always, my lord, to cooperate, my lord. But, my lord, I will be rather grateful, my lord, if the ECI affords me or, my lord, seeks my assistance or information, my lord, in their Delhi office.
But there is not
Delhi
so far as
office, possibly there is no requirement of going immediately. Here it's going on over here.
he had to be suspended because of a role which we.
Yes, I am not going into that. I am not going. I say that I have been
a criminal case pending.
Yes. Not because of pendency of criminal case. Disciplinary. The disciplinary action has been initiated against him. He has been placed under suspension because of changing the login credentials of an officer.
Yeah, I have said that I have changed.
He has
says that this is under influence.
Yes, I have.
But that's not for us to decide.
Yes, that the proper forum will decide.
That I will deal with. I am concerned about the entire state, my lord. It is not only pertaining to this particular assembly constituency. I am concerned about induction of foreign nationals, my lord, and thereby, my lord, completely trampling upon the concept of democracy, my lord. Free and fair election is a mandate to be secured by the ECI under Article 324.
The petitioner
সৌরভকে টাকা দিয়ে আমাদের ওটাতে তো সৌরভের মুখ করার কথা।
the petitioner has mentioned he's a government servant. What
Yes.
does this government servant mean? Is
Yes,
the
I'm a public
assistant
servant, my lord. I am
system
a,
manager,
Hmm.
assistant system manager attached to what?
my lord, I am, but it is there. I am presently attached to, my lord, will find, kindly take page 22, para 2, assistant system manager Kakdeep, subdivision, South 24 Parganas.
না না ডেজিগনেশনটা কি অ্যাসিস্ট্যান্ট সিস্টেম
Assistant system manager.
রোল এটা কি
The petitioner claims to be serving as the assistant system manager, Kakdeep subdivision, South 24 Parganas.
presently under suspension.
Stop.
নয় প্রত্যেকে যেতে হবে কনসেপ্ট হিস্ট্রি নেই
System manager, he has been involved in the process of revision of the electoral rolls under direction of the Election Commission of India. Stop. A complaint was lodged against him, and he is
Against me and few others.
against him along with others, and he has been placed under suspension. Stop.
communicated হয়েছে
A criminal proceeding. Now, an FIR was lodged against him, and a criminal proceeding is sub judice. Stop. Paragraph. In the instant writ petition, the petitioner prays for a direction upon the Election Commission of India to conduct a probe into the illegalities of manipulation of electoral rolls in various assembly constituencies in the state of West Bengal. Stop. Allegation is that foreign nationals and Rohingyas are also being included in the electoral roll. Stop. Next.
And prayer G as well, my lord, if necessary, by taking the aid of the CBI.
today not
No,
the
as
wake of the election if you have to submit
No,
our
no.
records and assist the CBI this will be a
Yes.
catastrophe for us
Necessary.
the the
See the faith on the ECI and Planet Senior Council.
the petitioner refers to, give me that order of the panchayat,
Pardon.
refers to an order passed by this court on such and such date in WPA number such and such, party number such and such.
না সেলাই করাটা জোসেফকে দিয়ে দিয়েছি বোধহয় না, বাট অ্যানাদার কপি।
Not another copy. You've not handed over any copy. No.
This is the copy.
Is a case number WPA and WPO, wherein
আচ্ছা। May I take your ladyship's kind leave?
yes,
The junior is being
yes, yes.
badly grilled in before the division bench, my lord. But Mr. Nag is here, my lord.
All right. আচ্ছা, কি বললাম?
The petitioner refers to an order passed by this court.
Wherein instance was found of issuance of fake online birth and death certificates under the Pathankali Gram Panchayat. Stop. It has been submitted that fake certificates of birth, death, and domicile are being relied upon for the addition, revision modification and migration of the electors. Stuff next. The prayer has also been made for conducting an investigation by the Central Bureau of Investigation. Stop paragraph. Learned advocate representing the Election Commission of India submits that steps have already been taken by the Commission for revision of the electoral roll. Stop. The allegations raised by the petitioner will be looked into. Stop. It has, however, been pointed out that no specific instance of illegality has been pointed out, and the allegations are all omnibus in nature. Stop paragraph. As it appears that the Election Commission is already in the process of revision of electoral rules. Accordingly, hearing of the writ petition stands adjourned till 10th September 2025. Stop. A report by way of affidavit shall be placed before this court by the Commission, disclosing the steps taken for revision of the electoral roll. Stop. The allegations made by the petitioner in the writ petition will also be taken into consideration at the time of preparation of the affidavit. Paragraph 9 represents the Central Bureau of Investigation. Stop. Let further notice be issued upon the respondent number 3, communicating the order of the court. Affidavit of service is taken on record.
And may I only pray
1
for
minute.
this? Instead of not the ECI, not any of the officers in West Bengal can do this. Otherwise, it has to go to Delhi. It takes
Any of the representative of West Bengal?
of the respondent number 2, your lordship.
Yes. Respondent number 2. Respondent.
Any of the officers from the
commission. Respondent number 2. Report. Respondent number 2. Were you submitting something? It will appear in the list.
Will appear tomorrow.
Tomorrow? Kalka list দিয়ে দেবেন. Serve notice upon the other side regarding this.
Then I am serving notice. Kindly keep it on Friday so that everyone.
Friday, all right, Friday. শুক্রবার দিন দেবেন.
My lord, item number 33. I beg to appear on the.
এটা আগের মামলার সঙ্গে যাবে। Yes.
My lord, the principal challenge is invocation of section 123 of.
My lord, I am for the
That
respondent.
has been revoked, mine. So
No.
by the authority in the meantime, this is the letter of communication.
My lord, section 123 has already been revoked, and he has been, my lord, ordered to be released.
To be released.
Yes, that is.
So your
fine.
purpose is served.
Yeah. On 19th, he
Learned
was
advocate
released.
appearing for the petitioner and the
Well, all the respondents.
respondents submits upon instruction that the order passed. Is it an order or a notice or what?
Order is on the next page. Lordship kindly see.
The page I have folded, that is the order, my lord. The revocation of section 123.
I do hereby
The
revoke
removement order
etc.
passed under section 123 of the Army Act 1950. Dated 19th August 2025. That where is the 123 order?
Invocation of 123
Where
is
is
page 57.
Page 57.
Annexure P9, my lord.
Dated 30th June 2025. Has been revoked.
My lord.
Vide order dated 18th August 2025. Stop. The petitioner has been issued a new movement order on 19th August 2025. Stop. Learned advocate submits that the grievance of the petitioner has since been redressed. Stop. Next. In view of the aforesaid submission, the writ petition stands disposed of. The movement order and the revocation of section 123. Revocation of order under section 123 of the order under section 123 of the Army Act filed in court today be written with the records.
Grateful.
I'm for the state respondent, my lord. I have a middle point of territorial jurisdiction. Territorial jurisdiction.
Lordship, I am appearing for the petition. Lordship, I'm led by Mr. Mukherjee using circuit bench. Lordship, on the last occasion, the respondents had raised a point on the jurisdiction, Lordship. Lordship, if kindly sees the prayer portion, my prayer D.
Yes.
A writ of or in the nature of mandamus directing the respondent authorities to provide compensation to the harassment for the loss of the business, your lordship. And your lordship, prayer number C, which is the a penalty which had been imposed on me. Lordship, my main...
Who has imposed the penalty?
Bokaro Steel Plant.
So it is not within the jurisdiction of
that
Calcutta High Court?
Lordship, my main compensation I'm claiming from SAIL, Steel Authority of India Limited. Now, the administrative building, the administrative decisions of all these penalties and compensations are the offices in the Calcutta, Lordship. So my main compensation,
Cause of action arose within a place which is outside the territorial jurisdiction of the Calcutta High Court.
Lordship, but I have been levied a penalty of 64 lakhs in an arbitrary manner.
Right, not by SAIL, but by Bokaro Steel Plant.
But Bokaro Steel Plant is under SAIL, your lordship.
So what? Why don't you go before the proper forum and get it done?
Lordship, then kindly gives me another date, your lordship.
Date? For what? Going before
No,
the
your lordship,
proper forum?
No, your lordship, then Mr. Mukherjee would argue this matter. Actually, he's engaged in the circuit bench.
On the last day, adjournment was sought for.
on the ground that Mr. Mukherjee is in another.
Lordship, on the last day, we did not seek for an adjournment.
No,
We
no,
were
you said
present
for a
here, we
Passover.
sought for Passover.
Yes, yes.
We were present.
Whatever.
The respondent sought for a adjournment.
No, we never sought for
No,
adjournment.
the respondent.
No, nobody sought for adjournment.
You were in there. Another
All
respondent.
are there.
Tell the learned counsel to join online.
Lordship, there is a matter fixed. Your Lordship, can Lordships kindly grant pass
I'm passing it over. Tell him to join online. I'm passing it over for the time being.
Much.
Next.
Lordship, I appear for the respondent number 6 bank.
6? Back.
State Bank of India, respondent number 6.
Lordship, I appear for the resolution professional, respondent number 5.
Your Lordship, I appear on behalf of the petitioner. Yes. The writ petition is arising from an order passed by the learned National Company Law Tribunal. The order is dated 28th of February 2024. It's at page number 61, Your Lordship. Through this order, Your Lordship.
But then Company Law Tribunal as an appellate forum, isn't it?
Yes,
Yes,
yes.
Your Lordship.
Ordinary remedy is there.
Then
Statutory
they will be showing judgments that a writ petition is maintainable, Your Lordship, through company against an order of the learned National Company Law Tribunal.
The writ court jurisdiction is never ousted.
Yes,
But
Your
whether the court will exercise jurisdiction or not is a big question mark. But if you have the NCLAT forum, why are you here?
Your Lordship, perhaps the time for filing of an appeal.
May I say
If
that
the time has elapsed, then invoke the provisions of the Limitation Act.
Your Lordship, there is a judgment by this coordinate by the
Only
coordinate bench.
because you have lost the time to approach the appellate tribunal, you'll come to the writ court. It can never be. When was the order passed?
Your Lordship, it was passed on 28th of February 2024.
Right.
It's at page number 61.
Page 61.
Your Lordship, I'm being led by Mr. Varun Kothari in this matter.
Whoever is leading you, the facts is not going to change. You approached this court in July 2024. Right. And the matter was decided on merits. A detailed judgment, 17 pages, is there. Why will the writ court enter into it? What is your submission?
he is coming up against an order of admission, Lordship, under section 7.
So the matter is pending.
No, matter is pending.
Yes, Your Lordship.
Admission,
CIRP
it is
proceeding is
against the
going
order
on.
of admission.
Right.
Why it has been admitted?
Why it has been
Because
admitted?
originally a writ petition, winding up petition was before this High Court.
Hmm.
It was filed by a person.
No,
That
by
is
State Bank.
Whoever.
Sukomol Biswas, that is not a financial creditor, that's an operational creditor. Operational creditor had filed. Now State Bank had filed an application here, they please transfer. Made a transfer, it was transferred to NCLT. Over there, Lordship, it has to be made section 7 compliant. Certain things are not in the winding up petition, that has to be put in. That was put in by the State Bank.
It's been admitted under section 60 of the IBC.
Yes.
So this application has to be made to make it compliant under section 60. Under section 60, there is a provision that you can make certain prayers. So that prayer was made to make it section 7 compliant. That is, the name of the IRP has to be suggested. That was made. And other things, that is the default chart and all, everything has to be put in. That was not there here. So that was put in. Over here, we ask for liquidation. Over there, first is resolution, then liquidation. So first part, resolution part, is now going on. That is, CIRP is going on. They have found a person who is agreeable to take up. That is, as in agreed by the COC, that is the Committee of Creditors. Now it is, application has been made for approval before the adjudicating authority. That is the NCLT. In this stage, she has come up. That section 7 application has wrongly been
admitted.
They have
Yes,
not
yes, it
complied
has
with
been
the
admitted
provisions
wrong.
of the Insolvency and Bankruptcy Code, Your Lordship.
It has not been compliant. It is not.
In the order itself, it is stated that if Your Lordship kindly comes to page number 72.
Page number 72,
Rule
yes.
5 of the company's rules, 2016.
She is saying section 8 should have been made instead of section 7.
Treated
This is a
application under
prayer.
All right,
section
so it's a
7, 8, 9.
very good ground for preferring an appeal. Please come.
Your Lordship, the limitation is already over, Your Lordship. Your Lordship, I'm being led by Mr. Anirban Ray in this matter. Kindly keep
Yes.
it tomorrow, Your Lordship.
The prayer is also wrong. The order date is wrong in the prayer. It should be February 28th, not 23rd.
Your Lordship, there are certain further point of law as well, Your Lordship, kindly. Kindly keep
As
it
a
tomorrow.
limit, accommodation has been sought for by the learned advocate representing the petitioner. Stop. List next Wednesday, 27th.
Grateful.
My lord, I appear for the petitioner. My lord, this is my writ petition against the wrongful withholding of my registered deed of conveyance by the district sub-registry of Guma.
For how many years?
My lord, this I had submitted for registration in 2005.
What were you doing for 20 years?
My lord, I had approached them multiple times. What they had told me is that there were some departmental proceedings pending against the sub-register of Guma,
Yes,
due to which
yes.
this could not be handed over. My lord, thereafter, my lord, I had subsequently made inquiries and I've come to know that those departmental proceedings have been dropped. I have annexed that order also.
Mm.
I have issued them multiple demand justices calling upon them to at least tell me why the deeds are still being withheld, my lord. My lord, they had written me a letter admitting that the deed is still with them and stating that there is some memo under which I have to obtain special permission. My lord,
A separate matter of the same nature was possibly moved to
yes, yes,
bench
yes.
also,
Yes, yes.
isn't it?
Moved by me before, my lord.
Yes.
In that, my lord had called for a report to be furnished by the state. This writ petition also had appeared on 27th March 2025 before a coordinate bench, and a report was called for to be filed within 2 weeks. My lord, no report has been filed till date, my lord. At least not supplied to us. 27th March 2025, in this writ petition itself, my lord.
Are you there for the state? Where is the report?
Led by appearing Mr. Arun Bag.
Ah.
I have instruction.
Please give. What does it say?
There is bar, my lord, finance department.
A departmental proceeding is pending.
Yes, ma'am.
And therefore, dare to request you to take necessary steps so that all disputed documents related to the matter are not delivered. A similar report I have seen in that matter also.
Yes, my lord, and my lord, this I have already disclosed in my writ petition. After
Mhm.
that, my lord, in the other matter, after seeing this memo, my lord had directed them as to what is the present status. Since 2005, my lord, my deed is pending.
Yes.
This
was in 2007. Thereafter, what happened?
My lord, there is no update report.
You have to bring an updated report. The writ petition of 24. You cannot rely upon 2007 document. Ashun to dekhi.
my lord will kindly take up the order passed earlier in this writ petition, my lord.
I can see this. In furtherance to the, no, not furtherance, in compliance of the direction passed by the court on 27th March 2025, learned advocate for the state has produced a communicating memo of the ADSR Guma dated 19th August 2025. Along with the said communication, a letter of the Joint Secretary to the Government of West Bengal Finance within bracket Revenue Department dated 28th May 2007, addressed to the Joint Secretary to the Government, addressed to the Inspector General of Registration and Commissioner of Stamp Revenue. কি বললাম শুরুটা কি করলাম এই সেন্টেন্সটা শুরু করলাম আচ্ছা ঠিক আছে is annexed with the aforesaid communication. It appears therefrom that the Inspector General of Registration and Commissioner of Stamp Revenue has been requested, was requested to take steps so that all disputed documents are not delivered to the registrant members of the public till the matter is settled. Stop. The aforesaid communication also mentions about serious financial irregularities regarding collection, remittance, and accounting of bank drafts in the office of the ADSR Guma, and departmental proceedings have been recommended against the then ADSR. Stop paragraph. The petitioner prays for return of the original deed of conveyance. Paragraph. Learned advocate for the state respondents is directed to produce updated reports of the criminal case. Stop. The authority shall keep in mind that a document of the petitioner, a registered document of a registrant cannot be held back for nearly 2 decades. Stop. The formalities required for handing over the document to the petitioner shall be disclosed in the report to be filed by the ADSR Guma. Stop. Released 3rd of September. Is the next one also same?
Yes, my lord, identical. And my lord, may I just point out this, my lord? My lord, this memo has
But
already.
is the state appearing here? Yes.
My lord,
You
this-
have similar communication?
Yes, my lord.
My lord, this memo was shown in the last order and recorded, my lord. My lord, this possibly cannot be the updated report because the same
No,
question
it is not the updated
fell
report. I
with the
can
last question
understand.
from the honorable.
2007 communication. Same order. Give your communication.
My lord, updated report with advance copy may be served, my lord. So that
Just wait. Next matter.
38, Lordship, I am for the petitioner. This is the affidavit of service, Lordship.
But I appear for the status.
Yes. What is the matter?
Lordship, matter is that, Lordship, my petitioner residential house in front of residential house PWD road. Over the PWD road, respondent number 6 construction over the PWD road. My ingress and egress are, of course,
Blocked.
blocked.
Where is your objection?
Lordship, kindly page 23, annexure P4.
Any report from your end, state?
My lord, before that, if your lordship allows me,
Yes.
my lord, the petitioner herself is an encroacher. Kindly come to page 20.
Yes.
She admits.
Yes.
3rd paragraph. It is further informed. Has your lordship got it?
Yes, yes.
Since 12-13 years, I, along with my other son and daughter, jointly run tiffin shop over the land which belongs to PWD.
That also remove, and I also accept this and both the representation.
Representation will be considered.
Representation and
The petitioner alleges illegal and unauthorized encroachment over public road. Stop. An objection by the petitioner is pending consideration at the end of the assistant engineer. PW within bracket roads. Stop paragraph. None represents the private respondent. Affidavit of service is taken on record. Stop paragraph. Learned advocate representing the state respondent submits that the petitioner herself is an encroacher of government land. Paragraph. The according to the petitioner, comma, the said encroachment has been removed. Paragraph, be that as it may, as an objection, alleging encroachment of public road is pending consideration at the end of the assistant engineer, comma, accordingly the instant writ petition is disposed of by directing the respondent number 4, the assistant engineer within bracket, public works within bracket, roads directorate, comma, Kakdeep, is directed to take into consideration the objection of the petitioner in accordance with law after giving reasonable opportunity of hearing to all the necessary parties and dispose of the same by passing a reasoned order at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
Deeply obliged.
Paragraph, learned advocate for the petitioner is directed to forward a copy of the objection to the aforesaid respondent at the time of communicating the order of the court disposed.
Okay. Lordship, in item number 39, I am led by Mr. Shobhushachi Chatterjee, Lordship. He is suffering from some serious oral disease. I am praying for not this week. Lordship, kindly fix it next week.
Where is the advocate on record?
Lordship, he is in some other court, Lordship, but
Call him. What is the matter about?
The excise license, when there was a shifting.
Hmm.
Now, he did not have the trade license. In 2024, he got the trade license. Well, this is our instruction.
Please give. Please call the advocate on record.
My lord would find 2005-6 is original shop.
Yes.
Thereafter, my lord, he was last line. He was shifted to 2014. Proposed site at Shala. Now he did not have any trade license, but that is he gets the trade license in 2024, which he has himself admitted. Now, my lord, there are objection cancer. My lord, in the meantime, there has been some change. Cancer care clinic has come up.
Where? That area? What is the prayer of the petitioner? For shifting?
Your Lordship could kindly pass it over, then I'll call the advocate on record.
Is the prayer for shifting?
He is now shifted to this place. Now this he cannot open. There is some agitation from the local people. For the
No, that means you have granted the license.
he was the new proposed site at Salab. Thereafter, he could not produce the trade license for 10 years. So the shop remained unopened.
Does the petitioner have a license?
It has been extended from time to time.
So it has been extended.
But it is one non-running condition.
Yes. So what exactly is the petitioner wanting? To commence operation. He cannot commence operation. Call the on record, please. I'm passing it over. Call the list.
But this is my application.
Yes.
This is my affidavit of service. This is come as per mentioning of the respondent, my lord. Don't know when. My lord, kindly come to page 27. This is the crux of the matter. I have, my lord, the residential unit.
Chandanagar Municipal Corporation?
At their instance, this matter has come, my lord. They have mentioned.
At their instance?
They have
Who is
submitted.
for the corporation?
My lord, advocate Leonard Bushi is for the corporation, my lord, due to the death of his maternal uncle, my lord. He could. Uncle. Kaka.
Yes.
Uncle, he is not present here.
Then
He
40
is
and
in his
41, my
native
lord.
place, my lord.
So he is not going to come.
He will be there on Friday, my lord.
My lord, then not this 40 and 41, same matter, my lord.
What have you prayed? For consideration and disposal of the representation?
Yes, my lord. Till today, my lord, this one is this, but the PWD is going on the construction, my lord, by my lord, blocking my way to egress and ingress, my lord.
Where is the state? You have given notice to the petitioner. You have mentioned this.
My lord, this is an unfortunate situation, my lord.
My lord, I personally know so on, my lord.
You should have been served upon the state council also, because state is also a party. Right? On the prayer made on behalf of the learned advocate representing the Chandanagar Municipal Corporation, hearing of the writ petition stands adjourned till 1st September 2025. Stop. Let notice be served upon all the respondents,
By
intimating the next date of hearing.
Mother 41 is the same matter.
40 you serve because it is your matter. 41 is also same order. Give your name.
Yes,
42 affidavit of service is there or not? 41 affidavit of service? না থাকলে দেবেন না। না থাকলে দেবেন না।
41.
You are there for the state?
Lordship.
All right. Chandanagar Corporation has sought for time. You have instruction?
Yeah, I do have one lordship.
Give, it can be written with the record.
Chandanagar Highway Division.
এটা রেখে দেবেন তো records এ। Mr. Ghosh, where did he go? Very well. 1st of September, it has been fixed.
Number 42. Yes, my lord, I am for the petitioner, my lord. Yes. Petitioner is a student of first year student and she belongs to very economically weaker section certificate for the last year, 2023 and 2024. But when I am applied for renew of this economically weaker section certificate, still now it has not been renewed.
Where is your application?
Application is annexed at page 19, P3. On 19th December, I applied for renew my certificate.
You got it for 24, you said?
Yes, my lord.
Then how can you apply in 23 for renewal? So 23 application was allowed for 24. Now for the year 25, you want another certificate.
It is up to 24. 23 to 24, it was there. But thereafter, before expiry of my economically certificate, so I applied for 19th December 2023.
Can't be. Lordship is
Cannot
correct.
be.
Lordship is correct.
You are going wrong.
No, my lord. The receipt is 22/8/2024. It will be received.
No, the certificate which is issued for the year 23-24 at page 112, it is valid till 31st March 2024. During the validity period of this certificate, my sister is applying on 19 December 2023.
Anyway, what is the position now?
Well, position, my lord, may I respectfully hand over this instruction by
What does it say?
ADMG.
Yes.
He says this 19th December 20, kindly see paragraph 2, 19th December 2023, she was asked to resubmit the same because of some anomalies, and thereafter it was considered and rejected. My lord, rejection is, my lord, page, my lord, kindly sees page 5, serial number 40, it is Rajanno Jana, the petitioner. Thereafter, the inquiry of verification of land details, page 6, 28th March 2024, serial number 48, second entry, Rajanno Jana, page 6.
Yes.
Verification of land details of Rajanno Jana along with other applicants. Now comes page 7, thereafter final page 8. 12th August 2024, it says cannot be recommended. Why? Because she is holding more than
5 acres of
200 square yards residential. So far as 5 acre part is concerned, she satisfies. Residential flat satisfies. But regarding residential plot, she does not, because it has to be within 200 square yards. Kindly this is clause 4. She holds more than square yards. Now,
did you intimate this to the petitioner?
This is the whole thing, my lord. Now this gentleman, this ADMG, what he says in para 3, kindly says para 3 kindly comes, my lord. To para 3, he says that this 30th September. So, my lord, this application which was inquired into and final rejected relates to 19 December 2023. That means the period when this certificate was valid. So now next what this gentleman says in para 3, that 30th September 2024 application we never received. That is, my lord, at page, my lord, 30 of the writ petition. That is for the current period. 24-25. It has to be. This one. That should be for the current period, because in EWS certificate, lordship, no, there is no concept of renewal. It has to be yearly exercise, annual exercise. So this 30th September, this ADMG says we have not received. However, he says
Page
that
30, how did you serve? There is no proof of service
No,
on
no,
page
nothing.
30. Yes, my lord, I serve it is. Show me. It should have been annexed to the writ petition. Yes, my lord. But this
so
is
now what I may suggest, lordship, to shorten the problem, my lord.
online application.
Yes, para 4.
Yes,
She may mind learned
sir.
system may take that recourse and get it thrashed out.
Geo is enclosed. Oscar.
Oscar, this portal is there. Kindly see page 11. The instruction, 11 of the instruction. Kindly sees, my lord, the first paragraph, fourth line from the top. So and so issued an order. Online submission of application for EWS certificate in annexes C and D. Format and issuing a digitally signed so and so. So whereas under the easy of doing business and business action reform plan, so and so has been. So, my lord, now if this portal is being clicked, entire thing will come up. So what I will suggest, we will shorten the issue. That
Please
for
come.
getting certificate for the year
Uh,
24-25.
an economically weaker section certificate in her favor. Stop. The petitioner claims to have made application on 30th September 2024 or for obtaining the EWS certificate and alleges that the same has not been provided to her. Stop. Learned advocate representing the state respondents has obtained instruction from the additional district magistrate within bracket General Paschim Mednipur, wherefrom it appears that the application made by the petitioner, allegedly dated 30th September 2024, was never received by the office of the respondent authorities. Stop. Admittedly, there is no proof of service of the application dated 30th September 2024. Stop. The ADM within bracket G has forwarded instruction that presently EWS certificate may be obtained online through Oscar, shopkota caps, OSCAR portal and not through Oscar portal. Stop. The Oscar portal in terms of the government order dated 10th July 2024 being number 1093. ঠিক আছে page 11. So, in view of the above, the instant writ petition is disposed of by granting liberty to the petitioner to apply for obtaining online EWS certificate through Oscar portal. Writ petition disposed.
For ready reference, I have already
is-
served a copy,
you
so
have-
she can get the guidance.
Service taken on record.
Yes.
I'm for the state, you look.
My lord, I am for the petitioner.
What is the matter?
My lord, petitioner is a old widow lady, my lord. My lord, her husband was died on 14th February. 14th February. Died on 4th February 2014. My lord, thereafter, she communicated several representation to get the pension benefit, my lord, but till date, she did not get any pensionary benefit, my lord. And
Pension, why is she claiming pension? Her husband was an employee of the state.
yes, my lord.
What the husband?
Husband was a medical practitioner in Baharampur, Baharampur Sodor Hospital, my lord. And he got the voluntary retirement. And there is another scenario. She is the second wife of her husband, and the first wife died, divorced, my lord, already.
Died and divorced means died earlier, divorced later, divorced earlier, died. What?
Divorce.
Divorce on account of death. What?
My lord, first wife already divorced in 2024. Thereafter, 2004, and thereafter she died.
Your Lordship, the fact is
In the list of dates, where have you mentioned about the death of your first wife?
list of dates, list of dates.
All right, 15th of June 2004, petitioner got married. You married earlier in June. No, June 24 you married and decree was passed in April 2004. All right, then.
Then, my lord, petition after the death of her husband, she made several representation, and there is a several departmental representation also made, and department also accepted that the petitioner is the only entitled to get the family pension. My lord.
Then why is it not being given?
My lord, in the recently. My lord, recently, petitioner received some documents from the department, representation from the department, and there is shown that it is shown that the granddaughter of the deceased person made objection, and she claimed the pensionary benefit, but she did not given the proper documents respect of this claim. For this reason, department also given another representation there. In department also said that the, my lord, may I read, my lord?
1 minute. Prior to that, tell me whether the writ petition will be maintainable. Will the writ petition be maintainable? Your deceased husband was a government servant, right? So if any relief is to be sought, it has to be sought from the tribunal. Why will the writ petition be maintainable? Service benefits of an employee? What will be your answer? What is the stand of the state?
Lordship, I have submitted the report. There is an objection from the granddaughter of the first wife of the petitioner's husband. But after that, we have again send us some notices for submitting the documents, and she has not submitted that in time. But still, till then, the file is pending before AG Bengal, Your Lordship. They have not released the.
If the widow is alive, the granddaughter's objection will be taken up for consideration.
Your Lordship.
What does the service law say? Did you check it up?
No, Your Lordship.
Why? Why will you rely blindly upon whatever is submitted?
Your
Any
Lordship,
XYZ comes up with an objection and the authority will sit tight.
But Your Lordship, she also claims that she is a claimant.
She may claim a lot of things. Will your officer not see whether she is entitled to in law?
Your Lordship, the MSVP has already stated that she is the only entitled person.
Then?
The AG Bengal is
AG Bengal has
objected
sent,
that.
to the finance department for the clarification. My lord.
Why, what does the supporting law say? Who are you for?
AG Bengal, my lord.
Where from is AG Bengal coming up with all these objections?
No
Did you
objection,
check
my
up the
lord.
law?
No objection, my lord. My lord, the state authority has been is to the appropriate authority for the verification, my lord. The
Why is AG Bengal raising objection? Under which provision of law?
my lord, AG Bengal is subject to my lordship's correction. My lord, AG Bengal is free to.
You satisfy the court as
Your
to
lordship,
how the
kindly-
petition is maintainable. Yes, what is your answer?
My lord, state also gets stand that the petitioner is entitled to get the pensionary benefit, my lord.
You say that you are entitled to get relief under 226. All right. Check up the law and come back. All right.
Kindly give me the liberty to file.
Another what?
Withdraw.
Another what? Acha. The petitioner claims to be the widow of a of an employee of the state government. Stop. She claims family pension. Stop. Next. Learned advocate representing the state respondent submits upon instruction that though the MSVP of the hospital has certified that the petitioner is the only heir and legal representative to receive family pension, the same could not be disbursed because of objection raised by the Accountant General of the state of West Bengal. Which paragraph it is mentioned? AG Bengal has raised objection.
Your lordship. Lordship, kindly come to the last page of my report. The administrative department is requested to submit the authenticated documents to AG Bengal, West Bengal, to settle family pension in favor of Srimati Shikha Chakraborty, wife of late Dr. Nitya Gopal Chakraborty.
My lord, this is not an objection.
And
this is not the objection.
But the file is lying over there only, your lordship. As per
This is from the registrar of the pension branch finance department of the state. It is not the AG Bengal.
But your lordship, the pension will be released from AG Bengal because the file is pending before
After the
before
verification
AG.
by the state, my
That has to be done by AG Bengal, your lordship. The verification has to be done by AG Bengal.
You are complicating things. কি বললাম?
Your lordship, the fact is the
কি বললাম?
objection.
না ওটা হচ্ছে disbursed as certain authenticated documents as asked by AG within bracket A and E, West Bengal, has to be submitted. Stop. Next. The learned advocate representing the petitioner is to make submission with regard to the maintainability of the writ petition before this court. Paragraph, the learned advocate for the state respondents is directed to take proper instruction with regard to the actual document that is required from the end of the petitioner for disbursal of pension. Stop. The respondent authorities shall take note of the fact that the employee expired in the year 2014 and the petitioner is currently more than 72 years of age. Release the matter next Wednesday. 27th, affidavit of service is taken on record. What exactly is wanting? Please take instruction.
Your Lordship, the thing is, the objection was raised before AG Bengal by the granddaughter. That's why the file is lying over there.
You will take instruction as to what is to be done for releasing the family pension.
I will.
All right.
My lord, the copy of the report, my lord, kindly serve.
To be given to you. All right, give a copy. Next.
I am appealing for the state, my lord.
Yes.
I am for the petitioner. My lord, the petitioner obtained one, my lord, that work order in respect of supplying some documents to the, my lord, the regional transport office motor vehicle department, through tender. My lord, thereafter, my lord, the work order, your lordship kindly come to annexure P1, that is the work order, which has been issued. 13.
What you were supposed to do? Construct?
No, not construct.
Supply of wooden furniture.
It is a new, my lord, the building.
All right.
So, my lord, the petitioner has to supply wooden table of 25 pieces, executive chair 12 pieces, wooden chair of 20.
No, will you get the transportation charges or the cost of? Oh, for supply also you will get.
Now, your lordship kindly take the next page.
Where is the document to show that you supplied?
Yes, my lord. Your lordship kindly come to page 14 and 15. Page 14 and 15.
Yes.
My lord, this is the
Motor vehicle sanction received.
receipt.
Motor vehicle section received. Yeah, what is your answer?
Now, my lord.
My lord, I am appealing on behalf of state, my lord.
Yes. What is your answer?
The regional transport.
देखिए কি বলছে?
My lord, only one thing, my lord, I also
Yes.
give a supplementary affidavit. There,
Why?
copy ta dekh. So the original. তোমার রিপ্লাই কি আছে?
Please come. The petitioner seeks release of payment for supply of goods in terms of the goods na furniture bolun. Furniture in terms of the order placed by the Regional Transport Officer Murshidabad, being memo number 949/MV/MSD, page 13, dated 9th November 2021. Stop. The petitioner has annexed document to show annexed documents at pages 14 and 15 of the writ petition to writ petition in support of the submission that the furnitures were supplied to the regional transport officer. Supplied in the office of the regional transport officer. ঠিক আছে? Next. Prayer has been made to direct the respondent authority to release payment. Stuff. Learned advocate representing the state respondents has obtained instruction from the regional transport officer Murshidabad, signed on 2nd April 2025, mentioning that the matter is under consideration of the office and arrangement has been made for physical verification of the items. Stop. The Paragraph the instant writ petition is disposed of by directing the Regional Transport Officer Murshidabad to take steps for releasing payment to the petitioner upon satisfaction that the items were actually supplied by the petitioner in terms of the supply placed. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. If any of the claim of the petitioner is disallowed, then the reason for rejecting the claim shall be made known to the petitioner immediately thereafter.
My lord, only
Disposed.
one thing, your
Service is
lordship,
taken on record.
kindly record that I have supplied the document that was annexed. They have received it on 4th January 2022. Now they are going to verify.
Difficulty is, it is mentioned that the letter was received, not that the furnitures were received. I checked up. Next. Received, that means you submit this letter and that was received. But whether you supplied the items is not very clear.
No, later means 8.
Yes, 45.
I am appealing on behalf of the state of
I appear on behalf of the Union of India led by Learned ASG. I have been asked to pay for accommodation for this day.
My lord, supplementary affidavit will be taken.
Why?
What happened, my lord?
Supplementary affidavit has not been used. It has not been used. Why keep documents which have not been used?
The quotation rate, if they challenge that I can give it back.
And give a copy to that
I have already.
the learned advocate.
Yes, I have.
Supplementary একটা রেখে দেবেন.
My lord, the petitioner is now aged about 103 years old.
Huh?
103 years old.
103 years?
He has come to this court, my lord, to affirm affidavit. My lord, what happened, my lord? My lord, the petitioner, my lord, joined the, participated in, my lord, August 1942 Quit India movement. And my lord, he was arrested and he was in prison, my lord, for more than 6 months. My lord.
What? He wants freedom fighters pension?
My lord, he is not getting, my lord, he is fighting here to there, my lord. In 1981, he, my lord, applied. My lord, some defects were there in the, my lord, applications. That, my lord, the state government, my lord, did not recommended the, my lord, case of the petitioner. The petitioner moved to the Honorable Court in 2014. My lord, the order was passed to consider his case. But the while the, my lord, central government authority considering
he never received pension.
Not he is not getting not pension is received, my lord. Lord, home lord, because due to the lord
2014 rejected upon consideration page 47.
Lord.
Yeah, see 2014 onwards, my lord, he did not sit tight over the matter.
Listen, thing is, considering his age, the authority should take steps for grant of pension.
Otherwise, unless he is eligible, how can it be?
Eligible means what? He fought for the country, and you say that he did. He will not receive pension.
There are documents and there.
No documentary evidence.
Yes.
Actually, he did not know that this pension will be granted. That is the reason he never kept any documentary evidence. The persons who fought for the country, they never thought of pension. Then?
That is the difference.
What is the state stand?
State
My lord, I have
recommend
taken
gain, my lord.
instructions from the district magistrate's office. My lord, they have, my lord, give me the instructions that no records or documents is found and lying with the office of the district magistrate in respect of the petitioner.
There are
What is your
But the findings of the, my lord, also
certificates of the, my lord, co-prisoners. I have given that co-prisoners, my lord, who are, my lord, there. My lord, he, my lord, they have, my lord, admitted that, my lord, I joined the, my lord, Quit India movement. And my lord, I was in prison, my lord, for more than 6 months with them.
Jail records do you have?
my lord, no
The jail
records.
records?
My lord, no records. My lord, kindly see the order. My
Where are the jail records?
lord,
What is the period of your imprisonment?
My lord, I was, my lord, 12th of, my lord, December 1942 to, my lord, June 1943.
Bring the jail records.
My lord, grateful to lords.
Which jail?
My lord, Tamluk jail. Tamluk, that was Tamluk jail, my lord. That was not at the material, it was Tamluk, now Tamluk.
Tamluk jail.
Tamluk jail.
আসুন তো।
Well, the certificate also, my lord, genuineness of the certificates also questioned by the authority, by the Union of India also.
If your jail records
Well,
show,
nothing in the district magistrate office, my lord, so far I take in.
verify from the jail records, because it is the petitioner who is coming, and that means the freedom fighter himself. Usually we get the widows, the daughters and everybody, but the freedom fighter himself coming for pension is very rare.
And it appears from the record itself, my lord, 2014, everything was considered, reason order was passed, that was not challenged. After 11 years, now he has come again before your lordship, my lord, by making a representation, that too not in accordance with the procedure, my lord. And
Whatever. The
let them come, my lord. Yeah.
Claims to be aged 103 years. Stop. He fought for the freedom of the country. Stop. He seeks the pension under the Shotantro Shoinik Shamman scheme.
My lord.
Stop. The petitioner claims that he was imprisoned on and from 12th December 1942 till June 1943. Is there a date?
My lord. Date is there, my lord.
Which June?
My lord, impugn not at page
9th July. I certify that Bhimcharan Nana.
Page 28, my lord.
Page 30. 12 December 42 to 9th July 1943.
Yes, my lord. Page 28.
ঠিক আছে? Stop. Learned advocate representing the state respondent submits that there are no records in support of the petitioner's claim of imprisonment. Stop. Genuinity of the co-prisoner's certificate is also doubtful. Paragraph. Learned advocate for the state respondents is directed to produce the jail records of the Tomluk jail for the period during which the petitioner claims to be in prison. Stop. Is central government learned advocate for the Union of India submits upon instruction that the case of the petitioner was duly considered in the year 2014 and rejected by passing a reasoned order. Stop. The petitioner never challenged the same. Released 3rd of September, 2 weeks' time. 103 years old. Keep this in mind. Every day matters for him.
My lord, your controls.
Service is taken on record.
My lord, instructions may be kept.
Yes, instruction দিয়েছে, written with the records. Okay.
46, my lord, I am for the petitioner, my lord.
I'm for the state, my
lord. The two petitioners, those petitioners, my lord, they have, my lord, spent both of them around 20 years, my lord, in prison, my lord. For offense committed by them, my lord.
You want release?
My lord, remission, for remission, my lord.
Yes.
Yes, my lord. Directorate of Correctional Services, my lord, has a center report that.
What does it say?
My lord, it say, my lord, the local people are still very annoyed upon the convict, my lord.
So not recommended.
No, sir,
right?
No.
Has it gone to the judicial department?
No, my lord. I am not say our, my lord.
The review board's order has to go to the judicial department first, and secondly, the order of the Supreme Court that has been passed very recently, last week only. Please check up. 20 years you have to release.
Yes, ma'am.
Yes,
Please
and,
check up.
And my lord, one more thing is, my lord, among the co-convicts, one of them has already, my lord, got remission from the Supreme Court itself.
Check up.
Yes, my lord. Yes.
When?
My lord, fixed a date, my lord. I will come up.
Please come.
My lord, may I get a copy of the report, my lord?
Have you completed 20 years?
Yes, yes.
19 years, my
No,
lord.
no. 19 years, my lord. But one of them has.
Not
Among-
20.
Yes, my lord. That's why.
One is 18, one is 19.
Yes,
20
madam.
years compulsory remission, but 18, 19.
MD Aslam, my lord. 18 years, 3 months, 16 days, my lord. In imprisonment or life convict.
Petitioner number 2.
And petitioner number 2, 19 years, 9
So then it
months,
cannot
and
be
5
given.
days.
Actually, the petitioners were convicted for life and are serving their life sentences. Stop. The petitioner number 1 has undergone 18 years, and petitioner number 2
3 months.
19 years, 18 years and odd, 19 years and odd. Imprisonment. Stop. The petitioners pray for premature release. Stop. Learned advocate representing the state respondents has obtained instruction from the officer in charge.
He is the notorious criminal, my lord.
Law Cell, Directorate of Correctional Services, West Bengal, wherefrom it appears that the proposal for premature release of the petitioners were placed before the State Sentence Review Board. And their case were not recommended by the board for premature release. Premature release for the year 2022. Stop. The proposal has again been placed before the board in April 2025, and opinion has been sought for from the investigating agency. Stop. The report from the agencies are awaiting. Stop paragraph. The instant writ petition stands disposed of by directing the we have not made the board a party. Directing the State Sentence Review Board to take a decision in the matter at the earliest. Stop. The decision of the board be communicated to the petitioner by the respondent number 2. Disposed. Next.
My lord, in item number 47, my lord, I am for the petitioner. It's a most
Respondent number 4.
unfortunate case, my lord, where the petitioner, my lord, is a service person. He is a sergeant of Kolkata Police, and he met with a road traffic accident, and he went to an orthopedic hospital. And what they have done, my lord, will reflect from the order. If your lordship may kindly take up the order against which, my lord, the petitioner has come before your lordship. My lord, kindly takes up page 141. He is now disabled, permanently disabled. My lord, my lord, the complaint would relate to hospital negligence coupled with medical issues. The patient, a police officer by profession, was injured in a road traffic accident. He was taken.
The relevant portion. Do not read the whole thing.
My lord, okay. My lord, page 142, my lord.
Yes.
Complaints have arisen while
50,000 penalty has been imposed.
Yes, page 145.
50,000 penalty has been imposed, but my lord, he is disabled forever. My lord, may I place the disability certificate, my lord? He was a A rank police officer with a
No, but disablement may not be because of the negligence of the hospital.
Obviously, there is no lift in a hospital, in a uni-speciality orthopedic hospital, there is no lift. My lord, kindly then seize the order. Everything has been recorded. He has to go with a saline, bottle of saline in his hand to the washroom, wherein blood was there in the saline. He was forced to fold his leg 140 degree. That is another medical negligence, which is recorded, my lord. As a result of which he is suffering a disability. He is permanently disabled. May I, my lord, read the entire order, my lord?
No.
It's a 2-page order, my lord.
All right, no, not a 2-page order. It's a 5 pages order.
Sorry, my lord.
Yes.
Only.
Has been. So you want enhancement of this?
Yes, and that is a provision.
Not his prayer in the writ petition.
Not his prayer. What?
But he is something, my lord, submit, kindly sees his prayers in the writ petition. But 50,000 rupees was awarded by the regulatory commission. My lord, the establishment has paid it. Now comes, my lord, what is he praying for? The regulatory commission has held that medical negligence is outside our domain. We cannot adjudicate.
Exactly.
Now, my lord, kindly comes to his prayers in the writ petition. Now what he wants is that kindly sees prayer 1, a writ in the nature of mandamus directing the state respondents to conduct a thorough inspection of the clinical establishment of the respondent number 3 in order to ascertain their overall compliance with respect to the standard protocol as mandated by the statutory guidelines of WHO regulations in consonance with the mandatory legal provisions as contained. It was open to him before the commission to agitate it. He did not agitate it. Kindly comes to prayer B then. Now he wants that the qualifications of all the training, my lord, the trained personals, doctors of their clinical establishment should be checked. But this was also, my lord, open before him before the regulatory commission. He did not.
No, that was not within the domain of the regulatory commission. That was within the domain of the who is the licensing authority.
His prayers. He is accepting that amount of 50,000.
Kindly cease prayer 4.
10 lakh
but that is already adjudicated by the commission. Commission has considered everything and granted 50,000.
My lord, medical negligence has several limbs. One of the limb is hospital negligence, another is negligence on the part of doctor. Admittedly, there is negligence on the part of the hospital,
order dated
which is recorded, my lord, in the order.
2025.
And there is statutory
Passed by
provision
the
also.
West Bengal Clinical Establishment Regulatory Commission. Is impugned in the instant writ petition. Stop. The complaint filed by the petitioner stood disposed of by the commission, directing payment of rupees 50,000 to the complainant/petitioner, which the clinical establishment claims to have paid. Stop. The petitioner has prayed for enhancement of the compensation paid along with other reliefs. Stop. The issues in the instant writ petition has to be decided upon exchange of affidavits. Stop. Let affidavit in opposition be filed within a period of 4 weeks. Reply, if any, within 2 weeks thereafter. Liberty to mention the matter for hearing.
I'm grateful.
Next.
My lord, in this matter, I am the petitioner. My lord, in this matter, the petitioner is bringing a padlock of different shape and size.
Petitioner
is bringing a padlock of different shape and size by the private respondent number 4 vehicles, bearing number WB11 B9004. It is in page number 3, my lord. On 4th November 2024.
Bringing padlocks of different shape by the private respondent 4's vehicle for retail sale. And the respondent represented that he lost the documents for the goods. Yes, then the vehicle was intercepted.
Yes, on the way, my lord, at Howrah Fish Market, the vehicle is being checked. During the checkup of the vehicle, the mobile team official Howrah zone has investigated, and because of the fail of the loss of the documents, the assistant commissioner of revenue investigated and initiated a case.
Why will this be taken up before this bench?
It's
It's a revenue matter. It should go before group
129.
bench.
My order is at page 14. GST order 129. It's an appealable order. They should have.
No, appealable or not is different, but then group 9 bench doesn't have determination. The matter relates to group 4. Stop. Let the same be released from the list of this bench for want of determination.
Representation considered. Kindly consider. I several time representation.
Group 4 have group 4 have এটা group 4 classification details আছে
Release
correction করে দিই মানে form is to be corrected order
leave granted to amend the presentation form and the front sheet of the writ petition. Yes.
এটা 120
Please wait.
GST তে provision আছে
I appear for the ombudsman RBI.
My affidavit of service, my lord. My lord, the petitioner has been a prey of a bank fraud, my lord. Now, my lord, over a period of time from 10/6/2024 to 12/6/2024, my lord, the petitioner's savings bank account and the petitioner's credit card was numerous amounts got debited from the petitioner's bank account and petitioner's credit card, my lord. My lord, an amount of rupees 3 lakh, in installments, in 5 installments, an amount of rupees 3,04,997 was debited from his savings bank account on one side, and 1,98,669 was debited from his credit card on another side. Now, my lord, the RBI, I am relying on a certain rules of the RBI, my lord. Now, my lord, the RBI rule says that if I report it within 3 days of the said fraud, my lord, my liability falls down to 0, my lord. Now, my lord, may I show that lordship? My lord,
then what has happened? You registered a complaint.
My lord, I reported it. Our FIR was registered. I went to the ombudsman also, my lord. But the ombudsman, I have filed an online complaint. That is my last annexure, my lord. The ombudsman, without giving me any hearing, closed the complaint without any reasons, my lord. Now, my lord, there is no signs of recovery, and my lord, the Axis Bank is charging interest on the credit card, my lord. Now, my lord, I have done everything within time. I can show to the
All right.
my lord.
What is your submission?
Lordship, they have approached the ombudsman, but Lordship, according to the rules, Lordship, they have to personally appear. They have approached the ombudsman through advocate.
No, my lord. My lord, may kindly comes to last annexure, my lord. I have not the advocate. I have given a legal notice. That was first. Then I have approached personally. My lord, may kindly comes to page number 36. My lord, this is the printout of the final. This is the final printout after the closure, my lord. My lord, may kindly see the complainant details. Name Buddhadev Mukherjee. In complaint details. Entity name Axis Bank Limited. And my lord will kindly see the complainant himself has approached. This is, my lord, with regard to the unauthorized transaction. Page number 37, my lord will see the first line. It is the unauthorized transaction. It was with regard to the savings bank, my lord. Savings bank fraud, my lord. And my lord will kindly comes to page number 38. The petitioner himself has approached.
You never approached through the advocate.
My lord, first I gave a legal notice to the bank, my lord. That is the earlier annexure, my lord. First
Before the ombudsman, did you approach individually?
Individually,
that is the advocate.
No, my lord, that is the printout, my lord. That is the annexure.
Take proper instruction. Please come.
My lord, only one thing, my lord. My lord may direct the bank to not charge interest, my lord. My lord.
No, every day these type of matters are coming. You all will disclose the passwords,
no, my lord, no passwords has been disclosed, my lord.
Very well. Please come. Did you serve the Axis Bank?
Yes, my lord, I have served it. Even I have given a notice also, my lord, of
appears on behalf of the Axis Bank. Affidavit of service is taken on record. Stop. The petitioner is aggrieved by the closure of complaint by the banking ombudsman.
Reserve Bank ombudsman.
RBI ombudsman. Without affording any hearing to the petitioner. Stop. the petitioner alleges that he is a victim of bank fraud. Stop. The fraud was reported within a period of 3 days. Stop. The bank has
To the bank and the police station.
The bank is going on charging interest and debiting money on account of the loan.
No, my lord, on account of the credit card due.
Acha, credit card dues.
Alleged credit card due, my lord. That is
Stop. Paragraph. Learned advocate representing the ombudsman submits upon instruction that the complaint stood closed as the same was filed through the legal representative of the petitioner. Step. The aforesaid submission of the banking ombudsman is denied by the learned advocate representing the petitioner. Step. It has been highlighted that though a demand notice through the learned advocate was given to the bank, but the complaint before the banking ombudsman was by the petitioner himself. Paragraph. Learned advocate representing the ombudsman is directed to revert with proper instruction, proper written instruction, along with supporting documents. Stop. Released on 3rd September. Let further notice be served upon
May
the
I show one thing?
Bank.
My lord, may I show only one thing, my lord? My lord, page number 22 for once, my lord, from my section, my lord. My lord, after the credit card due was credit card fraud was reported to the bank, my lord will see on 21/7, my lord, the bank has given me a message that my credit card due is 0 because we highlighted this provision. After that, bank started charging me interest, my lord.
Next.
I appear for the reserve bank.
Yes.
I appear for respond number 1 and 2 ICICI Bank, my lord.
Yes.
Service? Coming for person. Served everybody, man. Check with the my bank account was frozen at the behest of the police. Police has given 2 notices.
Which police?
Cybercrime police station, Puducherry, and another police cybercrime police station in Haryana.
Right.
Both have given notices to the bank to defreeze because my account is not involved. The involvement was stated to
Defreezed.
be both.
Directed to be defreezed. Where is it?
Kindly have a look at page 29 of the application of my writ
Yes.
petition. To the nodal officer, the
Request to-
respondent bank is mentioned
Yes.
in 29.
Right.
In connection with the above application, a petition is under inquiry at cybercrime police station.
Yes, next.
And the next one, your lordship will kindly have a look at my CAN application, my lord.
I have not.
Connected application number 1 at page 9 of that.
When did you file
I have
it?
not been served with a copy of
When did you file it?
CAN take होता है.
The can is here.
Filed and served also.
Yes, yes, it is here. Give a copy to your learned friend.
Yes, yes, I'll do that.
What is there?
23rd July, but page 9, my lord, if you can just read with me.
Request to
Page 9,
unfreeze.
they requested to unfreeze, but they haven't done it so far. For involvement of 15,000 rupees, my current account has a balance of
It is
12.74.
not the amount.
True.
It is your involvement.
No, it was a UPI fraud of
My
15,000.
instructions are that, my lord, that apart from these accounts, there are some multiple instructions from different police stations, my lord, to freeze this account. For that reason, only this account has been.
Bring your written instruction.
I will.
Please come. The petitioner alleges that despite communication given by the police to defreeze the bank account of the petitioner, ICICI Bank is not acting in terms of the communication. Stop. Paragraph. Learned advocate representing the ICICI Bank submits upon instruction that apart from the 2 police stations where a case was registered against the bank account of the petitioner, there are other criminal cases pending against the petitioner. Stop paragraph. Learned advocate for the bank is directed to revert with written instruction, disclosing details of the complaints or criminal cases pending against the petitioner's bank account. When? Next Wednesday?
2 weeks.
2 weeks. 3rd of September.
Look, I've served you a
Services.
copy of
Yes,
the
I have got the copy.
Well, Victor, I'm for the petitioner, my lord.
Yes.
The petitioner is a government contractor, my lord. He was allotted tender work. And my lord, I have completed the work. That is my lord, page 18. But my lord, my payment has not been made. 18 days.
কোথায় গেল on record? কত item? I forgot on record here. Item 50. AOR. Who hand over the slip, appearance slip for the petitioner? Please check the name of the learned counsel. And then submission will be that wrong spellings have been inserted. Check up.
My bill also would not have been cleared.
Yes.
Well, I'm the government contractor, my lord. I have been allotted work, my lord. That is my lord, page 18. And my lord, I have completed the work, but payment has not been made. That's why I made an application, RTI, page.
Who has not made the payment?
My lord, payment is not made by the executive officer of Jharkhand Panchayat Samiti.
Why are you here?
Well, because of tender work, my lord.
So
I
what?
have completed the tender work, my lord. Because my lord, since
Panchayat matters in group 5 tender matters are taken up. It is not that only in group 9 tender matters are taken up. Why will it be taken up here?
Since
you have to go there. Cannot be done.
Then
Group 5 release. Next. Next one also same.
Same, Panchayat Samiti.
All right.
Jharkhand Panchayat.
53.
I am for the
May
state.
take back the
My lord, I am the
service.
state for the state.
52.
My lord, may take back the service, every service.
Why?
Lordship.
It will remain.
Okay.
Give notice. He is appearing in 52, but 51 you have to give notice.
My lord, one line order may be recorded. One line order may be recorded.
Order is being passed
Lordship.
for release. But then that will not be an effective order.
It will not generate.
What can be done? This bench doesn't have determination.
Get to know it.
Do you have instruction why payment has not been made?
Lordship, I have some instruction, Lordship.
You have.
They have initiated some.
All right. Next 53.
My lord, a big paper.
Yes.
My lord, I am appealing for respondent number 3.
Well, this is a very short matter, my lord. My lord, the previous round of litigation, if your lordship kindly, there was an order passed by a coordinate bench of this honorable court, my lord. Kindly come to page 43 of the writ petition, my lord.
Respondent number 3, National Commission for Homeopathy. Ministry of Ayush Secretary, Union of India. Is anybody there?
Yes, but we have also served.
Who will be the answering respondent?
Answering respondent, my lord, Ministry of Ayush. Respondent number 2.
Then 2 is not here. What is your prayer? What is your
My prayer is that, my lord, as per the previous order, my lord, they should have given us an opportunity of hearing before passing the impugned order. Without giving that opportunity of hearing, they pass the impugned order.
Where is the impugned order?
The impugned order is at page 54, my lord. And before that, my lord, just I want to show your lordship the previous order, my lord. If your lordship kindly come to page 46 once.
Yes.
I am placing paragraph 14, my lord. In view thereof, this court is of the considered view that there was no occasion on the part of the respondent authorities to deal with the contention which is now sought to be raised by the petitioners for the first time in the affidavit in reply. The issue involved in this writ petition is a technical issue and the same should be best left for the experts in the field to take a decision. The petitioners will be at liberty to make a comprehensive representation before the Secretary, Ministry of Ayush, being the respondent number 8 herein, annexing documents and materials in support of their claim. If such a representation is submitted, the respondent number 8 shall consider and dispose of.
I can see the ASG appearing in the earlier matter.
Yes.
For the ministry.
Yes, yes.
You check up, he is not come today. I'll just adjourn it. Give one notice and check up who is appearing for the Union of India.
My lord, I have been told my lord, Priyanka Tibrewal is appearing.
She is not in the country. So you have to get hold of somebody who appears for the Union of India. Please come. None appears on behalf of the respondent numbers 1 and 2. Affidavit of service is taken on record. Stop. Let notice be served. Release turn 27th. Next Wednesday, please come.
I'm grateful.
Appearance to Dinesh. Order record hole.
Yes.
64 minute, I am for the Union of India, my lord. My lord, kindly see the cause title, my lord.
Cause title, what has happened?
That is, I think, my lord, there is a bar of territorial jurisdiction. My lord, tender was issued from the Madhya Pradesh. That was accepted from Madhya Pradesh. My lord, the work order issued from Madhya Pradesh. That was then also rejected from Madhya Pradesh.
All right, let me hear.
Kindly see the cause title.
I'm seeing. Jabalpur. Let the petitioner place his case. Yes.
My lord, according to the clause 7 of the tender documents also, my lord, jurisdiction at there, my lord.
MP. All right, yes.
And my lord, on identical issue, my lord, your lordship, few days ago, your lordship
Passed order?
judgment. That is regarding BSNL matter, my lord.
All right.
That's Sikkim.
Could I have a look at the judgment?
Yes, yes, yes.
What is your submission?
Lord, 226.2, if he's really urging this point, Lord, then
Yes, he
226.2.
is.
226.2, Lord,
Mhm.
I cannot be required to chase everybody. I'll tell you, Lordship, why. Lord, the tender is awarded to me for supply of certain particular specification of glued joints. My consignee is Kota, somewhere in Kota. Ultimate consignees, now railways have sent it to different people. Rejection advices have been issued by 88 different consignees. So if I have to hunt down 88, it's impossible. It is because of this that
Who is the
226.
tender issuing authority?
The tender issuing authority is the respondent number 1. Is the respondent.
That is also outside the jurisdiction of this
but
court.
the notice of rejection, the warranty
Only
advice,
received here in Calcutta.
everything.
Not everything. That is the only thing. Please go. No.
Whatever has happened, that I have
Nothing.
received within.
Well, kindly see the clause 7. my
But
lord.
clause 7, if your lordship desires not to speak
Jurisdiction.
tomorrow, I'm covered by one judgment passed by your lordship, which has been upheld in appeal. The other of
For any
Supreme Court judgment, that is a
disputes relating to
intra-contract
contract.
dispute resolution clause, my lord. It never takes away the jurisdiction of Article 226. That's one. Secondly, my lord, if a fragment of the cause of action has also arisen within, your lordships have held it within.
Integral part of
That's
the
right.
cause
So
of
the
action.
integral part here
Yes.
is the rejection. Because what has...
There in MP.
No, my lord, the authority
Communication
is
only
MP.
in Calcutta.
The
You want to
authority
come
is MP.
tomorrow? Come tomorrow. But then,
Only one request, my lord. Instead of tomorrow, she keeps it day after.
all right. On the petitioner challenges the
My lord,
cancellation of the
my lord,
cancellation of the
My warranty rejection advice.
voluntary rejection advice.
Warranty rejection advice is what I have.
Warranty. The petitioner is aggrieved by the warranty rejection advice issued by the respondents. Stop. Learned advocate for the respondents raises an objection with regard to the maintainability of the writ petition before this court. Stop. It has been submitted that this court does not have the territorial jurisdiction to decide the issue. Stop. Provisions of the tender document. Is this the tender document? Yes. The tender document has been placed in court in support of the submission that the jurisdiction of the Calcutta High Court cannot be invoked for resolution of the dispute that has cropped up. Paragraph. Learned advocate for the petitioner seeks accommodation released day after tomorrow?
Yes, but I think
Yes,
he
yes.
has some...
No,
Day after, the day after tomorrow.
Day after tomorrow?
Huh?
But day after tomorrow is a Friday. It's difficult.
No, she keeps it on Monday. Not 2 days
Yes,
won't make a difference.
25th.
25th, no, the affidavit of service.
Yes, service is taken on record.
But one more liberty I'll pray for.
No, not on 25th, 27th, next Wednesday.
Then very well, my lord, just one more liberty. Lordship, give me a liberty to file a supplementary affidavit.
Why?
2 documents we've missed. I just want to indicate that. Regarding the warranty advice. I'll cross the threshold of...
Kibale, leave has been sought for to file supplementary. Same is allowed. Serve advance copy upon the respondent.
Yes, yes, I'll do that.
Yeah? Done. Appointed Agun. 55.
Lord, I am for the respondent.
My lord, I am the petitioner.
Yes.
Yeah. My lord, actually, we are running a charitable English medium school, a private unaided institution under West Bengal Board of Secondary Education. In 2022, 11th May, FCRA division issued foreign contribution, approved our FCRA under FCRA Act 10 on 11th May 2020. We applied for renewal in the month of November 11, 2024. They rejected our FCRA renewal application, just stating
I'm good. Remember the statement.
This is the only Passover matter. And that's it. 34, nobody is there.
39, my lord, was.
Yes. Now the judicial hours is also over. Where is the council?
Lordship, actually, there's a fixed matter which was going on court number 2 circuit bench.
And it is continuing.
Rajavasu Chaudhary.
Oh, is it continuing?
Lordship, I believe it has been just over, so it might be joining.
Only not today. Leave it. Call the next matter.
Item number 39.
Yes.
Paying for accommodation, Your Lordship. Since I'm led by Mr. Shobose Chatterjee.
Then you are there.
Since Your Lordship, due to his Your Lordship dental issues, he left.
You are here. Somebody is having issues. Let him have. You are there.
My senior could actually assist Your Lordship better in a.
Do you have a trade license?
Yes,
Now he has got it. Paragraph 8, 2020.
He has got it.
I have got the trade license. I used to deposit the renewal fees also, Your Lordship.
Now
to the
you want
account.
the authority
I'm
to.
praying, Your Lordship, let there direction upon the authority that to, Your Lordship, to allow me to continue my business.
Nobody is stopping you. Who is stopping? The authority is not
Yes,
stopping.
Your Lordship. The SP, Your Lordship, the excise department, they are, Your Lordship, are specifically making an objection that when I went to the Your Lordship, the office, they are saying that the police verification is not completed yet. As of Your Lordship, now we have paid the entire fees and the renewal fees also we have given. No, we have also obtained the no objection from
Any
the
police
concerned Gram
verification
Panchayat.
required?
Police verification is obviously required. But what happened 10 years, it was closed down.
Yes.
Now I given the instruction, my last paragraph.
Yes.
On the first page, my lord, cancer care hospital has come up. First page, my lord, first page, the last paragraph. The cancer care, the school has come up. But this is the difficulty, and local people are resisting this.
In that case, he has to shift.
So, this is a difficult cancer care. This sentimental.
There is a hospital
I have
over there.
no, Your Lordship. Since Your Lordship, I got a no objection certificate from the local Gram Panchayat.
No, that
Local Gram
cannot
Panchayat,
do.
Your Lordship.
Your no objection certificate, you pay money to the Gram Panchayat and a no objection is issued. By that way, you cannot do.
I also obtained the trade license from the Your Lordship Panchayat.
Yes.
Now, Your Lordship, only issue is that, Your Lordship. Since
There
Your
is
Lordship,
a hospital, there is a school.
but Your Lordship, I made repeated representation to the concerned authority that Your Lordship to allow me to Your Lordship to continue my business.
How can you continue business? You cannot continue business with the school and the hospital over there.
Since Your Lordship, within the zone of Your Lordship, the prohibited zones, the shop is not there.
It is. This is what the deputy excise collector says.
May I get a copy of the report so that Your Lordship, I'll have to take instruction from the Your Lordship, the petitioner,
please come
to ascertain the fact, Your Lordship, that whether the school is there or not.
The petitioner alleges that the excise department is not permitting the petitioner to run the foreign liquor off shop despite having a valid license. Stop. Learned advocate representing the state respondents has obtained instruction from the deputy excise collector and the assistant commissioner of revenue dated 6th May 2025, which discloses that a mass complaint was filed by a school. Stop. The students of the school are using the path where the liquor shop is situated. Stop. There is a bus stand nearby, and women and elderly citizens use the said route. Stop. There is a significant threat to the safety and well-being of the school children. Stop. There is a temple nearby and one cancer care clinic. is functioning close by. Stop. The shop can lead to increased noise and air pollution from smoking and public disturbances. In view of the aforesaid reasons, the petitioner cannot be permitted to open the shop despite having a valid license. Stop. Next. Yes, what is to be done? Respondents, please say.
It has to shift, man.
Why don't you intimate the petitioner?
We will do it. But I do not find any.
Page number 27.
Yes.
I ask your lordship and approach to the authority, despite your lordship that they did not also answer.
The 27 is of 2019.
2019 and repeatedly, your lordship, as of now.
There is no
I made
contemporaneous. He got his trade license in 2024. He got his trade licenses to 2000. There is no contemporaneous demand just
The trade license, it has been submitted that the trade license of the petitioner has been issued only in the year 2024, though the license from the excise department was issued in the year 2014. Paragraph Dilikunto. It appears that in the facts and circumstances as mentioned herein above, it may not be possible for the petitioner to open and run the liquor shop from the existing site. Stop. Next. Accordingly, it will be open for the petitioner to take steps for shifting of the liquor shop to a separate place in accordance with law. Stop. The writ petition stands disposed.
Since your lordship, may I indulge on?
Mr. Sanal was there. The first
your lordship,
call he was.
Shift the place, your lordship. Then your lordship, the license was granted to your lordship, the petitioner, for the for only one to that place, your lordship, where I have applied, your lordship.
When in 2019? From 19 to 25, you locked your shop room, and in the meantime, all these things happen.
They are not allowing us to.
It cannot be done. There is a mass agitation. You cannot run your shop from there. You please shift to a better place so that you can give a copy to him so that he can take steps.